ಹೈಕೋರ್ಟಲ್ಲಿ ಇದೆಯಮ್ಮ, ಅಲ್ಲೇ ಕುತ್ಕೋ.
Court officer, hello? Am I audible, court officer?
My lords.
Yes.
My lords.
The KERC matters a lot. Regulations that are challenged and the demand letters. Similarly, many petitioners have gotten interim orders. I am also entitled to lot. Any date. I am not in this.
No. Office objections are complied. It's a fresh matter.
A lot. This was filed in the initial stages, not 2026, not 55.
Tomorrow.
My lords.
Yes.
My lords, this is the commercial suit for eviction. My lords, the trial court has allowed for the amendment of their counterclaim after the commencement of the trial.
When was the order passed?
My lords, in December.
My lords.
My lords, any date,
It's a
my lords.
partition suit, my lords. The amendment application has been allowed, my lords. We have challenged the order
I don't
dated.
want to hear any of the facts of the case.
Um,
Only one thing I want to
Mal-
know is, if it is a fresh petition, don't mention. It will come. If it is not coming, tell the court officer. Number two, the second urgency is matter coming up before the trial court.
Yes,
Apart
ma'am.
from this two, I will not hear any of the urgencies.
My lords,
in this
on
matter-
9th 7, day after tomorrow, the matter is coming up for the plaintiff evidence, my lords, with the urgency of the.
Day after tomorrow in the morning. Mention of-
I'll make a mention on the same day, my
My
lords.
lords, similarly,
Much
in this
obliged.
matter also, it was coming up before the trial court.
When?
This week itself.
You don't even know when is that. And you just say
Friday,
this
Friday,
week.
my lords.
When it comes, you just find out. If it is coming on the same day in the morning, I'll take. Yes.
My lord, I for correction, my lord. Order has been passed 15th of July last month. In the year is mentioned wrong, my lord.
Take it tomorrow. Yes.
Matter is posted day after tomorrow.
Yes.
My lord, the
Day after
suit for
tomorrow, you'll be
eviction-
mentioning day after tomorrow. And
Right, sir.
please don't, I do not want, if anybody mentions again on the same point,
It's a fresh
I'll adjourn
matter,
this
my
matter to next September. Yes.
Right, suit for eviction, my lord. My lord, this honorable court granted stay, my lord, subject to deposit of 78,000 within 4 weeks in the month of February. Petitioner has not deposited.
Just take it day after tomorrow. Yes.
For Tescom, my lords, vacation of stay, they have given a wrong HT value, my lords. 90 lakhs has been stayed, my lords.
90 lakhs
90 lakhs, my lords.
tomorrow.
Please.
Challenge the CERC regulations, my lords.
Yes, tomorrow. Yes.
My lord, in the last date of hearing, they have granted a stay on proceedings, my lord. Proceedings, my lord, stay could my lord.
So, there are so many matters stay granted. That is not the urgency. Yes.
Stage is for appointment of court commissioner, my lords.
When is the writ petition filed? What is the urgency?
2025, it has not come up before.
Yes. Wait for it. Yes.
My lord, this RPFC, my lord, this honorable court has passed the order in the month of December. Wrong order has been passed, my lord. Instead of this criminal mispetition, my lord, it is some other case has been pasted and passed the order. Therefore, I have filed the application to recall the order, my lord, and I posted before the regular bench. They said that you have to post before the move before the who has passed the order.
Tomorrow.
Therefore, kindly taken by tomorrow.
2016ರಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ ಸಿಂಪಲ್ ಇಂಜೆಕ್ಷನ್ ಸೂಟ್ ಸಮಯದಲ್ಲಿ 2016ರಲ್ಲಿ ಫೈಲ್ ಆಗಿರೋ ಸಿಂಪಲ್
I
ಇಂಜೆಕ್ಷನ್
can't understand Kannada, you have to speak in English.
ಕೋರ್ಟ್ ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ ಮಾಡೋದಕ್ಕೆ ಅಂತ ಅಪ್ಲಿಕೇಶನ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ಕೆ ಬಂದಿಲ್ಲಿ ಎಕ್ಸ್ಪರ್ಟ್ ಇಂಟರಿಮ್
This is English. Is it I can't understand Kannada, you have to speak in English.
ಪಿಟಿಷನರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಪಿಟಿಷನರ್ ಇಲ್ಲಿ ಎಕ್ಸ್ಪರ್ಟ್ ಇಂಟರಿಮ್ ಸ್ಟೇ ತಗೊಂಡಿದ್ದಾರೆ ಇವರು.
Yes.
My lord, urgency.
To vacate the interim stay, my lord. Matter is listed next week. It was listed last Tuesday. Date is not given, my lord.
I'm really fed up repeating the same thing.
Date is not given.
If the matter is coming, if there is a date for that, on the morning you can mention and take it up. That's what I have told already to the other advocates. The same thing will apply to you.
The matter is listed on 16th in the trial court, my lord. This is a stay.
What is today?
It's 7th.
16th is when?
It may be listed on 14th.
I will not. Yes.
My lord.
I have filed an IA for bringing the LRs of the petition, my lord. I will withdraw the petition if they allow, if the IA.
Day after tomorrow.
My lord.
Please wait. Huh? Fresh matter don't give. If office objections are complied, it will come. If it is not, I think I will not repeat this again. I will simply not hear to any of the requests. That's what I said. If you comply with the office objections, it will come tomorrow. Huh? Verify about it. Verify. And if the office objections are not complied, I will take up, I will say I will pass an order without taking it on the bench to list it in the month of January next year. You make sure and then make a mention before the court. Huh?
Objections not raised and not posted before the registered matter. Not yet come up.
Then what you are supposed to do? Go and request the registry. Why are you giving a memo here? Give back to him. Yes. Call the list.
My lord. This honorable court provide order date.
I have said 3 criteria. Apart from that, if any mention is made, I will take the memo and I will give a date in the month of January. So please think and mention. You will be taking the risk. Only 3 criteria. I'm again repeating. If the matter is coming up before the trial court, fresh matters not listed, tell the court officer. Apart from that, any other mention, I will give a long date. I will take the memo for sure. Yes.
Sorry, madam, the matter is coming up tomorrow, madam.
If it is coming tomorrow, what you should do? You should mention tomorrow morning, not today.
Very well.
My lord.
Lordship, my case is listed today before the trial court. It is actually, I have filed the application for.
When is the writ petition filed?
It has been filed on 7th of July, ma'am, Lordship.
Take up this matter in the afternoon.
My lord, urgency matter, my lord.
Yes.
Pending matter, CMKV matter. We have filed an application for the early hearing. There is also an expeditious disposal order from Supreme Court, my lord.
No, I didn't understand. What is it?
My lord, there is an expeditious disposal order from.
Maybe from the Supreme Court. What is this now?
My lord, it was listed on 16/6, my lord.
Yes.
They directed to list after October, my lord.
That is means it will come in the month of October. If you're not there, that is the order. I will not hear 2 times one matter.
My lord.
Yes.
My lord, list number 2, serial number 11, my lord. List number 2, serial number 11.
Please follow what happens in the court. What she will do now? She will call the list.
Please, my lord. Sorry, my lord.
Today's adjournment, number 1, page number 1.
Serial number 6, my lord.
2 to 5.
Serial number 6.
Yes.
It may be urgent next week, my lord.
List page number 2.
If I adjourn this matter, it will go in the month of
18.
September. List this matter in the month of September at the request of then counsel for the petitioner. Yes.
Page number 3, serial number 19 to 30. Page number 4, 31 to 41.
Madam, serial number 36, my lord.
30?
36, my lord. IBM 36, my lord. Yesterday there was one matter, my lord, which was adjourned for tomorrow to direct to list this matter along with that matter. This matter was tagged along with yesterday's matter and it is adjourned for tomorrow. I'll give that repetition.
Yes, list along with that. Yes, next.
Number, page number 5, serial number 42 to 46. Page number 6, 47 to 51. Page number 7, 52. Page number 8.
Number 52, blood service has to complete. The respond number 11.
Madam,
and 12,
62.
right? You have taken steps, blood, the survey, the correct address we have to furnish to the.
They have filed a vacate petition. We just have to see whether the stay can be vacated at their request or not.
They are earlier filed the wakalat. Again, when at the pendants of the petition, they have died. We have taken steps to the LRs for respondent number 11 and 12 in the two petitions.
The person who has filed who has filed vacate is no more.
Earlier filed, madam, the respondent number 1 to 12, they have filed. But the pendants of petition 11 and 12 died. We have taken for correct address and the
Then what is to be done? I have to pass an order on that.
furnish we have fresh address to the respondent number 11.
That's what, for that an order has to be passed or not.
Order passed, my lord. We have to furnish the steps for.
For that, because you have not furnished, it is coming. Then the court has to say that when you have to do it, we'll see when the matter reaches. Yes.
Page number 8, serial number 53 to 59.
56,
My lords, serial number 59, my lords.
For a short accommodation. 56.
In the month of September, at the request of non-consular petitioner. Yes.
My lords, serial number
Serial
59.
number 68 to 71.
My lords,
50 to 71.
serial number 59, my lords. It's posted for admissions, my lords. My lords, due to personal inconvenience, not able
Yes,
to.
this matter in the month of September.
Serial number. My lords, I take back my words.
Right,
I'll have the matter. I'll attend the matter today.
Yes, please come and argue.
Serial number 62, man.
59.
Page number 9.
Court officer, 59 not adjourned. He'll argue. Yes.
Serial number 62, man.
Yes.
In this case, last time when the matter had come up for admission, your lordship had directed to put up the file of WP 10810 of 2024. Instead of this, by mistake, they have put 10180 of 24. That has nothing to do with this case.
That's a whole problem. Whenever a number, when you say number, you have to write it on a paper and give. So that this kind
Paper
of.
also I had written and given. That petition number is mentioned.
Now you write it.
Petition itself.
Now you write and give it to her.
Tomorrow.
Just along with so and so, it is submitted that WP number 10180/2024 has nothing to do with this. Yes.
Tomorrow.
Yes.
Tomorrow.
Yes.
Yes.
Next. Page number 10, serial number 72 to 77. Page number 11, 78 to 85. Page number 12, serial number 86 to 90. Page 13, 91 to 98.
92, my lord.
Yes.
Filed one more petition as your lordship has directed. I applied for copies. 2 weeks time.
Yes, 92. Let this matter after 2 weeks. Yes.
Page number 14, serial number 99 to 105. Page 50.
Not one also, awaiting service.
Yes, this
Taken the
also
action
after
of
2 weeks.
Please.
Page number 15, serial number 106.
At the request of the learned counsel for the petitioner. Yes.
Page number 15, serial number 106 to 112. Page number 16, 113 to 116. Page 17, 117 to 21.
Serial number 118 is for a hearing on IA for stay, ma'am. I've been waiting for a hearing for a month. The respondents have moved an amendment application to withdraw from their admission before the trial court. It may please be taken up today. Serial number 118.
What is the urgency of a 2025 matter to be taken up today?
I posted the memo on 8th of last month, ma'am.
You
It's
might
IA
have-
for stay,
There
ma'am.
is so many people, not only a party in person, advocates also.
Ma'am, at least a date with top of the list, ma'am.
No top of the list. It will come. It is in the first list. It will be in the first list when it reaches you argue. Yes.
Page number 18, serial number 122 to 126.
My lords, serial number 122, my lords. The urging, your lordship, I just seek the indulgence, my lords, to take up this matter. The urgency is that, my lords, though the interim order in my favor was upheld by the Supreme Court, my lords, yet the petitioners are interfering in my peaceful possession. Day in, day out, my lords, they keep coming to my property, my lords, to dispossess me, my lords.
File a contempt.
My lords, I appeal for the petition in the case here.
My lords, the contempt also is being filed, my lords. It was posted before the I'm just seeking the indulgence of this honorable
That
court to
came in
hear
the
the
first
matter,
list.
my
I will
lords.
not further have any indulgence. Whenever it reaches.
My lords,
you
what
please
happened, my lords, though, my lords, there is the Supreme Court has upheld my interim
If it is,
order.
that's what
my
you
lords.
filed the contempt. That's the only
But there's a
remedy.
stay, my lords. Even if I go and execute also, my lords, they're not letting me to execute. Even police protection also I seek, my lords. That also they come here and take an interim order, my lords. I'm in a position where, my lords, they will be dead.
Please understand, there are so many matters which are urgent as your client.
Grateful, my
And
lords.
you have asked, the matter is listed in list 1. It will be in list one whenever it reaches. I cannot take any exception to your case now. Yes,
Because
Paul.
what happens, my lord, I'll be dispossessed, my lord. They come yesterday also, my lord. They come with all
It is an
these.
urgent alert.
They come with the bouncers and everything,
I
my
will
lords.
not take up this matter out of the turn.
Please,
Already
my
it's
lords.
listed in the first list. Please wait for
Number
that.
19,
Grateful,
127 to 130. Page number 20, serial number 131 to 137. Page number 21, 138 to 45. Page number 22, 146 to 151. Page number 23, 152 to 158. Page
Serial number 155, my lord. Serial number 155, my lord. Disconnection of electricity. Yesterday matter, it is posted today. Yesterday it was posted. Now it is posted today. Disconnection of electricity.
Where it is posted?
230. 1 month. One
I'm
month
not able to
back.
understand.
Disconnection of electricity.
Yes, 2:30, inform the other side.
Please,
Serial number 153, my lord. Matter is before the trial court today, my lord. It is an arbitration.
It's 2:30. Yes.
From yesterday, this matter was posted for coming up on
Monday is a long way. We are only on Tuesday today. Yes.
Page number 24, serial number 159 to 160. Page number 25, 161 to 163. Page number 28, 164, 165. Page 27, 166, 167. Page 67 point. Page number 35, page number 20, 35, serial number 168. Page number 36, 169, 170. List number 2, page 1, serial number 1 and 2.
Third matter, my lord. I am
Page 2.
Which one?
2, serial number 3.
The petitioner, it is a memo is filed stating that the matter is amicably settled. As a petitioner wants to withdraw the petition. Memo is taken on record and dismissed as withdrawn.
Page number 3, serial number 5 to 7. Page number 4, serial number 8, serial number, page number 5.
Lordship kindly mail. Serial number 8, connected matter. Lordship may have it after 2 weeks.
Why?
My brother has been passed away. Some functions I have to attend to. I got to go to
Some-
native place.
Some objections also in IA, there is objection, they have not
But
complied with.
have you informed the other side?
I informed.
Huh?
Mr. Butler has been informed.
But 2 weeks, why do you want 2 weeks?
No, either that another matter, they're connected matters, connected to some office objections, they have not complied with also.
No, that is true. When they have become, when vacate petitions are filed, any personal inconvenience, we can accommodate for a limited time, not for 2 weeks. This is matters next week.
Page number 5, serial number 9, 10. Page number 6, 11 to 13. Page number 7, 14 to 18.
That's 15 minutes. In a suit for specific performance, a third party is being pleaded minutes. The matter is coming up next week minutes. It may be taken up.
We'll see when the matter comes. Yes.
Page number 8, serial number 29. 19 to 23, page number 9, serial number 24 to 28, page number 10, 29 to 35, page number 11.
31. I have an inconvenience post lunch minutes. I had moved the matter. There is a stay that is there. Can this be taken up 14th and I'll keep the other
I
side?
will, once you ask for an adjournment, it will go in the month of September.
Then let it be minutes. I'll try and it.
Yes.
Page number 11, serial number 36, 37, list 1.
Lords, may I make one submission, my lords? One memo for posting, my lords. My lords, this was listed, my lords. Your lordship had issued the hand summons, my lords. After serving of hand summons, my lords, your lordship had directed us to move the memo, my lords. Now, my lords, it was listed on last Thursday, my lords, but it did not reach, my lords. Hence, my lords, now in the trial court, my lords, the matter is on 9th, my lords, for judgment. I had filed the application, my lords, for production of additional documents, which came to be rejected, my lords. Your lordship heard this matter, my lords. Hand summons was
The
issued.
matter in the first list on 9th.
9th.
On 8th. First list tomorrow in the first list. Yes.
Tomorrow first list.
Great.
Page, list number 1, For pronouncement of order, serial number 1. Maybe
Prepare for
That's what
respondent.
they're
my lords.
mentioning that orders are being spoken to RFC. Give it to them immediately. What it is. So order dated 30/8/2024, passed in SN numbers 370 of 2024 by the Deputy Tribunal is set aside, and the matter is remanded back to the DRT. Without further notice, the party shall appear before the DRT on 27/7/2026. The arguments of the party shall be completed within a period of 1 week from 27/7/2026, and the DRT is requested to pass appropriate orders by 5/8/2026. Considering the laches on the part of the petitioner in mentioning the matter before the DRT, which made the DRT to pass the impugned order, the petitioner shall pay cost of rupees 20,000 to the respondent bank.
Serial number 2, memo for the
Yes, give that memo.
Yes. Petitioner is the defendant. Before the trial court, the plaintiff has filed a memo stating that withdrawing the suit merits. Therefore, I am withdrawing this petition.
Memo is filed stating that the writ petition is filed questioning I number 3 under order 6 rule 17. And the plaint itself was written. Based on the memo filed by the respondent. As the petitioner wants to withdraw the writ petition, dismissed as withdrawn. Yes.
serial number 3. Chetan Kumar
For the
K.
petitioner, Your Honor, I filed a memo for withdrawal, Your Honor. Main case was disposed, Your Honor. Therefore, I filed memo here.
Memo is filed stating that OS number 220 of 2021 itself is disposed of, and the present memo is filed to withdraw the petition. Same. Yes, folks.
Serial number 4.
Memo is filed seeking to withdraw the petition, stating that the writ petition has become infectious. Same memo is taken on record and discussed.
Serial number 5 for preliminary hearing. Naveen GS for petitioner.
The writ petition wherein, my lords, earlier I had approached this honorable court seeking a direction to the respondent.
16/4/2025 writ petition. You will move a memo in the month of July 2026.
Not listed.
Certain thing we have to leave it to the wisdom of the advocates. Yes. What is the urgency now? Why you moved the memo?
Lords, an order, earlier I had approached this honorable court seeking a direction to the respondents to release the amount for which I had done the work. Thereafter, considering my representations for a work done certificate which was issued in the year 2020, the work was, my lord, shifting of 11 kV electrical cables. In the year 2020.
ESCOM, Mr.
Yes.
Devraj appears. Mr. Devraj is directed to take notice on behalf of respondents.
There is no interim order.
Respondents 1 to 3. What you mentioned that the court has granted a memo?
Lords,
What did you mention that the court has granted you a memo?
Lords, urgency that I am in a financial crisis, no, my lords. The amount that has to
Devraj
be,
is directed to take notice on behalf of respondents 1 and 3. Petitioners shall serve the copy of the writ petition. The respondent shall file their objections within a period of 4 weeks. Close this matter on 3rd of August.
Lords, in preliminary hearing, if I seek, my
Serial
lords.
number,
Wherever hearing, it will come.
Kind, grateful, my lord.
serial number 6 urgent. Serial number 7. BB Shivakumar.
Transfer
Petitioner.
petition of 2 cases to be consolidated and tried is rejected by the principal judge.
What was the case?
The 2 cases are on the basis of the will. Parties are brothers and sisters. But the first suit is filed at page 41 for the relief by the minor against the two defendants, and the relief is with regard to the will executed with the grandmother. The other suit that is filed is on the similar basis of a will and the bequest in so far as the properties are concerned.
That's OS number.
OS 8697,
Oh.
page 80 of 2015.
2015.
They have come up for trial. Trial has yet to commence.
Who are you?
But I am the defendant, a plaintiff a minor in OS 6178 and a defendant in OS 8697. But the mother has executed the will insofar as the movables are concerned in name of the grandchildren, and the will insofar as the son is concerned pertaining to the movable property.
Let's see the order.
The order of the learned judge of the trial court commences at page 21, annexure A.
found in the record, alleged to be found in the record with regard to the admitted signatures of one Dasappa. Further, there is no necessity for scientific investigation as plaintiff is claiming the relief after lapse of 58 years. Well, this contention is concerned, my lord. The plaintiff, in support of their case, have produced the memo issued by the Office of the Director of Animal Husbandry and Veterinary Services dated 7/4/1971, information and the list of pantry books wherein the alleged signature by Dasappa is found. Further, in support of their case, they have produced the copy of the judgment passed by the Honorable High Court of Karnataka, reported in ILR 2009, Karnataka 87, between Aschut and another versus Srimati Nanda and others, wherein the Honorable High Court has held that Order 26 Rule 10A, appointment of a commissioner for scientific investigation, application rejection of challenge to the suit by the plaintiff for partition and separate possession of suit scheduled properties. Defendants 1 and 2 pleaded prior partition of properties as per Exhibit D1. Denial of involves a question which requires a scientific investigation which cannot be conducted before the court. Held admittedly, the suit filed by the plaintiff is for partition and separate possession of the suit scheduled properties. It is the case of the plaintiff as the defendant number 3 that the parties as per the memorandum of partition. Please, Manat.
I've seen the order.
I understood, Manat. I do not want to read also, since my lord direct me to read. Manat, the view taken by Manat, para 12 make Manat, my humble submission, Manat. I can understand where the honorable court has come to the conclusion in letter. Manat, since it is a certified copy where it is not possible to found original signature. But for this purpose, I can understand very well, my lord. Original document is in possession of the defendant number 5, which they did not produce it before the court. But in absence of the same, another procedure is there, which I may be permitted to that extent, my lord. In the office of the sub-registrar, my lord, they will maintain the person's original document of including his LTM and signature in the records of the sub-registrar's office. At least I can be permitted to call for that record, whether it is the signature of my grandfather or not. As we have produced the original documents or the documents issued with the competent authority to show the signature of Dasappa is altogether different than that of what they wanted to claim, which is not executed by my grandfather. That is my humble submission.
Agreed with orders passed in I number 3. Dated 5th July 2025. Invoice number 3203 of 2022. By the Senior Civil Judge JMFC Hoskote. The petitioner is before this court. The petitioners have filed this application. The petitioner plaintiffs have filed the application. The suit is filed for partition and also
declaration.
Separate position in respect of suit scheduled properties and also a declaration that the sale deed dated 26/11/1994, 23/9/2006 and 19/7/1994 are not binding on their share. In the said suit, after when the matter is after the evidence is concluded and the matter is posted for arguments, President IA is filed seeking to appoint the court commissioner. It is a case of the plaintiff that at the time of examination of DW1, he had produced several documents on his behalf, out of which the exhibit D1 certified copy of the sale deed dated 27/5/1952 and also produced a copy of the original sale deed dated 27/5/1952. After verifying the said documents, they are suspecting the alleged signature of their grandfather by name D. Dasappa. Hence, it is just and necessary to appoint a court commissioner for complete adjudication in the matter and to decide the same on merits. The court, by order impugned, had dismissed the application. While dismissing the application, the court has observed that on perusal of the available records and the arguments canvassed by both the parties and on perusal of written arguments filed by the plaintiffs, the suit is filed for partition, suppressed position in the suit scheduled properties and to declare the sale deed dated 26/7/1994, 23/9/2006 and 19/7/1994 are not binding on them as a permanent injunction. On rival pleadings, the court has framed proper issues and both the parties led their evidence by producing oral and documentary evidence. When the case was posted for arguments, the application is for seeking permission to refer Exhibit D1 along with admitted signatures of one Tasappa found in the documents produced at the list on 26/6/2022. The court observed that on perusal of the said documents, which shows that the said documents are not obtained from the authorized authority and the same was also not marked by the parties and the same were also not admitted by this court. Furthermore, the defendants have also disputed the signature. Exhibit D1, the said sale deed was produced in certified copy and they have produced the Xerox copy of the sale deed dated 25/7/1952, which is not marked as exhibit. Both the parties have not produced the documents which are having admitted signatures of Dasappa to prove the same with the disputed signatures alleged to be found in the copy of the sale deed dated Exhibit D1 or from its Xerox copy. The court observed that except D1, the certified copy of the sale deed, both the parties have not produced any material documents for forensic investigation of the signatures of said Dasappa. Accordingly, the court has come to the conclusion that the plaintiff has not made out a case and dismissed the application. Next parallel, and counsel appearing for the petitioner submits that there will be a register maintained by the registrar, the sub-registrar, where the original documents will be there, and from that the signatures can be compared. It is submitted that all these aspects were not considered by the court, and the court has, in a mechanical manner, dismissed the application as there is a dispute with regard to the signature on the sale deed, unless and until the said document is sent for expert opinion. The prejudice would be caused to the plaintiff. Expert, having heard the counsel for the petitioner, peruse the material on record. The relief that is sought is to declare the sale deed dated 26/11/1994, 23/9/2026, and 19/7/1994 are not binding on them, and also they sought for partition and separate portion of the sue scheduled property. Now, by virtue of this application, they want to compare the signatures in Exhibit T1 and the Xerox copies produced by the defendant as per the list dated 26/6/2023. That is a sale deed dated 27/5/1952 for expert opinion. Court has rightly observed that there are no admitted signatures available, and even the document that they are relying of the year 1952 is not marked by is not admitted and marked by the court. And without there being a document of the admitted signatures, the application, when the matter is posted for arguments, that application cannot be allowed. The submission of the learned counsel that there will be a document available with the registrar, and that has to be that he should be given an opportunity, and there should be this document has to be compared with the signature in the said document. This court is not able to appreciate the said submission. The suit is filed in the year 2022. Entire evidence is completed. When the matter is posted for arguments, now the present application is filed, relying on a document which is not even marked as an exhibit before the court. In that view of the matter, this court do not find any reasons to interfere. Dismissed.
Cell number 9. Rajgopal Naidu for
I
petitioner.
represent the petitioner, my lord.
Yes.
The petitioner is the tenant under the second respondent. The second respondent, by developing ill will, has got the power disconnected, temporary power connection disconnected.
Come to the prayer you are seeking.
Prayer, my lord,
Directing the first
to consider the representation, to consider the representation. To consider the representation.
PESCOM.
Yes, my lord.
Mr. Devraju is, please have papers on him. I'll take it up at 2:30.
Tomorrow.
Tomorrow, then where it will come, I'll not take it out of turn. That I'm making it clear. Today, 2:30, it might reach. If I say tomorrow, it will go at the end of the list. What do you want tomorrow? Lizzie's matter tomorrow,
I will get to today itself.
2:30. Serve the papers on Mr. Devraju. Yes, next.
Cell number 10, VB Shivakumar for petitioner.
Lord, defendant's writ petition
Yes.
arising out of the commercial court proceedings. Lord, an application under 711 rule 15 is allowed by the court. But two aspects that are required. Lord, although I am a defendant, I filed my written statement in the plaint.
No. What is this IA?
IA is for production of the documents. Page 18, my lords, may kindly see. There are 5
Defendant in the
email
suit.
correspondence.
You are defendant in the suit.
I'm the defendant. But these documents were not disclosed in the plaint, nor they had reserved liberty to produce these documents at any stage. In the truth of statements that they filed, they did not disclose these documents being available. Now, I have a right to oppose this application because in a commercial court, such a document cannot be filed. But there is also the application that is filed, but does not assign any reasons. But the learned judge allows it. But the law is now settled that in a commercial court, on the date when you file the suit, you must produce all the documents, enabling me to file written statement. I have filed my written statement in the said case. None of these documents have been disclosed.
Let's read paragraph number 8.
Beg your pardon.
Paragraph number 8.
Para A to the order. As far as the objection raised with the defendant is concerned, defendant do not get the opportunity to file statement of admission and denial of the documents pertaining to the documents which now the plaintiff intends to produce can be overcome by according opportunity to the defendant to file the same. On perusal of the email communications, this is what I am of the firm opinion that the documents are helpful to adjudicate the dispute in a better perspective. This court, being the court of first instance, has to accord equal opportunity to both parties to put forth their case effectively. Having regard to the reasons assigned to the plaintiff and also taking note of the fact that email communications arose during the course of business transactions in between the parties, I am the view that IA needs to be allowed by imposing cost.
The court has given you an opportunity to.
No, but his truth of statement must be there. Learned judge fails to note whether in his truth of statement, whether he has reserved liberty to file these documents. And that is mandatory is what my submission is.
When is this commercial suit filed?
But this suit is filed. Let the
2025.
2025. And kindly see the plaint. None of these references are given, neither reserving a liberty insofar as these email correspondence are concerned. It's a surprise insofar as this document.
Let us see the plaint.
Plaint is at page 29, annexure D. Absolutely nothing.
Now, what are the documents that he has filed?
He has
Certificate under section 63, email, all the emails he has.
Emails he has paid. Kindly turn to page 30.
And the plaintiff and the defendant.
Yes.
Let's see what is his case.
The truth of statement at page 37. Nothing is there. None of these documents.
It is submitted that the plaintiff company requested the defendant company several times to pay the aforesaid outstanding balance amount of rupees 16,09,095.
Exactly.
That is now the emails or it witnessing the same.
Emails, we don't know what is spoken to. The emails, if they have been sent, I have an opportunity to say whether those emails correspond in.
So the court has given you an opportunity
to file the truth of statement. Whether those emails.
No, by additional statement that's what the court said. Come to para number.
I have noted that. Should I, when there is a mandatory requirement under the law, but the Supreme Court has also said you can't go on produce documents before the commercial court, as and when you like. The very purpose of the commercial court would be.
What is the present state?
Present state, it's not even commenced the evidence also. They have not commenced the evidence.
Any judgment you're relying on? Because any judgment you're relying on, I'm convinced with the order of the court.
I can place it, because I referred to in my grounds in
Place
writ
it. When do you want?
tomorrow or day after.
Day after.
Cell number 11. Cell number 11.
Side is submitted to appear. The petition, my lord, is seeking writ of mandamus, my lord. The suit is of the year 1994. The respondent plaintiff has filed a suit, my lord, in 1994 for declaration. And it is still
What is
pending.
this?
Ramnagar, my lord.
Why the suit is pending from 94?
I don't know, my lord. It is going on, my lord.
You have filed the order sheet?
Yes.
Where is it?
Order sheet I have not produced, your lordship.
That is
But what
relevant.
has happened, your
That is
lordship?
seeking mandamus.
They filed a suit, my lord, before the municipal court first. Then jurisdiction point came into field, your lordship.
When it was transferred to this court?
2019, my lord. 2019. Then the court has taken time to transfer the matter nearly about 10 years after, my lord, from the date of filing the suit. Now the petitioner before this court, my lord, is a senior citizen, more than 70 years, your lordship.
Please come.
But to more than 32 years, my
Present
lord,
petition
case
is
is
filed.
there.
The present writ petition is filed seeking the following prayer. Being counsel of the petitioner submits the suit of the year 1994. And after 10 years, the suit is filed. Initially, there was filed before the
Municipal court, your lordship. but
municipal court
yes.
and now to the present court. It was transferred in the year 2019. It is
The additional
submitted
senior
that
civil
the
judge.
petitioner before this court. The petitioner plaintiff is aged about
70 years, your lordship, as on today.
has aged about 70 years. Considering the same, there shall be direction to expeditiously decide the suit. Next, considering the fact that the suit is filed in the year 1994, and also the fact that the petitioner is a senior citizen, this court deems appropriate to pass following order. A writ petition disposed of, directing the court to expeditiously to dispose of the matter as expeditiously as possible, but not later than 1 year from the date of receipt of the copy of the order. Say no notice is issued.
Grateful.
Cell number 12. Chandrahasa G. For petitioner.
Not the suit for partition. The suit for partition, not I'm the defendant. This is defendant's petition. The plaintiff not files an order 7 rule, order 6 rule 17 not to include certain scheduled properties. Not before I make this submission. There was a connected petition which your lordship was pleased to dismiss. I have to bring that to your lordship's notice as well. However, what was not considered, what was not argued before your lordship is one point which I may take your lordship through. Your lordship for a moment takes annexure D, which is at page number 58, not for a moment. 58. This is not the amendment application that comes to be filed. The amendment application not only states the list of properties that are added. Now your lordship takes the amended plaint for a moment. There is not one recital that these scheduled properties form a part of joint family nucleus.
Where is affidavit?
Your lordship takes affidavit, is there at page number 58. Is the application. Affidavit your lordship will find at page number 68 of my petition. In the affidavit, your lordship will note that yes, they have said it, that it is a joint family nucleus. But however, your lordship will see the plaint. The reason why I'm saying this affidavit supports the application. But an amendment must be made to the plaint, also the plaint averments, saying that these properties are joint family properties. The reason I'm saying this,
whole purpose,
please,
because they have come to know about these properties
Please,
at a
my lord.
later stage.
Please,
That's
my lord.
where the reason for amendment.
I understand not in the affidavit, but an amendment ought to be carried out in the plaint as well, to state. Now, as of today, there is no pleading that these properties are not part of joint family properties. Your lordship takes if it comes in appeal tomorrow, your lordship will have plaint.
I'm not able to follow your argument.
Please, what?
Suit is filed.
Please,
A plaint is filed
Please,
stating that these are the properties, and accordingly, the suit is filed.
Yes,
and after that, he files an application
Please,
for amendment,
Please.
saying that there are some other properties which
Please,
are not included.
I understand.
Then what is the connection
But
that he
however-
should state it in the plaint?
Your lordship will see why I say that. Your lordship takes the plaint for a minute. Why in para 3 of the plaint, they narrates all the scheduled properties and says these properties are joint family properties. These are part of the.
That is the argument. Then no amendment.
No,
will
I
be
am saying the
permissible.
amendment, I am saying the proposed amendment which is sought must be made even in para 3, stating that these properties are also joint family properties. Now,
Once the amendment is ordered, that will be carried out.
the amendment is carried out to include the scheduled properties. But even as of today, there is no pleading to say that these are joint family properties.
When there is no mention about these properties, where will be a mention ever
I
made in the
understand,
plain?
Manoj. Therefore, I'm saying while making this amendment application for to include these properties, an amendment ought to have been sought saying that these properties are joint family properties. That pleading is not is,
Filed affidavit.
please.
Then this will be carried out in the
But
pleading
the affidavit
also.
will not be carried out in the plaint, Manoj. The plaint will only have the additional list of
It's
properties.
purely a technical issue that,
But the
that can be
technical,
done.
therefore, issues cannot be framed on those questions. Issues cannot be framed
Then
when
take
issues.
notice, I'll clarify that once they come.
Please.
Notice to the respondent.
Cell number
What will happen is unnecessary litigation,
I
unnecessary
understand,
contraction.
but this is only on a technical
But no
point and
useful
before your
purpose
lordship.
would be served.
I absolutely understand.
Because you're also entitled for partition.
I understand.
Listen,
But however, I
notice to
may
the
have to say,
this
not,
Petition is permitted to take out hand summons on the council appearing for the respondent shall file a memo to that effect.
Oblige,
The
please.
Yes. Once a memo is filed, this is matter.
Number 13.
Lord, the impugned order is in Kannada. I will place this translated copy by Monday or Tuesday.
This is matter. On 16th.
Please.
Yes,
Cell number 14.
at the request of non-counsel, the petitioner. Yes.
14. Ashok N. Patil for petitioner.
Sure, in this case. This application was filed, my lords, under order 6/17, seeking amendment, my lords, of the written statement. That, my lords, came to be rejected on the ground, my lords, annexure E, my lords, relevant page will be, my lords.
Insurance company.
Please.
So you want to take another pleading that accident has happened, not happened?
No, my lords, it's only, my lords, incorporating that, my lords, the policy was a act only policy. That, my lords, is
Earlier, what did you say?
Earlier, my lords, we had said that it's a bundle policy. It was, my lords, for a period of 5 years. The accident, my lords, occurred after 1 year. My lords.
What is a bundle policy? What is the act?
Bundle policy is where, my lords, when the new vehicle is purchased, my lords, it is mandated that they have to insure for 5 years. My lords, first year is, my lords, it covers all the, including the, my lords, own damage as well as pillion rider. For the subsequent year, my lords, it will be only act policy. But if the insured wishes, my lords, he has to pay additional premium.
The documents will, the document which you are going to mark will contain all that.
Yes, yes, it would, man. It would.
First year, it will,
It would,
will
ma'am.
cover everything and later it will be
It
an
would
act
contain.
policy for the next 4 years.
Yes, yes.
Let's see. Where is your affidavit?
Affidavit, my lords, is at annexure C para, page 21, my lords. This is the application which we filed, my lords. Seeking, my lords, to add paragraph number 12 after para 11 is this, my lords.
No, this is, I want to see the affidavit.
Affidavit, please, ma'am. The next 22 minutes.
I say that the amendment sought in the application, the said information came to know at the time of cross-examination. What is this?
And the petitioner was traveling in the capacity of pillion rider in the first respondent vehicle where pillion rider is not covered in the said policy and which becomes act policy. Non-filing of the above said application is a not intentional one. No prejudice will be caused to the other side if the application is allowed. But earlier we said, my lord, that the policy is admitted subject to terms and conditions of the policy. But if this is not there, my lords, in the written statement.
How come that is such a crucial fact? After the cross-examination, you will
No,
not
no,
improve your case.
cross-examination, but it was set down for respondent evidence.
At the time of cross-examination, the
Yes,
petitioner and petitioner is traveling in the capacity of the pillion rider.
Yes, ma'am.
So that's the time you want to let other side come notice.
Please.
Cell number
Petition permitted to take out hand summons and file a memo to that effect. Yes, 15.
Cell number 15. Rashid DJ.
The petitioner is a plaintiff before the trial court, my lord. Suit is one for recovery of sum of rupees 8,25,000.
What is IA?
My lord, my application annexure D, my lord, under order 18, rule 17, seeking for recall to permit cross-examination of DW1. My lord, at the
Was the
outset,
PW1 cross-examination completed?
18/9/2025, my lord, the cross of DW1 was closed. 10/10/2025, my application has been filed, my lord.
Come to the order.
Annexure A, page 44, my lord. My lord, there is some delay. I will not deny that, my lord. Due to lack of communication between the petitioner and the council.
Let's read.
Page 44 onwards, my lord.
Read heard both sides thereafter.
I'm sorry, my
Order
lord.
sheet dated 8/9/2025.
The order sheet dated 18/9/2025 shows that DW1 and his counsel were present before the court, but there is no representation on behalf of the plaintiff. This court has given ample opportunity to the plaintiff to cross-examine DW1. In spite of that, plaintiff did not turn up for cross-examining DW1. Hence, cross-examination of DW1 by the plaintiff was taken as nil. As such, the case was posted for arguments of the plaintiff. Now, the plaintiff has moved this application when the case was posted for arguments. The order sheet shows that sufficient time was given to the plaintiff to cross-examine DW1. In spite of this,
When
counsel...
counsel for the petitioner submits that. When counsel for the petitioner submits that, the evidence of defendant was closed on 8/9/2025. The defendant's evidence was closed. Then the application is filed under order 18/17, Review Section 151 CPC to reopen the evidence for cross-examination of the defendant. It is submitted that only on the ground that the plaintiff has not cross-examined the defendant, the court has posted the matter for arguments. It is submitted that if the opportunity is not given to cross-examine the plaintiff, the defendant, it would cause a lot of hardship to the plaintiff. Considering the same, there shall be stay of all further proceedings. Pursuant to the order dated so.
Grateful, ma'am.
Notice to the respondents. Petition is permitted to take out hand summons. Memo shall be filed by 23rd. Or else the stay granted by this court stands vacated.
Bill number 16,
Obliged.
Kendra Pavi, no petitioner.
My lord, the petition before Lordship, my lord, has filed a suit for partition in OS number 12 of 2025. Whereas the respondents 192 before Lordship, my lord, has filed a P&S proceedings for probate on the basis of the bill executed by the grandfather of the respondents 1 and 2. Lordship, kindly see, my lord, the main propositors is, my lord, one Venkatrayappa.
So what is the present IG?
It has been rejected, my lord. Section 10, my lord, of the application is
So
filed for
what if
stay.
first suit for partition is filed when?
25, my lord, 2025.
That is OS number?
OS number 12 of 2025. Either, my lord, it can be stayed or let the matter be clubbed along with OS number 12 of 2025.
P&SC is?
P&S, my lord, 2022.
You are, how are you arrayed in P&SC?
My lord, I was not arrayed as a party. I made an application to come on record because my lord,
OS number?
OS number 12 of 2025.
In that you are the?
I am the plaintiff.
You are not even a party to the P&SC proceedings. Why should it be now?
The reason is this, my lord. Property belongs to the family. In the sense, my lord, Venkatrayappa, the propositors, my lord, there was a registered partition deed in 1965. The properties, which is the subject matter of P&S, my lord, therein, my lord, there is a specific averment to the effect, my lord. The said property has to be enjoyed by himself and his 2 wives and children during their lifetime. Then after the death of himself and his 2 wives, it shall be divided equally among his children. Therefore, my lord, I came on record. However, my lord, the grandfather, Chikka Muniappa, that is the son of the grandfather of the respondent 1 and 2, that is, the grandfather is nothing but the son of proposed Venkatrayappa. He has executed the will. Therefore, I have got a share because by just kindly, I will take your lordship to the recitals in the partition deed, page 46. This is Kannada. Just I will translate.
We'll go to the order so that we'll be understanding the facts of the case.
Yes. Page 70, para 6. Findings. Straight away go to the finding.
Yes.
The petition filed objection stating that respondent 5 filed OS number 12 of 2025 for relief of partition and separate possession of state properties, wherein the petition property is one of the property. This court is not deciding the rights of the parties in this petition. In this petition, the petition claimed that Chikka Muniappa is grandfather of petitions executed a will deed dated 15/7/1921, and based on the same, the petitioners have filed this petition. This court is not deciding the rights of the parties in this petition. The rights of the parties will be decided in OS number so and so. The respondent number 5, who being one of the party in this petition, has to prove that the will is not genuine and not binding on him. The question before this court is whether the grandfather of the deceased was executed will deed so and so in favor of petition, and it is a valid will. Therefore, stay of this petition is not sustainable under law. Well, a will would be a subject matter of OAS and it is a comprehensive one. Therefore, my lord, either I have no objection if it is clubbed along this OAS.
Is he a party to the suit?
Yes, he is a party.
Is there read as respondent number, defendant number?
1 minute. OAS copy. ಇದು ಪಾರ್ಟಿ ಮಾಡಿದ್ರ ಅಂತ ವಯಸ್ ಕಪ್ರೇಟ್ page 52 minute.
Is there read as?
1 minute. Uh, 15 and 16 at page 53.
Now, in the suit, it is a case of the defendant that a will is executed in his favor by the grandfather. And what is the stage of the suit now?
The suit, my lord, the stage of the suit, my lord, Lashma Kandi, prayer Lashma Kandi, page 56.
Issues are framed.
My lord, it is at the stage of written statement and objection by so and so. It is at the stage of written statement.
And this is?
The prayer, Lashma Kandi, page 56 of the prayer, my lord. In the voice. I sought for second prayer.
Please come. There is senior counsel appearing for the petitioner. Submits that an application is filed under section 10. CPC is rejected by the court. The petitioner herein has filed a suit OS number 12 of 2025 seeking a partition and also a relief of declaration that the registered will dated 14/7/2021 is null and void and not binding on the plaintiffs. And in respect of the very same will, P&SC is filed with the defendant number 15 and 16 in OS number 12 of 2025. Hence, as the issues or both the issues, in both the cases, the issues revolve around the alleged will. There is every likelihood of conflicting judgments, and the court ought to have considered the same. Considering the same, they shall be stay of all further proceedings in P&SC number so and so. Notice to the respondents, petition shall take out ransom by 23rd. Memo shall be filed, or else the stay granted by this court stands vacated.
Cell number 17, B. Madhusudan Adiga for petitioner.
He appeared for the petitioner, my lord. I had filed a suit under section 91, read with order 1, rule 8, representative suit in respect of a wrongful act, that is illegal construction by respondents 1 and 2, a huge building, totally illegal construction. It is an agricultural land. It is not converted. No single site layout approval. No kata.
The impugned order.
My lord,
What is the impugned order?
the impugned order, injunction order was refused to me to permit
Let's
to
see
stop
that.
them from restricting.
Yes. In MA it is confirmed.
No, in MA also it is refused. Both the sides.
That's what I'm saying. Order of trial court is confirmed in MA.
Yes, my lord.
Let's see the order in MA. Come to the
They
reasoning
speak
part.
of the hardship of the person who is making an illegal construction, my lord. Hardship of the person.
Come to the order.
MA order, my lord. MA order is at page 43, my lord.
Yes.
And the relevant aspects are at page 53. Lordship, may
Come
kindly
to
go.
para 13.
30. The plaintiff have filed OS number so and so before the Honorable Trial Court in a representative character is not in dispute. Further, the title of defendants 1 and 2 over the suit schedule properties and construction of seminary at this juncture appears is not in dispute. The only question is whether the defendants 1 and 2 are constructing a seminary over the portions of the suit schedule properties in violation of law without sanction plan, in violation of buffer zone. The plaintiffs have relied upon the notice issued by the Panchayat Authority and Deputy Commissioner to the defendants 1 and 2 to stop construction. Further, they have relied on a reply by the Panchayat, BDO, Bidaralli Gram Panchayat, which shows that it has not issued any license to the construction permission to the defendants 1 and 2. But that doesn't mean that the injunction has to be granted, as the plaintiffs have shown prima facie case. It is significant to note that if at all the defendant 1 and 2 are constructing the construction in violation of law, then the concerned panchayat authorities are the proper persons to take action as per law. Though the DC has issued notice to defendant number 1 on 10/12/2024, it appears that the Honorable High Court of Karnataka has stayed in WP number so and so.
So there is a stay on
No,
the
stay
notice.
is not to take coercive steps, not to demolish, but it doesn't say that you go ahead with the illegal construction. It is not to demolish, my lord. I understand.
Because they have questioned the notices that are issued by the respondents before the High Court. High Court has passed an interim order. That case is pending consideration before the High Court. So how can there will be another order by the trial court?
High Court order is not to DC, not to demolish.
That is pending consideration of his main prayer. His main prayer is questioning the notices.
Yes, not to demolish. No, the interim order also is not to take coercive steps from the High Court. But
The final order.
if there is no final
Correct. What is the final relief he is seeking?
relief, is saying set aside the notice of the DC. Set aside the notice of the DC.
So
But
now the matter is pending before the High Court. It has granted an interim order. It has to be decided.
yes, but the High Court does not say that go ahead with illegal construction.
Because the High Court felt that it is not illegal construction, prima facie has granted a direction to them not to interfere.
There is no such finding that prima facie it is there is no illegal construction.
Yes. Please come.
The two submissions, my lord. There is no license, no kata, no plan approval, violation of the buffer zone. Hesarghatta main lake which supplies water to Bangalore city, the tributary, that buffer zone violation is there. Panchayat repeatedly.
You get impeded yourself in the repetition. You get yourself impeded in the repetition.
I filed already. It has not come up.
That would be decided.
Then this may be dismissed as not pressed.
Dismissed as not.
Not
The
pressed.
repetition is dismissed. Give the memo.
I'll file.
A memo is filed seeking a memo is filed stating that the repetition may be dismissed as not pressed. Memo is taken on record and repetition is dismissed as not pressed. Yes, next.
Number 18. Kumaraswamy.
Yeah, for the petitioner.
Yes.
Petitioner is the husband of the original plaintiff. Madam. He had filed an application for to come on record after a death. Madam.
What is the suit for?
Suit for bare injunction. The
The
defendants are the adjacent owners of the property of the plaintiff.
She was the plaintiff.
She was the plaintiff. My lord, after a death, my lord, I make an application for coming on record. My lord, I have produced various documents, my lord.
Come to the order.
Annexure A, page 9. Madam.
Page
9. Annexure. Reasoning is at 12. Madam.
to prove that she is the wife of deceased
Please. Madam.
plaintiff. Come to para 12.
Para 12, Madam. To prove that he is the wife of deceased plaintiff, the applicant has produced exhibit P4 to 29 documents. In these documents, it is mentioned that the deceased plaintiff is the wife of Nagaraju, who is the applicant herein. But in exhibit P1 and 3 documents, the name of deceased plaintiff is mentioned as Madhavamma, daughter of Siddha Shetty. In exhibit P3, the deceased plaintiff has mentioned that she is not married and she is spinster, and there is no whisper about the marriage with the present applicant in exhibit P3. In the plaint cause title, the deceased plaintiff has not mentioned the applicant name as her husband. If the plaintiff really married the present application, she could have mentioned his name in the plaint cause title. My lord, the plaintiff, my lord, she has inherited the property from her father. So she had mentioned only the name of her father.
If a person inherits a property, they'll mention the father's name, but not the
No,
husband's
because
name.
it was relevant. So she had, by mistaken, she had that was omitted. That doesn't, my lord. Even I have also produced that Aadhaar card, the death certificate, and the ration card. Nothing has been considered.
Let's see. Notice to the respondent.
A sort for stay. My lord,
Why should the stay with suit?
my lord, the entire suit will go.
We'll see.
It will be dismissed for some production.
A short date. Notice to the respondents. Petition is permitted to take out hand summons on the counsel appearing for the respondent. It shall file a memo to that effect by 27th of July. There's this matter on 28th.
In first list, my lord.
It is submitted that. Next, before this, it is submitted that the petitioner is the husband of the deceased plaintiff, and he has produced all the document to show that the relationship, but the court has dismissed the application. Considering the same, there shall be stay of all further proceedings. Yes.
Number 19, Puttur Padmavati Suresh.
I'm appearing for the petitioner, my lord. The connected matters are already stayed, my lord.
Take
WP
that.
number, sir.
Yes, 20.
Cell number 20,
Appear for the petitioner, my lords. My execution petition is held as not maintainable. I want to enforce an order dated 1/7/1989 when the defendants were restrained from not to create third-party interest or create possession or interfere with possession. They executed a sale deed and put the JDR number 3 in possession.
What was the earlier suit?
The suit is for declaration, my lords. Declaration and injunction. In that, I obtained an order that there shall not be any disturbance of possession or creation of possession against the defendants, 1 and 2.
Oh, that is, the suit is decreed.
No, suit is not decreed, my lords. It's still that pending.
When was the order granted?
1/7/1989, my lords.
1/7/1989, that suit is pending till now.
Still pending, my lords, because the file got misplaced, my lords. I had to get the file reconstructed. And therefore, my lords, during the pendency of the,
What is that order of injunction?
not to create possession or not to disturb possession. So defend,
Create third party rights.
please, my lords, virtually.
Hmm.
Third, defendants 1 and 2 executed the sale deed in favor of JDR number 3, my lords, in violation of the status quo order. I filed execution petition to enforce that order. I also filed a contempt petition under order 39, rule 2A, my lords. They have been punished. Plus, he should go out of the property and that sale deed has to go, my lords. Kindly see my prayer at page 91.
How can there be such an execution against an interlocutory order?
My lords, section 36 of the CPC, my lords.
Oh, there is an order.
Please,
For
ma'am.
violation of that order,
Please.
you have filed an application.
I have filed
That
a-
would be dealt with by the court.
Contempt court has already punished them, my lords.
Oh.
Passed an order of punishment.
And
Now
you
the
will
sale
seek-
deed has to
now-
go, my lords.
Now you will seek a relief for that.
The sale deed has to go, my lords, in the execution petition. Let's kindly see order 21, rule 32(5), my lords, of CPC.
Come to the order impugned.
Let's kindly come to, my lords, the reasoning portion, which starts from page 25.
So, because the court said not to create third party rights are created. In the execution proceedings, they say whatever the
Sale
action
deed that is there, my lord, that has to go.
set aside in the execution petition.
Please, my lords.
Please read the order.
That's page 25.
Hmm.
The DHR reasoning para 9. The DHR has filed the above execution petition based upon the interim order of
We
status
can come to para 11.
para 11. Having gone through the said understanding of the word decree would amount to a final expression of the court. In the case in hand, the DHR has himself contended that by filing the miscellaneous petition FR number so and so and OS number so and so was reconstructed, and upon the said directions the file was also traced, and that the case is now pending before the CT civil judge in CCH-28. Therefore, the said suit is not yet finally disposed of. No doubt, there might be an interim order of status quo. But with regard to existence of the said status quo, as on the date of execution of the said order, placing the JDR number 3 in possession of the suit scheduled property, and thereby selling the suit scheduled property in favor of JDR number 3 as on 5/10/2000, will have to be adjudicated by way of an effective adjudication. Therefore, since the very wording of the DHR, the suit in OS number is still pending, therefore there is no executable decree in favor of DHR to execute the same. And further, the learned counsel for the JDR has relied upon the definition of the subsection 2 of order 2, subsection 2 of section 2, the Code of Civil Procedure, so far as it relates to definition of decree, is to be well understood. Therefore, on these and other grounds, the JDR has sought for dismissal of the EP as not maintainable. The learned counsel for the decree holder has relied upon the decision in civil appeal number so and so, when the lordship have held at para 6. It is not possible to hold.
So I have gone through any judgment.
Lots.
Yes.
Plus one judgment. The court referred to para 6. Para 4 was relevant, my lords. The sole ground on which the High Court has refused to permit execution of the order is that the order sought to be enforced in execution is an interim order. This finding of the High Court is obviously untenable in view of section 36 CPC, which reads as
You
under.
cannot call this as a precedent, because there is no ratio laid down in this.
My lords, they relied upon 1965 Supreme Court, my
That
lords.
is not, we can't consider it as a precedent.
Then, my lords, are the judgment of the learned single judge.
This is also the same thing.
Because my lords may lay down the law, my lords. Because kindly see, my
So
lords,
for an.
kindly see
interim
order
order,
21, rule 32.5.
we'll see that the other side comes notice to the
Please,
respondents.
grateful.
Serial number 21. Sidramaya VB for petitioner.
If that is the case, every we have to constitute at least 1:10 ratio executing courts. If this proposition is upheld.
Because ultimately, my lords, the majesty of the court's order has to be maintained, my lords.
It
It's
has
not-
to be, that's why there is a contempt, there is a order, but not as if like it is a decree, if it has to be executed. That's what I said, 1:10.
Section 36, my lords. That way, my lords,
Such a
the
far-fetched
law commission has
definition.
also said we have to increase the number of courts, my lords.
No, if your proposition, definitely we have to. Yes.
Serial number 21. Sidramaya VB.
No representation, just in the month of September. Yes, 22.
Serial number 22.
Petitioners, request a short pass over.
Passover, I will call if it permits, or else I'll call, it will go to tomorrow. Yes, Passover.
Serial number 23. 23 Uday Prakashyam.
This is a connected matter similar as I had argued last date, my lord. They requested it.
What is that?
19547, my lord.
Take
Commission report where the ADLR had not filed the report, but the Taluk surveyor had filed the report. It's a connected RA. Similar order was passed by the.
Then counsel to the petitioner submits that in a similar matter, that's in WP number 19547 of 2026. This court has passed the following order. Extract that order. In the light of the same, there shall be stay of all further proceedings. Same notice in addition to all same. Yes.
Great.
Serial number 24. Balraj VR.
24, 25 and 157 and 158 notes.
24.
24, 25
uh,
and 157 and 158.
in the same list.
All are same release
One
notes.
minute.
Regarding this connection of electricity connection is concerned, the matter was listed before this court yesterday. Serial number
157 and 158.
158, please.
Mm. Mm.
And Devraj is the best
Take
come
it up afternoon or?
2:30 minutes.
Yes. in all the-
Devraj will come minutes.
Serve the notices on.
Already served minutes. Is requested to take up the matter at 2:30 minutes.
2:30.
He is held up in some other courts.
Overloaded. Yes. 2:30. Call these matters at 2:30.
Yes. Serial number 25.
25 also corrected, and other numbers you have noted down?
24, 25 and 157, 158.
All four matters at 1:30. I mean 2:30.
Yes.
Yes.
Serial number 26. 26 Umesh MN.
Petitioner, please. Plaintiff's writ petition challenging the rejection of application filed under Order 6 Rule 17. Suit was, I had filed a suit for the specific performance. Suit came to be decreed ex parte. Then they filed miscellaneous, the defendants filed miscellaneous petition. Miscellaneous came to be dismissed. Thereafter, the matter was taken before this honorable court by filing an MFA. MFA was allowed and the matter was remitted back to the trial court. In between, there were certain developments, like the defendants had agreed to execute sale deed in respect of 2 acres 32 guntas, of which in respect of.
Come to the IF.
Please, ma'am. Your lordship would find at ink page number 59. The proposed amendment.
No, the proposed amendment.
Yes,
affidavit.
3A. Before the plaintiffs entered into contract with the defendant offered to sell the entire property, including the scheduled property, for a total sale consideration of 70 lakhs, and the plaintiff agreed to purchase the same for the said amount. Thereupon, the defendants executed sale agreement dated so and so in favor of the plaintiffs. Accordingly, the defendants agreed to complete their part of the contract within 6 months from the said date by providing all the necessary documents, and also undertaken to execute the sale deeds either in favor of the plaintiffs or in favor of their nominees. And subsequently, out of 3 acre to 3.2 acres of land, The defendant executed sale deed in favor of the plaintiffs and their nominee with respect to 2 acre 19 guntas by way of several sale deeds and agreed to execute the sale deeds with respect to remaining extent of 23 guntas in favor of the plaintiffs whenever the plaintiff called upon to do so. Though the said sale deeds executed by the defendant, they received 3/4 of the aforesaid amount from the plaintiffs and other purchasers and agreed to execute the sale deeds with respect to the suit scheduled property subject to payment of remaining consideration amount. Accordingly, the plaintiff paid a sum of rupees 56,80,000 so and so, and the plaintiffs are due only in the sum of rupees 13,19,608, and the plaintiffs are ready to pay the said amount. This was sought to be incorporated, and the stage of the suit is at further evidence of the plaintiff.
How can you take this plea at this level? This is not a subsequent development.
This should have been stated properly.
You can't,
But-
2008 suit.
True,
And
well,
in
no,
and in
the
2026.
appeal came to be disposed.
That
May I
is
request your lordship to kindly take ink page number
fundamental
53,
issue.
Miller. Ink page number 53.
What you said was that something has transpired
Yes, ma'am.
after the decree is passed.
Yes,
That is a
ma'am.
different, but this is not something, no, come to second page.
Yes,
In
ma'am.
guise of that, you say that the plaintiff paid an amount of rupees 56,80,392 to the defendant.
Yes.
And the plaintiffs are due only 13,19,000.
Yes.
That is, this is available to you even in 2008. This is not a subsequent cause of action.
But how the consideration was adjusted in respect of the earlier sale deeds, that I wanted to narrate it. That has been.
Okay, that can't. Please come. Agreed with the orders passed in I number 12. Invoice number 374 of 2008, dated 27 March 2026. The plaintiff is before this court. The suit is filed seeking specific performance of an agreement of sale that came to be decreed ex parte, and later the said ex parte judgment and decree is set aside. Now the suit is at the stage of
Further evidence of plaintiff.
further evidence of the plaintiff. The present application is filed seeking, application is filed under Order 6, Rule 17, seeking amendment of the pleadings. It is a case of the plaintiff that the suit is filed for specific performance. The plaintiffs have recently changed their counsel and came to know about the defense taken by the defendant number 2 to 4. The plaintiffs have handed over the vital documents to the counsel. The plaintiffs have filed an application to withdraw the suit with liberty to file a fresh suit on the same cause of action. That came to be rejected. There was no transaction between the plaintiff and the defendant as alleged in the written statement. The plaintiff could not able to disclose the real transaction and illegal acts done by the defendants. Hence, they wanted to amend the pleadings. That came to be dismissed by order impugned. The court has observed that the amendment cannot be allowed to overcome the defense set out by the defendants. In para number 10 of the affidavit, the plaintiffs have stated that they could not disclose real transactions and illegal acts done by the defendants in their pleadings. It is not explained that what had prevented the plaintiff to disclose the complete facts and transactions in respect to the suit transaction in the inception. The court further observed that the mere changing of the counsel is not a ground to seek for amendment of claim. On careful perusal of the proposed amendment, it is prayed that certain facts regarding the payment of an amount of rupees 56,80,932 to the defendants has been sought to be inserted. It is nowhere stated in the affidavit that what had prevented the plaintiff to disclose the said facts at the time of filing of the suit or at any later stage before commencement of the trial. The court has come to the conclusion that the amendment sought after commencement of the trial cannot be allowed liberally unless cogent reasons are made out by the applicant. The amendment which gives rise to a new case cannot be entertained and accordingly dismissed. Next, parallel counsel appearing for the petitioner submits that the said amendment is very much crucial for deciding the dispute between the parties. Because of the mistake on the part of the counsel, certain important aspects with regard to the amounts were not stated. Unless and until this amendment is carried, it will cause hardship to the plaintiff. It is submitted that the court cannot look at the cannot look at the issue in a hyper-technical manner. And the court has to balance the interests of the parties. And also, when a particular amendment is very much essential for adjudicating the dispute between the parties, the court ought to have allowed the application and no prejudice would be caused to the defendant. Next one. Having heard the learned counsel, the petitioner, there is a material on record. Suit is of the year 2008. The petitioner wants to place on record certain facts which were never taken before. Now, after the evidence is set down and the matter is posted for the further evidence, this aspect of paying the payment of amount or any amount that is what is outstanding amount that has to be paid is an important aspect in a suit for specific performance. And at such a belated stage, the plaintiff cannot be permitted to introduce a new pleadings which would change the nature of the suit. In those circumstances, the court below has rightly dismissed the application, and this court finds no reason to interfere. Accordingly, this.
Great.
Cell number 27.
Yes, petitioner.
Has read it.
We are challenging the order passed by the learned trial court Mellad regarding IA number 1 or 39 rule 1 and 2 Mellad. The respondent
What is the suit for?
Suit for declaration as well as the
You are the plaintiff.
Plaintiff.
Both the courts have held against you. Both the courts have held against you.
No.
Oh.
The sale deed was created by the R1 to R3 Mellad. We are the owner of the property Mellad. They created a person.
What is the IA for?
IA1 not to interfere our peaceful position and enjoyment.
That's an injunction application filed.
Yes.
What did the trial court do?
Trial court was issued notice Mellad.
Where is that?
Your page number 36.
No, where do you get the order? Not at 36.
Annexure 16(6) Annexure D.
Page number? Please come.
666.
The counsel for the petitioner. The present writ petition is filed seeking the following prayer. Then counsel for the petitioner submits that they have filed the suit seeking declaration and injunction. In the said suit, an application is filed seeking an ad interim temporary injunction, and the trial court, by order impugned, had issued emergent notice returnable by 16/7/2026. Then counsel for the petitioner submits that when an application is filed seeking injunction, the court has to pass an order on the merits of it, but it cannot issue emergent notice. He has relied on an order passed by a coordinate bench of this court in so and so. Considering the judgment that is passed by a coordinate bench of this court, refer to supra. This court is passing the following order. The writ petition is disposed of, directing the trial court on the same day and ask them to decide it on 16/7.
Kindly, they are interfering in our peaceful. My lordship may kindly see the annexure H.
What do you want the court to do? I will
not
not
to interfere.
I will not grant any order. The court will decide. I'm saying it is coming up anyhow on 16th. It's just a week. The disposed of, directing the court to consider the IA on 16/7/2026, notwithstanding the fact that the suit summons was served on the respondent, defendant or not. The defendant or not. The court on that day shall pass orders on the IA.
Like they are created the kata as well as the regarding the personation. That's why Malad we have filed it.
Next.
28. Pawan Kumar ji.
Defendant's writ petition.
Yes.
Application seeking amendment of plaint was allowed. Lordship may kindly come to page 20.
What is the suit for?
Suit for declaration.
Which year?
Of the year 2024.
What is the IA
23,
now?
my lord. IA for the amendment of schedule.
To that affidavit.
Page 21, my lord. I am aggrieved by the second amendment sought for.
1 minute.
Please, my lord.
What is the second amendment?
The entire boundaries is changed, my lord. Page 21 and 22. Amendment 2 sought for delete suit schedule property boundaries as so and so and add East Bay Road so
What
and
is the
so.
stage of the suit now?
Now plaintiff evidence.
Hmm.
Basically, the entire schedule is changed.
Let's look at the affidavit.
Affidavit, my lord, is at page 23, second para.
Now,
Please, ma'am.
suit is for,
Declaration.
they're seeking declaration basing on,
Based on a sale deed.
so what are the boundaries in the sale deed and what are these boundaries?
Now they have bought in this sale.
So these boundaries, which are by amendment they are seeking, are the boundaries mentioned in the sale deed. So they say that it's a typographical mistake. What is wrong in it?
But the entire, what they instituted a suit on a set of scheduled property. Now they change the entire scheduled property. The change is a subject matter.
What is that they have changed? They're seeking their declaration of title basing on a sale deed. Whatever is the schedule in the sale deed. Now by way of this amendment they have sought. They said it's a typographical mistake. No prejudice to you.
The prejudice is the entire subject matter is changed. That is the difficulty.
That I understand.
Subject matter changes.
Please come. Agree with the order passed by the court on I number 2 and 3 dated 4/4/2026 in OS number 808 of 2023 by the principal senior civil judge and CJN. The petitioner defendant is before this court. The respondent herein has filed a suit for declaration and injunction.
Declaration, and they filed second application for now seeking injunction. That is also allowed. Same impugned order.
Declaration and injunction. In the suit is of the year 2023. When the matter is coming up for the plaintiff's evidence at that point of time, the plaintiff has filed an IA seeking amendment of the plaintiff. By way of this amendment, the petitioner want to add one paragraph, and the second prayer is to correct the boundaries of the suit scheduled property, and it is a case that it is a typographical mistake. The court, by order impugned, has allowed the IA. While allowing the
Para 10, my lord.
court has observed that it is a burden on the plaintiff to prove the pleadings and schedule of the property upon which he intends to have the declaratory relief. As such, it appears that both amendments sought and the application are very much essential to maintain the suit before the court, merely because of the fact that the plaintiff has not produced any documents corroborating the schedule of the property would not disentitle the plaintiff from amending the plaint, as a burden is upon him to substantiate it. However, both amendments will neither change the cause of action nor the nature of the suit. The amendment in respect of pleadings are in the form of explanation, and the relief sought has been corrected by including the consequential relief of injunction. Though the second application is maintained in the case was set down for evidence of the plaintiff, he has not led evidence. Moreover, though the defendant has resisted both application, not at all produced any contrary materials to disbelieve the version of the plaintiff. That apart, if the applications are allowed, no hardship will be caused to the defendant. On the other hand, if the application are not allowed, much hardship will be caused to the plaintiff, and the same cannot be compensated, as it will non-suit the plaintiff, and accordingly, the court has allowed the application seeking amendment. Next, parallel counsel appearing for the petitioner submits that petitioner is not aggrieved as far as amendment number 1 is concerned, but is more aggrieved by amendment number 2, whereby the plaintiff is completely changing the nature of the boundaries of the suit scheduled properties. In that case, the entire nature of the suit will be changed, and that would cause prejudice to the defendant. This aspect was not appreciated by the trial court, and the trial court ought not to have allowed the application. It is submitted that the order impugned is liable to be set aside. Next, having heard the counsel for the petitioner.
It's not on sale deed, but they say it's only ancestor property. My apologies.
The learned counsel for the having heard the learned counsel the petitioner peruse the material on record. The plaintiffs have filed the suit seeking declaration and injunction, basing on it is stating that the property is an ancestral property, and they are the owners of the property. Initially, certain boundaries are mentioned in the plain. Later, they have said that there is some typographical mistake with regard to the boundaries, and they've changed the suit schedule, and they wanted to amend the plaint by introducing this particular change in the boundaries. Land counsel for the petition submits that it would change the cause of fire, the entire suit. This submission, this court is not able to appreciate. Now the evidence is not yet commenced. It is a case of the plaintiff that there is a typographical mistake in the schedule of the property. If the same, and as it is the burden lies on the plaintiff to prove his case, and this amendment is not brought in for to cover up any latches, the part of the defendant, on the part of the plaintiff. When as rightly observed by the court, if this amendment is not allowed, lot of prejudice would be caused to the plaintiff, and if that is allowed, there is no prejudice to the defendant. While considering the application under Order 6 Rule 17, the court has to balance the interest of both the parties and look at the substantial interest of the parties. In those circumstances, this court is of the view that the trial court has rightly considered, allowed, and this court finds no reasons to interfere. Accordingly dismissed.
Also 32, my lord. Also seal number 32.
Yes.
Also seal number 32, same one.
32, that is arising out of
Same impugned order. That is 213.
32 also same. Look at it in this, what is IA, in that what is the remaining all same.
Grateful.
33 you said?
32, my lord.
32.
Grateful.
Cell number 29, Ravi Shankar S.
This is with regard to order 8 rule, yesterday matter. Same similar matter, my lord, you have granted stay. Order 8 rule 9. There are two suits for two applications for two writ petitions for one as came yesterday.
And counsel for the petition submits that in the connected matter, this court has passed an order that is WP number 20179 of 2026.
Yesterday.
Same similar order in this one. Yes.
Cell number 30,
My lord, I am petitioner, my lord. My lord, the petition had two petition. The another WP number, my lord, FR number 20665, pending before the scrutiny bench. Can be proposed this one along with the WP number 20665, 2025, 2026.
This along with so and so.
cell number
Give
31.
the write a number and give it to the court officer.
Slip code is there.
Whenever any of the advocates are mentioning anything, write it and give it to the court officer. Otherwise, it will lead to unnecessary confusion. Yes.
Or a plaintiff's petition, my lord.
31.
My lord, the defendant, after 1,494 days, files an application at the stage of my evidence to bring his written statement on record. Now,
Is it a commercial suit?
no, my lord,
Normal.
regular suit.
What is the reason? What are the reasons
My lord,
stated?
the affidavit, my lord, is at page 24. Page 24, paragraph 4, my lord, at page 25. He says that, I say that
But
the
you go
above
to the
suit,
order of the court. From the order, we'll read.
my lord, it's not stated in the order.
No. What is the reason for the court
Yes,
to allow
ma'am.
the application?
The order is at page 17. The reason is at para 7,
Hmm.
which is at page 20.
Hmm.
Having safely relied on the verdict, it is also crucial to note that the defendant number 1 has tendered his appearance and also filed his objections to IA 2 and 3 and also advanced his argument to IA 2 and 3. It is also crucial to note that the defendant has also contested the case before the Honorable High Court of Karnataka and MFA so and so. However, due to the confusion in view of COVID-19 second wave lockdown, some confusion has resulted in the non-filing of the defendant number 1. It is crucial to state that it is held in the case of Salem Advocates Bar Association so and so. Statutory period mentioned in CPC is directory in nature and not mandatory.
When was the suit filed?
21, my lord.
20?
21. It was filed on 12/5/21. 12/5/21, and he has rendered appearance. Please see his affidavit, my lord.
So you can give the dates.
Yes, my lord. I'll just. Is it affidavit? Please see his para 4. He himself brings it out. Page 25. Suit is filed on 13/5/21. He renders appearance on 17/5/21, and he files his statement of objections to IA 2 and 3 by e-filing on 23/5/21, para 4 at page 25. Now please see para 7, my lord, which is his explanation, para 7, 8, sorry, para 8 and 9, that is page 27. I state that the case was posted from time to time for framing issues. The issues were framed on 5, 6, 20.
Probably defendant was thinking that the written statement will be filed after the matter is resolved for.
No, my lord. He gives the explanation.
No, that's what I'm saying. He's thinking that it has to be filed once the case is resolved for judgment, then the written statement has to be filed. That's why he probably is waiting for all this. Please come. The present writ petition is filed. Agreed with the order passed by the court, whereby the trial court has allowed has taken the written statement on record after
494 days.
1,494 days. It is submitted by the land council that the defendant is contesting the matter and without even giving any reasons for the delay, he has filed the application and the court without considering the objections filed by the plaintiff has taken the written statement on record. Considering the same, they shall be stay of all further proceedings pursuant to the order dated so and so. Notice to the respondents, petition is permitted to take out hand summaries. File a memo to that effect by 24th, or else a stay granted by this court stands vacated.
My lord, may I request the stay of only the impugned order, my lord?
That's what I said.
Yes, sir.
As for pursuant to the order.
Because I'm a 90-year-old man. I have to record my examination in sheet.
The order dated, or there shall be stay of all further proceedings. That's why I said pursuant to the order.
Yes, my lord, because now it's only for my, all I'm requesting,
So-
my lord, let me record my evidence, because if something happens to me.
They shall be stayed as far as the operation of this order is stayed. All further proceedings may go on.
Grateful, ma'am.
Yes.
Cell number 33, 32 disposed, 33 Lingraju KR.
This effect appear for petition, my lord. It's a suit for partition, my lord. So defendant number 1 petition, my lord. My lord, page number 69, my lord, annexure E.
What is the suit for?
My lord, suit for partition, my lord.
The IA.
My lord, before that, my lord, page number 69, annexure E. This is the judgment and decree in decided suit, my lord. Few documents produced in that suit, marked. Those very same document have produced in this suit. My lord, document have been accepted. My lord, some sale agreement and say consent deeds are there. My lord, once a document produced in earlier proceedings, my lord, they need not prove. My lord, in these proceedings, my lord, now the court insisted kindly produce the original document and required to pay the stamp duty, and it's not arises. Once the document produced in earlier suit, very same document have been produced before this court. Where is the need of production of originals of?
What is the law on that?
My lord, section 35, my lord, even Supreme Court also clarified, my lord, admitted document did not be.
Again, who admitted the documents?
My lord, in earlier proceedings.
What is the suit? What is the purpose in the, for example, a particular document is relied on in the other document, other suit.
My
Please understand.
respectful, in earlier suit, the document
You didn't
was
hear
admitted.
What is my query?
Please, my lord,
How
please,
can you answer without hearing my query?
please, my lord.
I said, in the earlier suit, a particular document is marked for the purpose of collateral purpose. For a collateral purpose, the criteria is different. Now, in a subsequent suit, you wanted to rely on that document for a primary purpose. So, you cannot, the same analogy what is applied in the subsequent suit will not apply to this suit.
My lord, 1965 Honorable Supreme Court full bench judgment, the document admitted in the earlier proceedings need not be proved.
Now I have asked you a question, you answer to that. I said, in a particular document is marked for a collateral purpose, where it is it is impounded for that particular purpose. They cannot rely on the primary purpose. So the same document here you rely on for to prove your further declaration. Then
No,
the criteria will.
I am the defendant. I'm not seeking declaration. I am only producing those documents saying that there was transaction between the family.
Something, how It is as it is, that document cannot be taken in this court as it is. That depends upon facts and circumstances of each case.
My lord, now documents are before that court. How can I produce the original document before this court? That can't be. Now, the document which are produced before this court now, those documents are seized.
We'll see, take notice.
My lord, now kindly see, court is insisting, kindly see the order dated so and so.
When is the order passed?
My lord, order passed on, my lord, 25/4, my lord, before vacation, 25.
Take out the short notice, I will not grant stay.
My lord, now today's matter listed today, insisting to produce the original. How can I produce it? Original documents are before court.
Matter on the petition is permitted to take out hand summons.
1 to 4, my lord, plaintiffs.
Respondent,
1 to 4. Others I seek dispensation.
remaining, who are the others?
My lord, other defendants, my lord.
Same thing, like how it happened yesterday. Look at the cause title and tell the court who are the other defendants.
My lord, 5 to 20, my lord. 5 to 20.
Memo, give the memo.
Please,
Memo
ma'am.
is filed seeking dispensation of notice to 5 to 21. The same is dispensed with. Notice to respondent 1 and 4. In addition, hand summons and petition shall file a memo to that, shall take out hand summons and file a memo to that effect by 23rd of July. If the memo is filed, list on 24th.
My lord, my respectful submission, my lord. Now the originals are with before
Only 1 week.
earlier proceeding.
1
How
week.
can I? It is not possible to produce. How can I pay the stamp duty on those documents on Xerox, my lord? My lord, today's matter, my lord, court is again and again insisting, my lord.
Tell the
For-
court that it is matter coming on 24th.
Cell,
Please, ma'am.
cell number 34. Mohan S for
I
petitioner.
appear for the respondent. May be permitted to file my wakalat for respondent number 1, who is the plaintiff before the court below.
It is not even notice is ordered. Why you want to file your wakalat? Let him argue.
My lord, the suit for specific performance. An application is made seeking a direction to the plaintiff to produce an unregistered, undisputed document which has been referred in the registered sale agreement in Exhibit P1. The Lakshmi kindly take to page number 25 of the paper book. This is an undisputed fact that there was some money transaction between the parties. And my specific defense was that there was no sale
Come to
agreement.
the impugned order straight away.
Impugned order, it runs from, I have just, page 86, my lord. Page 86, the order is dated 25/6/2026, where my application seeking a direction to the opponent to produce an undisputed document agreement of sale dated 28/4/2011. This document is, a reference is found in this, about this document in Exhibit P1, which I have produced it at Exhibit P1, which I have produced along with
They have
the
filed an application seeking a direction to the plaintiff to
Correct.
produce the original unregistered
unregistered sale agreement.
document dated 28/4/2021.
Correct, my lord.
Which is alleged to have been executed by
And-
defendant number 1.
Correct.
Then he must have produced it because that is the agreement on which he is seeking specific
No,
performance.
that's not the agreement which is relying upon in this suit for specific. He relies upon a registered sale agreement subsequently. And that's why I
For
made
whose case is that there is another agreement?
another agreement. According to him, 2011, there was an unregistered sale agreement.
Is it the case of the plaintiff?
It is the case because he produces Exhibit P1. Your Lordship may kindly take to page 25 of the paper, my lord. There is a mention about the earlier agreement also, which I do seriously dispute it, that there was some money transaction between the parties. Your Lordship may kindly take to page 25 for a moment, my lord. Exhibit P1. Otherly, there is during the year 2011, the vendor has agreed that he would form sites in the main schedule property by obtaining layout plan sanction, and the rates are also mentioned under an unregistered agreement of sale 28/4/2011. This document is of 2017. According to me, there was some loan transaction between the parties. So when he makes a mention, then I seek permission of the court, give a direction to him to produce this agreement of sale, which he also doesn't dispute. Even in the chief examination, he makes a mention about this.
No, the suit is, the trial has concluded.
Trial completed and an application is made for recalling for the next date.
Why should,
Further examination of the defendant that is slated on 13/7/2026.
it is reopened?
It is reopened.
Your Lordship, if I may make a submission. The defendant number one, who is the petitioner in this case, has denied the execution of the very same document in his written statement as well as in his evidence. Now he has come up with this application saying that the plaintiff has produced this document, which the plaintiff is not even relying upon to prove his case. Exhibit P1 is already an
No, in the
unregistered
affidavit,
document.
where is your affidavit? Why you want that document? Page number?
My lord, page number 70, my lord. Para 3, the document on which plaintiff is relying is a crucial document to ascertain the real facts of the case. Plaintiff has adduced it, and even in the evidence, there is a reference to the unregistered agreement of sale dated 28/4/2011. The present sale agreement dated 13/7/2007 is in
Why do
continuation
you
of the
want that document now?
because according to me, it is a loan transaction, there is no agreement for sale at all.
Anyhow, he has to, there is another agreement of sale which has to be proved.
No, even that document I
No,
dispute.
that you can prove. How is it, how is this necessary?
He makes a reference in the evidence also.
Deny it. You deny it.
I deny it.
Yes.
Because-
No, if at all, if it is, that is for him to prove.
No, that's right, my lord.
There are no, is there any issue with regard to that?
No, Your Honor.
Then what is the purpose of reducing the evidence?
No,
when there is
because
no issue?
it will show some light on the between conduct of the parties because it is not a sale agreement.
But how did you realize it after concluding of the
No,
trial?
of course, belatedly, of course, I don't want to go beyond that. Because after, but anyway, the case now stands for
He has
reopening.
taken a stand with regard to, in the plaintiff,
No,
he
he
has
relies on
stated about
exhibit
the
P1.
2011 agreement.
2011.
Then subsequently, there is in 2017, there is a registered agreement.
Correct.
On for that, he has filed a suit for specific performance.
Correct, very true.
You denied it. You denied
I deny both the
2011,
agreements.
2017.
2011, 17
Now,
both.
what is to be proved is
No, the-
2017.
My specific defense was neither I agreemented a sale agreement of 2011, nor I
It's
executed.
inconsequential.
Because it should show
Yes,
more
please
light on
come.
this agreement. To show some more light on the conduct of the court, because it's a loan transaction, first of all.
The agreed with the orders passed in I number 18 in OS number 168 of 2020 dated 25/6/2026 by the Senior Civil Judge and JMFC Nelmangla. The defendant is before this court. Respondent herein has filed a suit for specific performance based on the agreement of sale dated 13/7/2017. In the plaintiff, it is stated that in continuation of an earlier unregistered agreement of sale dated 28/4/2011, the registered agreement of sale dated 13/7/2017 is executed. The defendant has denied the execution of both the agreements. Thereafter, basing on the pleadings of the parties, issues were framed. And the issue is whether the plaintiff could prove that there was a agreement of sale dated, registered agreement of sale dated 13/7/2017 is executed by the plaintiff, there is an whether the agreement of sale dated 13/7/2017 is proved by the plaintiff. There is no issue with regard to the agreement dated 28/4/2011. Then the present IA is filed, seeking a direction to the plaintiff to produce the original unregistered sale agreement dated 28/4/2011, which is alleged to have been executed by the defendant number one in favor of the plaintiff. That came to be dismissed by order impugned. The court has observed that the defendant number one has categorically denied the execution of an unregistered agreement of sale both in the written statement as well as in his oral evidence. Having taken such a specific defense, the defendant cannot now seek production of the very same document, whose execution he has consistently disputed, with the object of compelling the plaintiff to produce it at the stage of final argument. Such inconsistent stands do not advance the case of the defendant for exercise of the inherent powers of the court. Moreover, if the application is allowed at this stage, what is that? Inevitable consequences would be reopening of the evidence, consideration of recording admissibility of the document, payment of stamp duty and penalty if any, and affording further opportunity to both parties. Such a course would unnecessarily delay the disposal of a suit which has already reached the stage of final arguments. In the absence of any compelling necessity or exceptional circumstances, the court is not inclined to adopt such a course, and accordingly, the court has dismissed the same. Next para. When counsel appearing for the petitioner defendant submits that the petitioner defendant has denied the both unregistered agreement of the year 2011 and the registered agreement of 2017. It is submitted that to prove the case of the, it is submitted that to prove the conduct of the plaintiff, the agreement dated 2011 is very much essential, and the court has failed to consider this aspect and dismiss the application. It is submitted that in the the plaintiff has taken a consistent stand with regard to this agreement. The same ought to have been produced before the court. Just only on the ground that it is filed at a belated stage cannot be a ground for the court to reject the application. Next para. Having heard the learned counsel for the petitioner, peruse the material on record. The suit is for specific performance, which is of the year
2020.
2020. It is an undisputed fact that the evidence of the parties concluded and the matter is posted for argument. At that stage, the present application came to be filed. The court has the present application is filed. The issues are framed long back, and there is no issue pertaining to the agreement of sale of the year 2011. Basing on the pleadings, the court has framed the issues and evidence was let in, and the matter is posted for final arguments. At this stage, the petitioner filed this application, seeking a direction to the respondent, seeking a direction to the plaintiff to produce a said document. When that document is not the issue in this, that is not the document basing on which an agreement of the specific performance of an agreement is sought, and when there are no issues in that effect, and even by producing the document, it is not going to make any difference on the evidence as already let in. The court has rightly considered all these aspects and rightly dismissed. This court finds no reasons to accordingly dismiss.
35. Anirudh for petitioner. 35.
Yes.
My lady, this is a case arising out of COM OS 1724 of 2024. The Honorable Commercial Court, by way of its impugned order dated 25 April, has directed the plaintiff to amend the plaint in a manner where each plaintiff is filing a suit against each respective defendant. Now, my lady, the difficulty here being the petitioner or the set of petitioners.
Come to the impugned order.
My lord, my lady.
Page number.
504. Issue number 3, treated as preliminary issue with order dated 30 January 2026, is answered.
Page number 2.
504, volume 2.
Order is in the second volume.
My lady. (504). Issue number 3.
That's the operative portion of the order.
My lady.
Issue 3.
Issue 3 is
as a
treated as preliminary issue. With order dated 30 January 26 is answered in the negative, holding that a single suit by all the plaintiffs, which is the petitioner in the present writ, against the defendant.
Who are the plaintiffs?
My lady, the plaintiffs are individual people who have invested monies through defendant number 1 and 2. Defendant number 1, through its director, had approached these plaintiffs seeking investment into their company. Now, these investments have been done in 2 ways. I'll refer to page 41 in volume 1. There's a chart indicating the entire table of how this investment has been made.
Let's see.
My lady, page 41 of the volume 1. My lady may see in the middle there is a plaintiff. Now, plaintiff has invested money to defendant number 1 and 2, wherein they have also entered into 2 agreements, which is one is a supplementary LLP agreement and one NCD.
What is the relationship between the plaintiffs?
My lady, they are not related. No manner they are related. They
All have an independent cause of action against the defendant.
my lady, my lady, that is correct. However, the transaction that has taken place has been done as a whole. It has been connected as a series of same transaction, wherein money from the plaintiffs have been routed through various defendants and has been pooled into 2 entities, which is defendant number 3 and defendant number 4. Now, at the outset, the investment was on the basis that quarterly payout would be given on the basis of whatever real estate project is going on. Now, the plaintiffs have not received any communication, any quarterly payments regarding to that extent.
Why the plaintiffs cannot file independent suits?
My lady, the difficulty here being because,
What is the difficulty? Everybody has their own cause of action.
my lady, at the end, the question of law that would arise out of all the transactions and the plaint when it is read as a whole is where that money went. Because at the end, defendant number 3, and the entire scheme at the outset is a Ponzi scheme. Because there is no real project, there is no real income which is coming out, which is generated, which is divided among the investors. Basically the scheme is some investors give money.
So basing on what you say that one suit is maintainable.
My lady, if the plaint is read as a whole, if examination and every document is analyzed at the whole, it is 2 entities which are receiving money through various other entities.
But cause of action for each one of you is different.
My lady, I understand. My lady, I understand the point that cause of action arise on basis of different agreements, different dates, different everything. Be that as it may, the plaintiffs had invested.
That be that as it may. That is a crucial aspect.
My lady, that's what I'm coming as well. The plaintiffs had invested money in defendant number 1 and 2. That's clear.
That
Now,
I understood.
now
Because defendant is one and the same, and
Yes.
plaintiffs who are unconnected, who has independent cause of action, because they have grievance against defendant too, all of them will file one suit.
My lady, that's where order rule 1, rule 1 comes in, where 2 tests is given under rule 1 subclause A. One, there has to be same series of transaction or similar series of transaction. Second, there has to be similar question of law or fact. First being similar series of transaction is there, same money is going through same defendants through all the various entities, and same question of law would arise in the event the trial is even concluded.
Come to the order. How many plaintiffs are there?
My lady?
How many plaintiffs?
My lady, 28.
Let's read the order.
Yes, ma'am. My lady, similar arguments were made before the trial court as well. That same series of transactions is happening.
How it is? How the court had dealt with it?
My lady, I'll read the conclusion. My lady, para 15 of the impugned order. Para 14 and 15. I have carefully gone through all the above cited decisions wherein observation have been laid by the Honorable.
Para 15.
14. Page number 499.
Yes.
Para 14, I have carefully gone through all the above cited decisions wherein observations have been laid down by the Honorable Apex Court and the Honorable High Courts as regards maintainability of a single suit by different plaintiffs against different defendants wherein multiple cause of action arise. Coming to the present suit, on a careful reading the entire plaint amendments and also the document that has been annexed with the plaint, from the pleadings from the plaintiff, while describing the cause of action for the suit in para 61, pleads that the cause of action has arose on execution of each GDN and NCDs. My lady, what the erroneous part? The cause of action continued to the date on which each payment was made by individual plaintiff and also on the date of non-payment of interest to each of the plaintiffs. The very description of cause of action would clearly indicate that each plaintiff has got a different cause of action against different defendant. While seeking prayer for payments of the money, the plaint government should indicate that plaintiff number 1, my lady, these are the details of which plaintiff is owed by which defendant. My lady, if I come to end of page
The
501.
reliefs claimed are also distinct from each other.
My lady?
Even the reliefs claimed are also
My
distinct from
lady,
each other.
the reliefs are distinct from each other. We are not claiming single relief from a single entity because the transactions have been divided in such a manner.
Right.
My lady, page 501, the last paragraph, all the plaintiffs are not seeking relief against all the defendants, but on the other hand, the prayers as described in the plaint would indicate that each of the plaintiff is seeking payment of different sums of different defendants. It is averred that defendant 1 and 2 and 3 are jointly 1, 2, 3, 5 and 5 are jointly liable to pay a sum of 8,43,990 rupees. To plaintiff number 3, again, the same order goes where each defendant is liable to pay. Para 16 on page 503. From the above arguments, it is amply clear that each of the plaintiff has entered into a separate agreement with separate defendants. Though some of the defendants may be common to the GD and agreements, nevertheless, the claims are made against separate defendants by each of the plaintiffs. As evident from the pleadings, bonds in favor of the plaintiffs are not issued by all the defendants, but separate defendants have issued bonds against separate plaintiffs, under which claim is made for payment of amount accrued as interest. Therefore, it is manifestly clear that each defendant has a separate claim against the respective defendants. All could not have been brought under one
Let's
single.
see the cost item.
My lady, page 5 for the petitioners and page 4, page number 5.
The
These
plaintiff.
These are the plaintiffs, and my lady, the annotation for trial court and high court is written there, so it's identical. It's in the same order.
So where are the defendants?
My lady, page number 14.
Defendants are in number 20.
My lady. Initially, there were 22 defendants, 2 were removed as per.
So now you're relying on order?
Order 1, my lady, for
Let's read.
order 1, rule 1, my lady. Order 1, rule 1, who may be joined as plaintiffs. All persons may be joined in one suit as plaintiffs where A, any right to relief in respect of, comma, or arising out of, comma, the same act or transaction or a series of acts or transaction is alleged to exist in such persons where jointly, severably, or in the alternative, and if such persons brought separate suit, any common question of law or fact would arise. My lady, the first being there is the same series of transactions happening. The investors pay money to the defendant number 1 and 2.
And 2.
And the 2 mean at the end, the defendants in the written statement are also said that there are I'll refer to the blame game that the defendants are undertaken. That is page 73 of the petition. Basically, defendant number 4 has issued the NCDs, the debentures, and defendant number 9 to 13 were transferred, which were subsequently transferred to the plaintiffs. In that, the defendants have blamed each other that we don't hold the NCDs, we have transferred the NCDs to this company, and they have transferred to you. So we have no say in this. That is how they are evading their liability. That there is no cause of action in that sense.
Notice to the respondents. Petition is permitted to take out.
My lady, I also seek an interim state. My lady, the urgency being today, the matter is listed before the. My lady, there are merits there are sufficient merits to disclose that the corporate wheel, if lifted, same set of people are there. Same set of people are handling the transactions.
Does this matter? Petition is permitted to take out hand summons and shall file a memo to that effect. Does this matter on if the memo is filed by, when can you file the memo?
My lady, yesterday, 6/7.
Huh?
6/7, yesterday.
When can you file the memo? By serving the hand summons on the counsel for the respondents?
My lady, by the end of next week.
This is if the memo is filed by 15th, does this matter on 16 July?
My lady, the urgency being the matter is listed before a trial court for dismissal. My lady, if a stay be granted for 2 weeks at the very least, may be heard on merits on the next date. My lady, it's a request, my lady. It's a humble prayer.
Yes.
My lady, the thing being, it's a 9 crore matter. The investment money would be different. The entire purpose of this writ petition would be different.
36 urgent, 37. We are Vishwanath for petitioner.
My lady, if I may make one submission. My lady, this writ petition would become infructuous. The plaintiff is.
I actually want to dismiss it. Because to give you an opportunity, I'm issuing notice. That's why I don't want to stay the proceedings.
My lady, it's humble. My lady, I understand that the law.
I would have dismissed it at a.
But again, my lady, facts and circumstances of the case.
Even if you want this weekend also, I can give, but I cannot grant interim order because I'm not convinced.
My lady.
Much obliged.
They appear for petitioner.
Yes.
My lord, in an execution proceedings, my lord,
Mm.
judgment debtor in pursuance of an order passed in WP, that is annexure A, my lord, 17877 of 2024, a commissioner to
Why do they tag these on the top? Yes.
have challenged an order, my lord, wherein the appointment of the application for cross-examination of a commissioner, my lord, surveyor, was rejected by the executing court, my lord.
Let us see
My lord, the appointment of a commissioner was in pursuance of an order passed by this honorable court in WP 17877 of 2024, my lord. That is at page 17, my lord.
Yes. Now we'll see the impugned order.
Impugned order is at F, my lord. That is the page reasoning is at page 52. It commences, my lord. Only on the reason that, my lord, the decree order is yet about 92 years. The application seek.
Let's see the order.
Yes, my lord. The may read from the reasons, my lord. 52. This application is filed by the JDR under Order 16 Rule 1 Red with Section 151 of CPC, raised to summon the surveyor, court commissioner appointed by this court as he has objections to the commissioner report and seeks permission of this court to cross-examine him in the interest of justice and equity. This court passed an orders on IA under Order 26 Rule 9 CPC on 14/6/2024 by allowing the said IA. Agreed by the same, the DHR challenged the order dated 14/6/24 before Honorable High Court of Karnataka, Bengaluru. Then the Honorable High Court of Karnataka, Bengaluru has remitted back by altering the order of this court. Therefore, on the observations of the Honorable High Court of Karnataka, Bengaluru, this court appointed commissioner and he has filed his report.
Why you want to examine the?
That is, my lord, I request your lordship to kindly peruse the schedule, my lord.
No, your application. Why you want this? Why you
My
want
lord,
to
there are
cross-examine?
certain the direction to locate the property what was encroached by the judgment debtor was to be identified, my lord. So that was the clear direction.
We'll see your application. Why you want?
Yes, my lord. IA, my lord, I have filed it at page 43, 44, the affidavit, my lord. Para 3, my lord. Affidavit, page 44.
Oh, basing on the report, you can submit to the court. You have already filed your objection.
I have filed my objection there, my lord. When once, my lord, it is apparently, my lord, there is totally a deviation from the directions.
But you can demonstrate to the, why should you cross-examine the commissioner now?
That is there, my lord. Your lordship, that's why I request your
You have
lordship.
filed there is earlier order in the suit where with regard to the boundaries and other things, there is a mention. Now the commission is appointed. His record, report is on record. You filed your objections.
Yes, my lord.
Court while passing the
But
order.
my lord,
will
when once
consider
an objection is filed, my lord, the coordinate bench of this honorable court, my lord, gives a right to the applicant to cross-examine the, otherwise, my lord, it will become a part of the record. That's what that has been held in the order, impugned order. Just, my lord, the reason, just I'll substantiate, your lordship may kindly peruse, page 27, my lord. That's the sketch which has been prepared against the directions issued by the Honorable High Court in said WP, under which, my lord, the commissioner.
the judgment. You're relying on some judgment.
Yes, my lord. I'll quote, already it's there on. Adallappa, reported. This I have 24 January 2023. Quoted.
Which case?
My lord, this is WP 201274 of 22. Shadak Sharappa versus Kumar Vijayalakshmi. I have submitted, my lord.
Yes,
Here I
yes.
request your lordship to kindly peruse page 21, my lord.
Yes.
The para 2, I, madam, HI. The court may in its discretion examine the commissioner on any matter
Which
concerned.
page? Page number internal.
Page number 21.
Therefore, the contention of defendant number one, that's how it starts.
No, it's here.
I'm
Well,
looking at
here, page 21. Madam.
paragraph.
Paragraph H high, that is para 20 and subpara H I. Page 21. Madam.
No, there are no subparas.
ಇನ್ನೊಂದು ಕೊಡಿ ಕೊಡಿ.
Yes.
And I
Yes.
The court may in its discretion examine the commissioner on any matter concerning the report. There is no compulsion to examine the commissioner. However, if the objection is filed to the report and the party filing objection seeks to examine the commissioner, then the commissioner should be examined. In either case, once the commissioner is examined, the court, having due regard to the evidence, may reject or accept the report in its entirety or in part, providing there are materials to justify such a finding on the report. In the appropriate case, the merit of the report can be considered at the final hearing. While considering the report at the final hearing, if the court finds that the report is erroneous and fresh commission is required, the court may pass appropriate orders. Here, my lord, the learned judge has presupposed the validity of the report.
Oh, if you
Allah,
look at
your
this
lordship
I-
may kindly peruse.
No, the very same judgment, if you look at I, there are different, the conclusions in this.
My lord, when one's objection is filed,
Huh?
I request to be read with J minutes.
that is, when one's objection is filed, my lord,
So that we will, no, read it again. The court may in its discretion examine the
Yes, my
commissioner
lord.
or
Here-
any matter concerning the report. There is no compulsion to examine the
then
commissioner.
however,
That is one limb. Second, however, if the objection is filed to the report and the party filing objection seeks to examine the commissioner, then the commissioner should be examined. In either case, once the commissioner is examined, the court, having due regard to the evidence, may reject or accept the report in its entirety or in part, provided there are materials to justify such a finding on the report. In appropriate cases, the merit of the report can be considered at the final hearing. While considering the report at the final hearing, if the court finds that the report is erroneous, a fresh commission is required, the court may pass orders.
that's the
Next,
learned
J,
judge's
J,
discretion.
J.
Yes.
If the court is, read it.
The court is dissatisfied with the proceedings of the commissioner as found in order 26 rule 10, it or 3, it may direct further inquiry depending on the facts. As a matter of caution, it is clarified that examination and order under 26 rule 10(3) are only to verify if the commissioner has followed the proper procedure while carrying out his task. The person there, my lord, that's where I'll be in a position to substantiate before this honorable court, my lord. Here,
What the court says is, without cross-examination, it is open to establish that the report is inadmissible in.
that is there further, my lord. When once a right is given, when once I file the objection.
Right is also taken away.
That is, my lord, if it is read in entirety, my lord, there it is indicated that, my lord, when an objection is filed to the commissioner's report.
We should read it in entirety. which is
Entirety,
favorable to
that's there, my lord. There, the other options, suppose if objections are not filed, when an application is not filed seeking the cross-examination.
Consider your objections, not necessary to appoint.
One submission, my lord. Here, I request your lordship to kindly peruse the perversity in the report, which requires cross-examination, my lord. For the simple reason, I request your lordship to kindly peruse page 45. This is a sketch.
We will see your objections. What are your objections? Let's see.
Objections I have
Objections to the
filed.
report, which cannot be considered by the court without examining the commissioner. Where is that?
I have judgment surveyor commissioner's report at page annexure D, my lord, page 40.
On the judgment letter, please
Yes,
read
my
that
lord.
at page 40.
Say para 2, it commences, my lord.
What do you say?
Not insofar as the objection which has been filed. The learned trial judge, while passing the impugned order, I would request the Honorable Court to kindly come down to page number 48, ink page number 48. The learned trial judge has observed all these objections which has been taken by the petitioner, who is the judgment aptar, had taken these stands in the original side in the OS. And that has been answered by the learned trial judge on the original side in OS number at paras number 1214. That is the last page of the impugned order. Last page of the impugned order. All these contentions which has been raised by the petitioner in the statement of objections to the commissioner report, the learned trial judge goes to the factum that all these agitations were made by the judgment aptar in the original side being a defendant, saying that the property is not in existence. The trial court, having observed that the property is in existence, having recorded a finding at para number 12, 14, 15, 17, 20 and 21 of the judgment in OS number 677 of 2009, has come to a conclusion that there is no property of the defendant which is in existence, which they want to prove it by virtue of they have filed another suit for declaration.
Why the court commissioner is appointed?
Well, at their instance, the court commissioner was appointed.
For what? For what purpose?
For the purpose of identifying only the B schedule property which is in the possession of the judgment aptar. This Honorable Court, while passing the writ order on an earlier occasion, annexure A for a moment, page number 11. Page number 15.
The judgment debtors cannot be allowed to perpetually deny the benefit of the decree.
Page number 16, para number 5, my lords. Page number 16, para number 5. The suit for declaration and recovery of possession of B schedule property. The B schedule property is part of A schedule property. The B schedule property lies on the eastern side of A schedule property. Therefore, there cannot be any difficulty to identify the limits of B schedule property. The judgment aptar, instead of seeking appointment of a commissioner to measure and demarcate the B schedule property, has sought for measurement of A schedule property and B schedule properties and properties of his predecessors so as to identify the B schedule property. This is invariably an attempt by the judgment aptars to re-agitate the settled questions of fact and law, and designed to protract the execution of decree and to hand over possession of the B schedule property. Therefore, the judgment aptars cannot be allowed to perpetually deny the benefit of the decree to the decree holder. I've seen that. Having regard to the conflict between the judgment aptars and the decree holder, it is appropriate to modify the impugned order by directing the appointment of a commissioner so as to measure B schedule property from the remaining portion of the A schedule property and identify the limits of B schedule property and hand over the possession of the B schedule property to the decree holder. This would meet the ends of justice, also ensure.
I've seen that. I've read that.
So therefore, the order of this Honorable Court was very clear, because they did not object on the original side the existence of the A schedule property. They also said that I am in possession of the B schedule property on the original side, which was confirmed by this Honorable Court in the RFA and taken up in the form of a civil appeal, which was confirmed. So therefore, having regard to the order of this Honorable Court on the writ side, the commissioner was appointed for the purpose of demarcating only the B schedule property, measuring it from the A schedule property. Now, pursuant to the decree which has taken place, now he is before the very same court seeking a declaration saying that my property is in existence towards the east of the property of the plaintiff decree holder. So therefore, he wants to approbate and reprobate and say that his land is still in existence because in order to help his declaration suit which has been filed in the year 2020-24. So therefore, taking note of all these consequences, the learned trial judge has held that the contention which has been raised by the other side has been already adjudicated on the original side. All these objections was the very same defense which was opened by him in the original side. And that has been adjudicated at para number 12, 14, 15 of the judgment. Yes. That judgment is also there on board. That may be taken into consideration for a moment. The OS judgment is placed, Manoj. OS number 677 of 2009.
Which paragraph?
Para number 13, internal page number 13, my lords. This is the defense of the defendant who is the petitioner before this court. Page 13, para 13. Now turning to the defense version, I hope my lordships have got it. Let me examine whether there is any substance in the contention of the defendant number 1. At the inception itself, I would remind that he has not stepped into the witness box nor sent any other person by authorizing him to depose on his behalf. Thus, in the absence of any oral or documentary evidence on his part and his failure to face the cross-exam, the court has to evaluate and find out whether there is any force in his unproved version. It is not his case that any portion of the property alienated to the plaintiff was acquired either by the BDA or by MSEB. According to him, only portion fell to the share of Narayanappa in survey number 3 and part of his share that survey number were acquired by the BDA for formation of 80 feet road, and he is left with a piece of land measuring east to west 20 feet and north to south 65 feet. This is his contention, my lords. He says that his property was acquired by the BDA, but he is left over with an area measuring 20 feet into 65 feet. Now with this, he is before the court in OS number 1258 of 2024, filing an independent suit after the judgment and decree has been confirmed, stating that he is left with an area of 1,485 square feet even after acquisition. That is why he wants to cross-examine the witness. And he has constructed a row shops, and there is in its possession. Pleadings to this effect can be seen in para number 1 of the written statement at page number 2. Here it is a material to note that he has not precisely pleaded out of east to west 100 feet and north to south 65 feet that was allotted to him in the survey number how much was acquired by the BDA. Let alone coming up with such precise pleading, he is not bothered to produce even a piece of paper to show how much of his land was acquired by the BDA. When it is not his case that the plaintiff's land was acquired by the BDA or MSEB, and when no evidence is produced to show such acquisition of her property, and instead there is an evidence to show that what extent of land she purchased under Exhibit P2, if at all it was his contention that he has left with 20 into 65 feet in his piece of land, it was obligatory on his part to come up with the corroborating oral and documentary evidence to substantiate his plea. At least in the cross-examination of PW1, he should have suggested how much of his land was acquired. Therefore, his contention that after acquisition of some portion of his land, he was left with 20 into 65 feet in survey number 3 cannot be trusted. In para number 2 of his written statement, he further contended that after partition amongst himself and his brothers, portion measuring east to west 30 feet and north to south 62 feet was given to the plaintiff by way of gift to her. But due to the inadvertency of the deed writer, the said measurement was wrongly shown in the alleged sale deed. According to him, it is not a sale deed. In fact, it is a gift made by the brothers. He was gone to the extent of contending that since the plaintiff was unmarried and illiterate, it can hardly be presumed that she could not have purchased the suit property from her brothers. He has also pleaded that towards east of the plaintiff's property, there is a footpath as on the date of his written statement, and there is no further property to the plaintiff. It is interesting that when he made so many grounds attacking on questioning the genuinity of Exhibit P2, he forgot on one thing to mention as to what was the age of the plaintiff when the sale deed was executed in her favor on 29/3/1973.
Yes.
So as to ascertain. So
May I make
para
mention?
number 20, my lords, in conclusion.
These contentions were all considered in WOP while directing the appointment of a commissioner. Just I request your lordship to kindly peruse page 20, my lord.
No, how many times you will take
No,
the same
no,
objection?
here, that's where, my lord, I am not seeking any review of the judgments passed earlier and all these things, my
You cannot
lord.
because
Only
it's
thing,
already
only thing, my lord, I just wanted to submit, my lord, page 20, my lord. This is the schedule given by them seeking the possession of the encroached area. That is page 20, my lord.
Yes.
Here, my lord, all that piece and parcel of land bearing survey number 3, Katraguppa village, Bangalore
This is
South
a
Taluk.
scheduled property.
This is the suit scheduled property, my lord. It was it was in the middle of city limits, my lord, when the suit was filed. No kata was filed. The identity of the property itself was in dispute. There also, my lord, on the eastern side, your lordship may kindly peruse, eastern boundary, east by property belonging to Venkateswamy, father of JDR. West by remaining piece of belonging to decree holder. North by property belonging to MSEB. South by road. This is the piece of land, my lord, in respect of which the decree holder is seeking the possession. Here your lordship may kindly peruse south by road. This was, my lord, the Honorable High Court directed to locate this property as per this schedule. Your lordship may kindly peruse page 27, my lord. This is the report sketch given by the surveyor. There, my lord, he locates this portion, that is ABDE, to be the property, my lord, to be given possession to the decree holder. Where is the schedule matching, my lord? It's on the south, my lord, quite obviously as claimed in the execution petition. On the southern side, road should have been existing. Here, as per this, my lord, on the northeast side of the property, my lord, road is being shown. Entire topography, there is a change, my lord. That's why a surveyor who has gone there without adhering to the sketch and suit schedule is trying to locate the property, creating a dent into my property which has been left over after the acquisition. That's all, my lord. My submission, lordship, may kindly peruse the sketch prepared by the commissioner, whether it is in accordance with the schedule pleaded in the execution petition or in respect of which the decree is granted. So that's,
Where is the road as per this?
that is on the southern side as per the schedule they are seeking. As per the sketch prepared by the surveyor, my lord, it is coming on the northeastern side.
No, my lord.
So
As per
it's,
the report-
sketch
as per
is
the
before the
sketch
honorable court. This
prepared by
is
the
the survey.
he
If they are
does
disowning
say-
the sketch, my lord,
It does say in the legend, which has been demarcated below, the property which has been shown with C, D, E, and F is the A schedule property, my lords. That is what he identifies. That is what he has written in
DEF.
C, D, E, and F is A schedule property, for which they have no objection. It is also in the it is also contended by them that they have no objection in the original side that it belongs to me. The only dispute is in with respect to the schedule which is marked as A, B, C, F. That is the B schedule property.
on the southern side,
Now
where
he
is
has
the
been
road?
squatting over this property from the year 1980, and he has leased out this premises in favor of subsequent lessees, and he is earning out rents in respect of that. Now he doesn't want to leave this premises.
No.
That is my.
As it is submitted by him, as per the map, as per the suit schedule, there is a road on the south
Yes,
side.
my lord, this is the south, this is the road.
No sketch.
That is what the surveyor has
Known
demarcated.
as Rasta in. It
The
is not-
southern
it-
portion is the road. This is north.
That's the north side, not the.
This is the
southern.
north. That is what he has demarcated, even in the legend.
Where he mentioned about the directions.
This is north, my lord. This is the direction.
No, direction is shown, my lord, north. Southern side road
Serial
should have
number-
been there,
in serial
but
number
he
four.
shows the road on the northeast side.
Serial
That's
number
where, my
4.
lord, a small portion which is left over after acquisition, my lord, that is in my possession. That's where I have constructed the building. That is to be, my lord, if at all he was to put the possession of this particular scheduled property based on the sketches, survey sketch, map and all these things, my lord, quite obviously on the southern side, there should have been a road. What they have claimed in the schedule is otherwise what is located. Now, if he rather demolishes my property, my lord, which is not on the southern
No, my
side,
lord,
I will be put to
at best I
irreparable.
can say-
Let him be cross. That is
his
there, my
claim.
lord, I am seeking.
It is his claim that he is in on the eastern portion. At best,
Allah, our
At
schedule,
best,
your lordship may kindly at page 20, categorically they say that, my lord, on the southern side, there is a road. When the sketch that is prepared by the commissioner shows otherwise, quite obviously, my lord, I have got a right to cross-examine him to ascertain. I am ready to hand over the possession, my lord. That should be in accordance with the claim made in the suit as well as the execution petition. It cannot be otherwise, my lord. That's where, my lord, when once my property is situated on the eastern side, which is indicated as per the schedule, my lord.
Agreed with the orders passed.
my lords, at best, this is the portion which has been demarcated for handing over of the possession. Even as per the argument which has been canvassed by them, this is onto the west of A schedule property. A schedule property, there is no dispute.
A scheduled property, is it delivered?
It is in my possession, my lords. Onto the east, he claimed that
That's what,
this
no,
property
the
is there.
dispute is with that.
Insofar as this area, my lords, even as per his contention, it at best it could be this area. Now I am before the executing court seeking possession of this area.
Property, yes.
That can be delivered. That can be delivered. Over which he doesn't have a claim.
No,
Because
that's
insofar as
already in
this
their
area is
possession.
concerned-
Encroached portion, which is the encroached portion
As far
that
as
has.
this area is concerned, he is already independently before before the trial court in a
Petition
different suit.
number 112 of 2024. I number 1 of 26. In execution petition number so and so by the principal
Double one
city
two.
civil and session judge dated 26/2/2026. The judgment debtor is before this court. The respondent herein has filed the execution petition seeking execution of the judgment and decree which has attained finality. Suit is for declaration.
Declaration in possession, recovery of possession.
Declaration and recovery of possession. Earlier, when the petitioners filed an application for appointment of commissioner, when that came to be dismissed, petitioner has come before the court.
No, no,
And
that came to be allowed.
that came
Fully
to
it
be
was
allowed.
I was before the writ.
Then against that, a writ petition is filed and it is confirmed.
No, it was modified.
In the writ petition, the order is modified, whereby the court had directed appointment of a commissioner so as to measure B schedule property from the remaining portion of A schedule property and identify the limits of B schedule property and hand over the possession to the decree holder. The court decree holder subsequent thereto the commissioner was appointed and he has filed the report. The petitioner herein has filed his objections to the report. It is a grievance that the surveyor, instead of measuring and reporting the actual measurement boundaries and topography of the scheduled property, has simply superimposed a scheduled property at the behest of the decree holder. It is the case that the survey is not in existence with the actual, is not in accordance with the actual existence of the properties. The surveyor has assumed the existence of A and B scheduled properties and has not correctly recorded the existence of the properties. It is further stated that on the eastern side of the A scheduled property, no property exists other than the road. The same has not been mentioned in the sketch. The road shown on the southern side has no existence. The newly formed road by the VDA is in existence. It is stated that non-mentioning of the road found by the BDA in the sketch amounts to improper depiction of the topography. It is stated that the survey is based on the assumption of the existence of Schedule B property on the eastern side of the Schedule A property, which is being seriously disputed. It is stated that the road is not running on the southern side of the scheduled property or survey number 3, which is running on the northeastern side as per the sketch. It is the case of the judgment debtor that survey is not in accordance with the law and norms. Hence, he wanted to cross-examine the surveyor. That application came to be dismissed by order impaired. The court, while dismissing the application, has observed that since this is an execution petition and already the things are adjudicated, there are no grounds to allow the IA. The observation made by the court in para number 12, 14, 15, 17, 20, 21 of the judgment invoice number 677 or 2009. Therefore, court being the executing court cannot go beyond the decree. The JDR on which point he is seeking for summoning the commissioner was already observed in the judgment and decree. DHR is aged 89 years and the decrees of the year 2009. Therefore, no sufficient grounds are made out by the JDR and accordingly dismiss the petition. When counsel for the petitioner submits that the court only on the ground that the JDR is aged and the suit, it is discussed, it is decided on the ground that it is decided in the suit, has dismissed the application. He relied on the judgment of a coordinate bench of this court in WP number 201274 of 2022, dated 24th January 2023. He relied on paragraph number
20, my lord.
23.
HIJ.
Only paragraph number 23.
Para number 20 HIJ.
Paragraph number?
20 HIJ. Page number 21.
He relied on paragraph number 20. HIJ. Relying on this, it is submitted that when he is disputing the commissioner report, he has every right to cross-examine him. Then counsel appearing for the respondent submits that the court has rightly held that all these issues with what the petitioner is raising before the court are already decided in the suit, and the executing court cannot go beyond the decree. It is submitted that only for the purpose of dragging on the proceedings, the petitioner is coming up with one application or the other. It is submitted that he has already filed the objections to the commissioner report, and the court will be considering the same while passing the order. It is submitted that there is no necessity to cross-examine the commissioner, and the court has rightly dismissed the application, having heard the counsels on either side. There is a material on record. The judgment and decree has attained finality, and the findings of the trial court are affirmed by the apex court. In the execution petition, the petitioner has sought for appointment of an advocate commissioner. The commissioner is appointed, and the petitioner has drawn the attention of the court to the sketch and the report of the commissioner. He has pointed out the discrepancy in the commissioner report with regard to the boundaries. As per the sketch that is furnished, the road is on the southern side. When it comes to the sketch that is placed by the commissioner, there is a road on the northeastern side.
That cannot be meant. That cannot be. He's trying
That's
to.
my
interpret.
submission.
Serial number 4 may be taken into consideration for a moment. The commissioner says on the south it is road. Within the sketch itself, he has identified it.
It is submitted that there is a road on the southern side, and the topography of the topography was not properly appreciated by the surveyor, and as such, at this it is necessary to cross-examine the surveyor. Then counsel appearing for the recording the contingency. Then counsel for the respondent has drawn the attention of the court to the report wherein it is mentioned that the road is on the. Then how are you saying that when it is when the
No, my
report
lord,
is
it's
clear?
not there. It is the sketch.
we
He is
should not go
submitting.
by the sketch,
When
my
once, my lord, if it is road, he would have drawn a sketch accordingly.
Was it?
My lords, we would have to read the serial number 4 and 5.
What
The
did he
sketch should
say?
not be taken into consideration.
How, my lord, the
Serial
sketch
number
was
4 and
supposed,
5.
he says that, my lord, as per the schedule, road is there. But he has not drawn the
As
road.
per the schedule.
How
not
can
as
it,
per the
then, my
schedule.
lord, how he has located the
As per the
property?
existence at the spot.
He has drawn the sketch.
Sketch.
As per the
No,
topography, he
and
has drawn the sketch.
whatever the below
topography.
points are there, they must be as per the sketch.
Let's he has answered each and every point relating to the sketch.
That
Where
is-
the property
that is contrary
what
to
is
his
onto
own
the
sketch.
east, What is onto the
Sketch
north?
on the sketch is showing northeast road.
No, my lords, we would have to place the sketch as this. Because the topography of the road runs like this.
He has mentioned the road, the directions. Look at the direction.
He has done so in the serial number 4 of the sketch explanations given to the sketch. That requires to be taken into consideration. The sketch would have to be taken into consideration with respect to point number 4, 5 and 6. That is where he demarcates what are the boundaries to the schedule. Now they are misdirecting this honorable court with respect to the direction and the sketch. That should not be gone into. The explanations which are there within point number
According
4
to
and
you,
5, 6.
he will draw something and he will give a,
No, my lords, he has done it very perfectly to the effect that the north is on BCDE. BCD. That is north. That is geographic north. The south is AFE.
What is that north? He is showing something not there. Not,
This is north, my lords.
below.
This is north. Even otherwise, this is south. Even if you go by this is south. If you take the northern like this.
Let
as
the
he has shown.
commissioner be cross-examined. Then council submits that. The same is when the sketch that the road is existing on the southern side. In the light of the submissions made by both the parties, and particularly the submission of the land council for the petitioner, that the survey is not conducted as per the sketch, and in the light of the sketch that is placed before the board, and the note below the said this thing, there appears to be some confusion which can be clarified by cross-examining the commissioner in the facts and circumstances. This court is of the view that the cross-examination of the surveyor is very much necessary in the facts and circumstances of the case. The petitioner shall conduct the cross-examination on when is it coming up?
Tomorrow, madam.
Tomorrow it is not
Summons
possible.
has to go to the
Summons has
commissioner.
to go.
The petitioner.
Without any further adjournments, let
The
them.
petitioner shall cross-examine the commissioner, and petitioner shall not seek unnecessary adjournments and shall proceed with the matter. Accordingly, the petition is allowed
Cell number 38.
by setting aside the order dated so and so. Consequently, so and so is allowed. Yes.
38. Ganapati Bhatt.
Respond, 2 days time may be granted, madam.
For what?
Senior is held up in.
Oh, you said so the other day, that you have informed to the other side and other side has not. Is it the matter?
No, no, madam. No, that is not.
This is not the matter.
This is not the matter.
This is not the one.
This is not the matter.
Mr. R.V. Nayak had done that.
Anyhow, there is no interim order in this. We'll adjourn it. This is matter in the month of September
Cell number 39.
at the request of land council, the petitioner.
39. So Padmavati.
Yes.
For response.
What is this?
My lord, yesterday's matter for the commercial courts matter. My lord.
Take that.
I'm producing some citations, my lord. My lord, regarding the question has posed on the last day, my lord. What happened, the matter which was pending before the civil court, the days which was what happened?
So what is this issue?
This is my lord, I'm appearing for the Oriental Insurance Company, my lord. I was the defendant before the trial court, and I filed the writ petition before this honorable court challenging the order
You're
passed
saying
under.
that the date of transfer.
Yes, my lord. Yes, my lord. 120 days, 120 days.
Let's see.
I filed my written statement, my lord, before the commercial court.
Here, in your case, the facts are, your right to file the written statement is forfeited long back.
Long back, my lord. I have not filed the recalling application before the civil court, my lord.
When was your right to forfeit to file the written statement was forfeited?
My lords,
Order
if I
dated?
may, 9/9/2024, my lords.
9/9/2024.
Yes, my
When
lords.
was this transfer?
This transfer happened on 26/2025. Order was, but
24/6/2025, my lord.
apology.
It was registered before the commercial.
Commercial.
Yes. Now please come to these judgments which you are relying on.
Decisions, my lord.
No, you're relying on some judgments.
Yes, my lord. I am relying on the decision. The first judgment, my lord, where, my lord, my lords may kindly see the page number 12, ink page number 12, my lord. Admittedly, IA number 1 of 2019 seeking the leave to file the written statement.
Para number?
Para number 10, my lord, page number 12, ink page 12, my lord. Admittedly, IA number 1 of 2019 seeking a leave to file the written statement is filed within 120 days from the date of listing the suit on a transfer before the commercial court, which date is to be taken as the date of services of the suit of summonses in a commercial court. In terms of the above extracted proviso, learned commercial court judge has discretion to allow the defendants to file the written statement within a 120 days from the date of services of summons. On the next page, my lord, in the instant case on 19/2/2019, the date on which the first listing suit was transferred to the commercial court is to be taken into the date for the services of suit summonses. From 19/2/2019, the petitioner and but defendant had a maximum of 120 days time to file the return statement. My lord, what section 15 subclause 4 says of the commercial codes is explanation. Section 16, section 15 subclause 4 proviso to subsection 4 of the section 15 of the 2015 Act reads as follows. Commercial division or a commercial court, as the case may be, holds a case and management hearing in respect of such transfer, the suit or application in order to prescribe the new timelines or issue further directions as may be necessary for a speedy and efficacious disposal of such a suit or application in accordance with the Order 25A of the Code of Civil Procedure, provided proviso of Sub-Rule 1, Sub-Rule 1, Rule 1, Order 5 of the Code of Civil Procedure Code 1908 shall not apply such transferred suit or application. The court may in its discretion prescribe the new time period within which the written statement shall be filed. In the above proviso makes it abundantly clear that the Sub-Rule 1, Rule 1, Order 5 of the CPC would not apply to the transferred suit or application to the commercial court. Commercial courts in its discretionally shall prescribe the new time period within which the written statement shall be filed. Commercial court failed to follow the mandate provision of subsection 4, section 15 of the Commercial Courts Act, my lord. Proviso Sub-Rule 1, Rule 1, Order 5 of the CPC, which prescribe the timeline for filing the written statement, would not apply to the commercial suits transferred from the normal civil court to commercial court in terms of the proviso subsection 4, section 15 of the 2015 Act. This amendment proviso, Order 8, Rule 1 of the CPC, insofar as the Commercial Courts Act is concerned. Now, my lord, it
No,
provides the
you have to
discretion.
tell the court what would happen to the earlier order. That I want to know.
My lord, earlier order, there was a taken as nil, my lord. In the meanwhile, my written statement was ready, my lord. In the meanwhile, it was transferred to the commercial court, my lord. I filed application along with the written statement, my lord, before the commercial courts for the receipt of the notices within 25 days, my lord. And also, my lord, from the date of the first hearing of the commercial court within 106 days, my lord.
There is some order passed before transfer.
Yes, my lord.
After transfer, what would happen to that order? What would happen to the earlier order passed by the civil court?
My lord, that only, my lord, Order 5.
All these judgments, what you have relied upon.
Yes, my lord.
They say that in those cases, notice is served to the defendant. After the transfer,
Yes,
he
my
has
lord.
filed under in the
In-
light of the proviso, they said so.
Yes, my
No,
lord.
in your case, your
In-
right to file the,
In all these cases, whichever I relying, my lord, the right was forfeited before the civil court, my lord. I'm relying on those judgments also.
which order?
My lord, the Supreme Court judgment, my lord,
Page number?
page number 44, my lord.
No, that is not Supreme Court judgment.
This is
Yes,
the,
yes,
yes, my lord, this is Supreme. Page number 45, my lord, and paragraph number 11, my lord. In other words, the time that was available if the strict interpretation is given to the oversight provisions was nothing because time of 120 days had expired even when the matter was pending before the normal civil court, my lord. The reliance is placed by the High Court on the judgment of this court, SCG contract so-and-so, private limit so-and-so. In support of the contention, the timeline prescribed under the second proviso of Sub-Rule 1, Rule 1, Order 5 of the CPC is a mandatory, and that appellants have forfeited their rights to file the written statement. Next, madam. But we do not agree that the suit, the become a subject matter of the dispute in SC. Yes, my lord.
My lords, if I may, my lords. My lords, in the all the judgments that I have cited, my lords, the facts of the cases are completely different to what has happened in the present case, my lords. Here, my lords, on they came on record on 27/6/2024, and the written statement was taken as nil in 9/9/2024. And on 27/2/2025, I had filed for the transfer of the case. So, my lords, in from 9/9/2024 to 27/2/2025, they have not filed any recall applications. And moreover, they participated and filed the objections in that for the memo that I had filed for the transfer of the case. They were well aware of the fact that the case is going to be transferred, my lords. Meanwhile, when the case was registered on 21/7/2025, um, the the matter was continued from the stage where it was left out. In the OS case, it was left out for the stage of chief examination of PW1, my lords. And when it was transferred, again the same stage was continued. I had completed my chief examination and they appeared, they came on record, they appeared, and when they sought time for cross examination, then the court observed that you have not filed the written statement, then your seeking time is not unreasonable. So then they came to know that they have to file the written statement, my lords. Upon that, they have filed the written statement, my lords. If the timeline is to be considered, my lords, 9/9/2024 till the date of the this order, my lords, the trial court order, it has been lapse of 18 months, my lords. And moreover, in their application, they have not stated on what reasons they are recalling that order. Simply, they have stated that we have not received the certified copies. That is not a reason, my lords.
Heard result. Signature.
Lord, Your Lordship kindly, one submission, my lord. Serial number 77.
Every day I cannot repeat to the advocates that I will not hear any mentions at 1:30.
Lord, it's not question of mentioning, my lord. It's a matter where senior citizens is involved, may be taken up on priority basis.
So not taken, why you have not mentioned in the morning?
Madam, I was on my legs in other courts.
Your problem, not the court's problem.
My lord, you should kindly appreciate this situation. It's a senior citizens case.
ನಿಮ್ಮ ಹೆಸರು ಕೊಡಿ ಸರ್. ಮೇಡಮ್
Reserve.
ಅದೇ ಫಸ್ಟ್
ಏಟ್ ಅರ್ಜೆಂಟ್ ಆಯ್ತು ಸರ್. ಅಲ್ಲ ಅದು ಫೈಲ್ ಕಳ್ಸಿಬಿಟ್ಟಿದೀವಿ ನಾವು. ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಇದೆಯಾ ಅದ್ರಲ್ಲಿ?
ಇದೆಯಾ ನೀವು ಕಲಿತದೆ TH ತೊಳಿ.
ನೀವು ಬೆಳಗ್ಗೆ ಹೇಳಿಲ್ಲ ಅದನ್ನ.
ಮೇಡಮ್ ಕಂಟಿನ್ಯೂಷನ್ ತಗೊಂತೀರಾ ಇಲ್ಲ ಅಂದ್ರೆ ಲಿಸ್ಟ್ ತಗೊಂತೀರಾ ಮೇಡಮ್?
ಮತ್ತೆ ನಿಮ್ದು ರಿಪೋರ್ಟ್ ಮಾಡಕ್ ಆಗ್ತದೆ.
ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಮಾರ್ನಿಂಗ್ ಅರ್ಜೆಂಟ್ ಆಗಿದೆ ನೋಡಿ. ಅದರಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ ರಿಸರ್ವ್ ಎಂಟಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ ಎಷ್ಟೊಂದು ಇದೆಯಲ್ಲ, ಅದು ಯಾವ್ದೆಲ್ಲ ಎಂಟ್ರಿ ಮಾಡಿ ಯಾವ್ದು ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಒಂದರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ ನೋಡ್ಬಿಟ್ಟು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ರೀಚಾರ್ಜ್ ಎಲ್ಲ ಇದೆ, ಡೇಟ್ ಹೋಗುತ್ತದೆಲ್ಲ. ಲಿಸ್ಟ್ 2 ಎಲ್ಲಿ ತಗೋತಾರೆ ಇವ್ರೆ? ಒಂದೇ ಕಂಟಿನ್ಯೂ ಕ್ರೋನಾಲಜಿ ಇಲ್ಲಿ. ಲಿಸ್ಟ್ 1 ಮುಗಿದ್ರೆ ಲಿಸ್ಟ್ 2 ಯಾವತ್ತಿತ್ತು ಮ್ಯಾಟರು? ರಿಸರ್ವ್ಡ್ ಅಷ್ಟೇ. ರಿಸರ್ವ್ ಆಗೋಯ್ತಲ್ಲ. ನಾಳೆ ಯಾವಾಗಾದ್ರೂ ಅಥವಾ ಮಧ್ಯಾಹ್ನ ಹೇಳಿ, ಎದ್ದೇಳುವಾಗ ಹೇಳಿ. ರಿಸರ್ವ್ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ
ನೋಡಿ, ಸುಮ್ಮನೆ ಜಾಸ್ತಿ ಕಂಟೆಸ್ಟ್ ಮಾಡಿದ್ರೆ ನಮ್ಗೆ ನಮ್ಮ ಕಂಪ್ನಿಯವ್ರು ನಾವೇನ್ ಕೈ ಇರುತ್ತೆ.
ಬಡ ರೆಡಿ ಇದೆ ಬಡ ಕ್ರಾಸ್ ಮಾಡ್ಕೊಂಡು
ಅಲ್ಲ ಮೇಡಮ್ ನೀವೇ ಕ್ರಾಸ್ ರೀಕಾಲ್ ಎಲ್ಲ ಹಾಕ್ಬಿಟ್ಟು ನೀವೇ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ
ಡ್ರಾಫ್ಟ್ ಎಸ್ವಿ ಅಲ್ಲ
Madam? This is utter negligence, madam.
Court officer, madam?
Sir, 91, that probability of reaching the cases we can't tell, sir. If it is not reached today, then every day the list one will be repeated as it is. The remaining cases, whatever left in the list number one will be repeated.
Court officer, madam?
ಪಾಸ್ ಓವರ್ ಒಂದೇ ಇರೋದು. ಇದು 230 ಮೆನ್ಷನ್ಡ್ ಪಾಸ್ ಓವರ್. ಸೀರಿಯಲ್ ನಂಬರ್ 9 ಇಲ್ಲ. 9 ಎಚ್ ವಿ ದೇವರಾಜು ಸರ್. ಹಾ 153, 55 ಅರ್ಜೆನ್ಸಿ ಮೆನ್ಷನ್ ಮ್ಯಾಟರ್ ಜೊತೆ.
Continue the list. Continue the list.
List number 1, serial number 40. Ready?
Appearing for respondent. Appearing for respondent, my lord.
Okay, Devanand.
My lord, in this case, my lord, before my land friend comments the arguments, my lord, my land friend, writ petition is filed without referring to the documents, my lord, without there being records, because he has filed application for referring the signature for handwriting expert, my lord. That documents, exhibits which are marked, which has to be referred, my lord, those documents are not produced. I myself, I'll produce and along with translated copy, my lord, but I should kindly accommodate 2 days time, my lord. Monday or Tuesday.
Well, if my friend think that I am guilty of some suppression, let him expose me. Let him expose me.
What he is saying is, all the documents that are there
No,
before the trial court
it's
are not
okay.
filed. If filed, you say if they are filed, it's
Plain
fine.
written statement, IA objections and all that, those documents are the ones which are
Are
required to
all
be
the
gone
documents
into.
that are relied on by you and by the court while passing the order, are
Very
they
well,
before
very
the
well,
court?
very well,
Yes,
very well.
this
Let him.
matter after 2 years.
Can I know the date, my lord? Can I know the date?
To list this matter on 13th.
Obliged.
Serial number 41. Serial number 41.
For petitioner in
Petitioner.
furnishing the translated copy of the relevant portions.
Exact. What is the IA?
So IA filed by the respondent 1 and 2 under order 1 rule 10-2 for deletion of the petitioner from the FDP proceedings, please. At page number A.
Let us see the
91.
application that's filed.
The annexure A is the impugned order, translation is filed, my lord. And thereafter compromise petitions entered between the petitioner and the respondent number 1 and 2.
Now you have filed an IA to delete.
Please,
delete
IA
this
is in English, my lord. Page number 91.
Let us read
Annexure
this.
L.
Let us read that first.
Please. Page number 91. 91 is the objections. And IA is annexure K, page 89, my lord. Affidavit is the page number 90. That is application under order 1 rule 10-2 of CPC read with 150. May I read? Page number 89, my lord. Annexure K.
You are not a necessary party to the final decree proceedings.
Please, my lord.
According to you, you are not you are not.
No,
a
I was a
necessary-
party in the original suit and RA filed by the some of the defendants against the judgment and decree. And all the proceedings, I was a party, but I was not represented, my lord. I was not, I filed a wakalat and I not filed any objections. On that context only, the trial court has dismissed my application, negate my objections. My objections, lordship may kindly say.
Come to the impugned order.
Impugned order, my lord. Objections may kindly, page number 91.
Let me look at the impugned order first.
Please, my lord.
Yes.
The respondents have entered into compromise, my lord. Compromise by petition has been filed in the year 2018 itself, my lord. They have also paid a sum of rupees 50,000 out of the said compromise, my lord.
No, what
That
is-
issue has not been raised before the.
What is the share allotted to this fourth respondent?
Please, my lord.
What is the share allotted to the fourth respondent in the FTP proceedings?
No, he was a purchaser, my lord. Before filing the suit itself, he has purchased item number 3 of the scheduled property in the year 1999, my lord. In the 2000 suit has
Document and agree as far as the fourth respondent is concerned.
came to be dismissed against the respondent.
So what he'll do in the final decree proceedings?
So, Your Lordship may kindly see, after that, my lord, they have entered into compromise, my lord. Compromise petition has been filed and they have agreed for, Your Lordship may kindly see, annexure F and G, my lord. I produce page number 10. Translated copy.
This is a petition filed by you. Where is the order?
No. So far, no order has been passed against this compromise petition. Since from 2018, compromise petition is still pending consideration before the trial court. And they have received the sum of 50,000 out of 4 lakhs. You should may kindly see the page number 12 in the compromise petition conditions. Para number 5 and 6, my lord. Page number 12, para 5.
Where is this, the original document of this, which is in Kannada?
It is in Kannada, my lord. I
Where is
produce
the page
annexure
number?
F and G, my lord.
Page number?
Page number, my lord. 80, my lord. 80. Annexure F is the memo.
What is
And-
the name of this, the fourth respondent?
Fourth, Mallesh, my lord. F,
Get his signature in the compromise memo.
page number, annexure G, page 81, maybe kindly see, wherein
Yes, that's what I'm
all the
asking.
parties are been signed. Page number 81, annexure G, in the last, my lord, all the parties have been signed.
Where is Malish?
Mallesh is a page number 85, last, my lord. Page number 85 in last. Mallesh.
Yes, what do you say?
Lord, this respondent has volunteered his appearance before the issuance of the notice, my lord. Lord, he has lost a case in the suit, my lord. Lord, his application for impleading has been rejected. That has not been questioned. That has been questioned in the miscellaneous appeal, my lord. Even miscellaneous appeal is also rejected. Lord, some of the other defendants who had preferred the first appeal, my lord, that has been allowed. Lord, they have come on record. Lord, in the FDP, my lord, he doesn't have any say in the matter. Insofar as the compromise and everything, my lord, that has not been brought to the notice, my lord, in the FDP.
But the compromise petition is pending
No,
in the
no.
FDP proceedings.
No, my lord. His presence is not itself is not there in the FDP proceedings, my lord. In the
No,
FDP
no, forget about
proceedings,
the presence of fourth respondent. About this, the document, they filed an IA.
that document has not been filed in the FDP. There is no whisper of that document in the order impugned, my lord.
And let us see in his application, where did he say so about
Please.
this? Page number
Please.
90, he said some. Like, please come to your affidavit at page 90. Where did you say about this?
Page number 92, my lord.
Yes.
In my objection statement, page number 92, I have stated, my lord.
Please point out which paragraph.
So, under the circumstance, the petitioner is not at all entitled.
With regard to compromise.
Page number 92, my lord. Page number 92.
Yes.
Second. There are no bona fide reasons to believe the relief person. As point of fact, on 6/7/2018, the petitioner responded to 7 to 8 have also filed compromise
Yes.
petition under 2023.
But that has not been.
If the court has not considered it, all the more reason that this order has to be set aside. You have taken money in respect to, and some compromise
Lord.
is entered between the parties.
No, my lord. May I submit this, my lord? Now I have entered appearance, my lord. Let him serve the copy. I'll file my defense. I mean, I will put forth my defense.
He has not caveated, my lord.
Yes, I was there before the trial court, my lord. Insofar as writ petition is concerned,
He has
what
not a
contention he has
caveator.
taken, I do not know, my lord.
He is not a
Not-
cavator, my lord.
1 minute, I'm referring to the affidavit objections filed to your application.
Definitely, my lord.
He has taken a plea there with regard to the compromise.
Lord, there is no application as such according to my instructions, my lord. Let me see.
It's a certified copy, my lord.
Let me see, my lord. A notice may be issued, my lord, today. Tomorrow itself, I will come
This
up
is
with
the
an
court
objection
copy, my
or
certified
final
copy.
hearing. I will be ready, my lord.
Certified copy, this is the.
I'll come up,
certified
I will come
copies.
up with the objection tomorrow or day after tomorrow, my lord. My lord, let me have the look at the writ petition, what he has
order
filed,
sheet
my lord.
itself, it has been
Without that, my
recorded.
lord, how can I put a defense, my lord?
Forget about the writ petition.
Please.
He has filed the objections which you are very much in your knowledge. Objection to your affidavit.
Definitely, my lord.
So in the objection, he has stated about the compromise that is entered and the amount that you have taken.
Definitely.
In that case, in the order, why the order is silent about this?
My lord, in this writ petition, my lord, he is supposed to file the entire order sheet of the FDP proceedings, my lord. I do not know whether that has been depicted. The compromise petition, the filing of the compromise petition has been depicted in the entire order sheet. I do not know, my lord. That is the reason, my lord, I am requesting, my lord, let him serve a copy. I'll come up with an objection or my defense. My lord, tomorrow itself it can be taken up. Nothing is to it.
This is matter tomorrow as the first case.
You will ask my
In
kindly
the
say
meanwhile,
page number
my lord,
142, my lord, kindly,
Serve the
entire order
papers. I
sheet.
said tomorrow as the first case. Yes,
Cell number 42,
I will not adjourn the matter further.
please.
Yes.
cell number 42, because
Notice, no, so and so submits that he has instructions to file wakalat.
Name, birth,
On behalf of whom?
Sir, you name.
All respondents?
Only one respondent.
Which
The
respondent?
contesting respondent, my lord, Kala Shetty.
He is added as respondent number
One.
R1. Yes. Yes, next.
Number 42,
I appear, Manoj, sir.
Lord, this copy has not been served to state, my lord.
Which one?
42,
You are for whom?
state, sir.
State again, now AG, before filing, we have to serve a copy in the AG's office. If he has not got from
Not
AG's
shown.
office, he cannot blame me here.
Lord,
And
I'm
as
for-
far the caveat is concerned, it
I'm
has been sent by
caveat.
mail also.
Seek short period for filing objection,
My lords, may
because the matter was in
Because
the,
you can't seek time.
please, my lord, because
Being
the,
You are only entitled for audience before.
please, my lord,
Yes.
one submission.
being, my lords,
The
being in
writ
caveat,
petition-
they know what it is, and then these
Writ
are
petition
the.
was in office objection, my lord. Other day it was moved on first. It was directed to list on second or third. After 1 week, it has been listed. That's why I'm seeking 3 days.
lords,
It may be
in a-
called on Friday.
Let me hear the matter.
Please,
If
my
it
lords.
requires any
My
adjournment,
lords,
I'll
in a,
grant.
Please, my lord, please.
in a revision petition,
Yes.
which was not even maintainable. A prayer that was never sought has been granted and counter signature granted in my favor, which is being granted right from the year 1968. That has been set aside and matter remanded to the STA for fresh consideration. Now, my lords, kindly take Annexure A is the original permit issued to me in the year 1968.
Yes.
14/68, so B. Now, my lords, the route, if my lords would kindly see at item 7 there, Anantapur to Shivaganga via Chitradurga, Challakere, Settur and Kalyanadurga. This Anantapur to Shivaganga, my lords, was something that came about by way of a modification in the year 2008. But originally the route was Anantapur to Chitradurga via Challakere, Settur and Kalyanadurga. The name Challakere, my lords, may kindly note, my lords, because it has been the part of the original route right from 1968. 68 until 2026, my lords. At least 10 counter signatures have been made by the state of Karnataka. 11th time, this objection is raised, which I will point out. Then, my lords, what happened? I will point out which is the counter signature issued even after the new act came into force. That, my lords, would get at page 27.
This was at a time when route was only Anantapur to Chitradurga. Top of the first part is permit endorsed by the Andhra Pradesh STA. Lower part is the endorsement of counter signature by the Karnataka state STA. Therefore, from 2003, there it is there, and even earlier to that it was there. Then, as long until the state interstate agreement got this route incorporated, by virtue of the agreement reached between the two governments, they were allowing issuing the permits on double point taxation. Now, Annexure C, page 28, is the interstate agreement
Yes.
dated published on 7th March 2008. Agreement was entered into on 5th March 2008. It was published in the Gazette on 7th March. You my lords would kindly turn to page 33, my lords. Route number 25 is N. Soumya Anantapur. She is the AP operator, petitioner. 14/68B, permit number is also mentioned. 142 Anantapur to Chitradurga via Atmakur, Kalyanadurg, Settur, Obalapuram. This, my lords, the title of this statement is at page 32.
No, that you are referring to some other will, Chellakere or something is not there in this.
Which one, my lords?
Original one.
This, that part I will point out last entry, my lords. Page 39. Item number 34. Page 34, item 39. N. Soumya Anantapur, 14/68B, Anantapur to Chitradurga, applied for extension from Chitradurga to Shivaganga. My application was pending. Then it was awaiting the finalization of the interstate agreement. Therefore, this agreement was made, stating at paragraph page 32, statement showing the routes are being shall be operated by the private operators of Andhra Pradesh in state Karnataka state. There were no question of any nationalized route and all will not come in this case, because the agreement itself says it is these are the routes being operated and which shall be continue to be operated by private operators of the Andhra Pradesh state in the state of Karnataka. And against these routes, length of the route is also mentioned. In respect of each route, originating point, terminal point, what is the distance to be traversed in state of Andhra Pradesh, what is the distance to be traversed in Karnataka, what is the total distance of the route. All these are there. Then, my lords, after this interstate agreement, Annexure D is the order of the STA Andhra Pradesh.
Where do you get it?
That is, my lords, Annexure D, page 35.
Yes.
Dated 9/11/2020, where, my lords, at page 38, it says, the seventh supplemental interstate agreement covers the extension of route of N. Soumya at serial number 39 of Annexure 9, and the schemes coming in the way are exempted by the government of Andhra Pradesh. Hence, the application filed by Srimati N. Soumya for grant of extension of route from Chitradurga to Shivaganga in respect of permit number 14/68B is considered and is hereby granted. Thereafter, there was some litigations. Then there was delay in counter signature and operating the route, and ultimately, my lords, it was countersigned by annexure. The separate annexure number is not marked. Page 26, if my lords would kindly see. Page 26. (14/12/2020). My varied route was also countersigned by the state of Karnataka.
Yes.
And there, my lords, Anantapur to Shivamogga via Chitradurga, Challakere, Settur, Kalyanadurga and back to perform 2 single trips. Then, my lords, last sentence of that. This route finds a place at serial number 39 of Annexure 9 of Interstate Agreement dated 7/3/2008, entered into between the states of Karnataka, state of Karnataka and Andhra Pradesh.
But this Challakere is not there.
Challakere, what has happened is, in the agreement it is there. In the agreement, one agreement it is not there. But having regard to the length of the route, when 2 termini are fixed and it is said that this is the distance, there can be one route that hundreds of villages en route, they would not be mentioned. If a person has to challenge,
Like from Anantapur to
Yes.
reach Kalyan Durga.
I have to reach Kalyandur.
Kalyan Durga, they have to travel through
They have to,
Challakere.
from Chitradurga to Kalyandur, if I have to go, I have to traverse via Challakere only. And for double checking, they indicate in the agreement the distance to be traveled also. Suppose I deviate from the distance, then it will be contrary to the agreement. Suppose there are 100 villages coming en route. One cannot expect that the agreement would contain all the 100 villages. Then, my lords, thereafter, my permit came up for renewal and renewal was granted. Was granted. Thereafter, my lords, I applied to the STA Andhra Pradesh for variation of timings. Because it is the originating STA, it only has to grant. Annexure E, page 39, is the order dated 26/11/2021, by which variation in timings was granted. My lords may kindly, existing timings, proposed timings it referred to. Then, my lords, last paragraph onwards I have to read there. In the reference first cited of N. Soumya, proprietors of so has applied for grant of revision of timings in the place of existing timings of the Secretary STA Andhra Pradesh. Then next page, whom all they consulted. In this regard, a memo was issued to the Deputy Transport Commissioner Anantapur District requesting to conduct timing conference and all the sector operators, affected parties pertaining to interstate route Anantapur to Shivaganga via Chitradurga, Challakere, Settur and Kalyandur and furnish a detailed report. The Deputy Transport Commissioner Anantapur was conducted timing conference and fixed on the timing conference has been conducted on 22nd October 2021 at the office of Deputy Commissioner Anantapur, heard with all the sector operators. The Traffic Inspector KSRTC Chitradurga Division, that is represented from the STU of Karnataka State Division, and the APSRTC Depot Manager Kalyanadurgam attended for the meeting, stated that no objection to proposed timings of bus number so and so Anantapur to Shivaganga. The sector operators of private buses, they were also present, who are present in the meeting have filed individual representations stating that they have no objection for grant of revision of timings. The Deputy Transport Commissioner Anantapur has submitted a detailed report to the Transport Commissioner Vijayawada. Hence, the proposed revision of timings requested by the applicant has been examined and considered by the Secretary STA AP Vijayawada with reference to the report furnished by the Deputy Commissioner of Transport Anantapur. The applicant has produced all the valid records. Therefore, the revision of timings is granted. And the applicant is advised to obtain counter-signature of revised timings of permit within 30 days from the date of this order. This I am referring to because that is one of the contentions raised in the revision petition. Now, my lords, the STA Karnataka, Annexure F, page 41. It had no choice but to incorporate the timings granted by the STA Andhra Pradesh, because this is only countersigning state. Under section 88(6), agreement has to be followed, and the counter signature, in fact, Malas, I'll point out from the counter signature, the interstate agreement itself. Interstate agreement entered way back in 1975. There is one statement in that agreement. It says the agreement parties, state governments, shall take step to dispense with the counter signature as far as it is in accordance with the agreement. But that has not been done, maybe for whatever reasons. According to me, only reason is they want the transport operator to be obedient to the transport authorities of both the states. Except that reason, no reason occurs to my mind. Then same timings which are sanctioned by the STA Andhra Pradesh, that is incorporated in the counter signature here. Not a minute change is there. It is not their case also that it is contrary to.
This is on 6/12/2024.
Yes, Manoj.
This is 6/12/2024, page 41.
Yes, 6/12, because this is counter signature.
So this is
My lord, the permit is granted on 26/11/2021.
30 days they were there, you have to have.
30 days I have to apply. COVID was there and I have explained that there was some delay in applying. 2022 January I applied. A difference of about 10-15 days. Thereafter, 22 to 24, the matter was pending with STA. I had to file a writ petition before this honorable court. A mandamus was issued to decide the matter. That was disobeyed. Then I applied, then I moved the contempt jurisdiction. In the contempt, when personal presence of Joint Commission for Transport was ordered, at that stage, they granted the counter signature. That was subject to the condition that I withdraw the contempt. All this I have stated in paragraph 11 of my objection statement before the STA. Then, my lords, this the endorsement of counter signature, then that is page 41, page 42, the endorsement that was made on the permit itself. Thereafter, my lords, the annexure G, page 43, revision petition is filed under section 90 of the Act. Okay, it is necessary to go through what are the contentions raised. His sole grievance in this was ultimately timings are affecting.
Who is he?
He says he is a sector operator, RTA permit holder within the state. He is not interested. Yes, my lords. He raised this contention.
No, he is operating in which state?
He is operating in Karnataka state. I have raised a contention that his permit has expired and evidence of renewal of the permit has not been placed, and it was not placed even till the end of the revision proceedings. Now, my lords, kindly say what are his objections? Page part. Existing operator.
Valid up to 26/12/2025 on the route Obalapura to Chitradurga.
Obalapura to Chitradurga.
And having
that is his intrastate.
With that of the respondent number 1.
Intrastate.
Chilakere and Chitradurga.
Obalapuram is a very controversial boundary, my lords are aware. That is, again, second survey is now ordered. Obalapuram to Chitradurga. Then, my lords, para 2 is what kindly see is grievance. It is submitted the timings countersigned by the respondent number 1 authority is serious, that is the Karnataka State Transport Authority, is affecting the service of the petitioner, and timetable with comparison is extracted below to establish that his grievance. Petitioner, that is, he starts at 6:09 p.m. and I started 6:03 p.m. Earlier it was 6:15 p.m. This is the short grievance. Then, my lords, he says, the petitioner submits that other than the timings in the counter signature ground is illegal and improper. He makes a statement there. Then he proceeds. The serial number 29 and 13 of the interstate agreement reads below. In the intermediary places of route in the permit under, there is no mentioning of the place and no timings can be assigned except at destination place in Karnataka. His grievance is, permit contains the route contains Challakere. It is an intermediate place. Therefore, no timing could have been assigned to Challakere. What he says is, you starting point you fix the time. End point only you fix the time. Intermediate stations you cannot fix the time. As if he would fly over this one. Then, my lords, he refers to the 7th supplemental agreement. And at para 9, it is submitted. There is not say para 8 at page 46. Hence, the respondent authority countersigning the timings at Challakere and Chitturga is against the procedure of interstate permits, and timings can be assigned in countersignature authority only at destination Shivaganga to carry passengers beyond state borders to reach Settur in Andhra Pradesh. Hence, countersigning the timings at Challakere and Chitturga within Karnataka is illegal. Kindly see, in the entire thing, his grievance was against the timings. There is no prayer, there is no ground made out to say that counter signature itself has to be set aside. Then para 10 he says about the delay. The permit was endorsed on 26/11/2021. He was to obtain counter signature within 30 days. There has been a delay. Then, my lords, para 11 he says he had given a complaint and that was not acted upon. Therefore, he is found. Wherefore, prayer. Yes. Petitioner prays this honorable tribunal will please to call for the entire records relating to counter signature of permit number so and so, along with interstate gazette notification so and so, to set aside the end of renewal of dated so and so, to countersign the timings only at the destination, direct the petitioner permit holder not to pick up or set down passenger Karnataka between direct the respondent to delete countersigned assigned timings at Chitturga and Challakere. The limited prayer was, you set aside the timings assigned at Chitturga and Challakere. No other prayer. Yes, he may have a genuine grievance against the timings.
No, what is, how he is benefited by this?
What he says is his bus starts 6 minutes earlier to my bus. Therefore, he gets larger number of passengers. Original timing. Revised timings, I start 6 minutes earlier to him. Therefore, I get more passengers.
So according to him, he should be given the earlier slot.
He has to go back to the earlier timings. That is the sole prayer. Now kindly see my objections also. I objected in particular pointing out that
we'll go to the order.
Order, my lords. Order at page 63. Facts in brief and all, my lords may omit. Para 7 at page 73. Whether the present revision petition is maintainable. My contention was that since STA Hyderabad has fixed the timings, he has to go there. All that you have to do is only to the Karnataka State Authority has done is endorsing this same thing. Then, my lords, in para 7, page 74, insofar as the maintainability of the present revision petition, it is the contention of the counsel for the second respondent that revisioners have not challenged the original grant of permit subsequent renewals, no locus standi to challenge. However, on the other hand, then he goes dealing with the judgments and all that. Then he says he rejects my contention of acquiescence based on earlier judgment of this bench. Then, my lords, he holds at page 76 that accordingly I hold the point number 1 in the affirmative. He holds the revision petition maintainable. He ignores the fact that Karnataka ST has only exactly copied the timings fixed by this one. He may have a grievance saying that I was not heard because he was not interested, but for him the remedy is before the AP STAT or AP High Court, not here. Then point number 2, so far as this point is concerned, then he goes on the 12B at 77. On the other hand, it is the contention, the last 3 lines in the para above it notices, therefore the counter signature granted with regard to route is illegal and improper. This is not the contention. Contention is timing granted at Challakere is wrong. Then, on the other hand, then in view of the rival contentions, he goes on at 12E. He holds at page 78. In view of the above said decision of their lordships of the Honorable High Court of Karnataka, it becomes pertinent to see whether there is mention of route Challakere to Chitradurga in the interstate agreement concerning the permit. As the petitioner has challenged the counter signature of the first respondent in issuing the endorsement of counter signature of renewal of the second respondent for the via route Challakere Chitradurga to Challakere. In this regard, from the perusal of the Gazette notification dated shown, so it is to be seen at serial number 25, the Gazette notification, that the route mentioned in connection with the second respondent, Anantapur to Chitradurga, via Atmakur, Kalyanadurg, Settur and Obalapuram. Further, at serial number 39, Anantapur to Chitradurga applied for extension of Chitradurga. As such, it is clear from the perusal of the above said Gazette notification that Challakere route is not mentioned. On that reasoning, he sets aside the entire counter signature, which is beyond the prayer made. At best, even if he had rejected my entire case, he could have only said that since your route commences at Atmako, the Anantapur, and ends at Shivamogga, Shivganga, intermediate stations, timing given is bad. If that finding is recorded, my answer would have been that STA Andhra Pradesh is the competent authority. It has given and you cannot meddle with that. If there is any difficulty in implementing the agreement, there is a provision in the agreement itself that the authorities in these two states will have to sort it out. That is a part of the agreement. Now, my lords, kindly see the order passed at para 13. Therefore, I am of the opinion the impugned endorsement of counter signature first needs to be set aside. Why? And that is not a prayer he has asked. And matter needs to be remanded back. Therefore, he sets aside.
The whole basis for all these orders are about the notification that is issued.
Yes.
The Gazette notification. In the Gazette notification, particularly when it mentions about this route, as observed by him, Challakere is not part of the route.
It is not part of the route for the simple reason that omission of Challakere there cannot be read in isolation because of the impracticability of mentioning each place in the agreement. In 1975, Challakere must have been a very small town. In fact, it was a small town.
But in case of in these cases of route permits and all, everything assumes significance.
Then, my lords, every village cannot be mentioned. Therefore, to see that they do not deviate from the agreed interstate route, they mention the distance. If 2 points are to be traversed within the particular distance mentioned in the agreement, what is the straight line or what is the route? In fact, my lords, if my lords go by the definition of the route in Motor Vehicles Act, there is no need to mention the intermediate stations at all, because subsection 38 of section 2 of the Motor Vehicles Act defines the route as the line of travel.
He's the one appearing for the revision petition.
Yes, revision petition.
What is the order that is passed by the court is beyond what you have sought
No,
for?
my lord, it is proper. And in view of the order of the tribunal, the vehicle has been stopped by the authority also from 36/2026. He is not operating within Karnataka. Up to state border in Andhra Pradesh, I have no grievance at all. My grievance is only in respect of extension from Chitradurga to Shivaganga. Because all the interstate permits will be given timings beyond state border only, because they want to carry the interstate passengers. They can pick up, but beyond state border, they have to pick
No,
up.
that is not your review before the authority.
That I have stated in my revision petition.
You are only concerned with the timings.
No, it is counter signature because timing is not assigned by the STA Karnataka.
Correct. That you're aggrieved by the counter, the timings that are altered.
No, not at all like that, Mala. Counter signature itself is bad because of the reason the secretary STA Karnataka should have called for the revision of timings as per the portion concerned from state board within Karnataka. That is the procedure. In all other cases, they will call for a assignment of timings, calling KSRTC and other existing operator common to this route. That is not done by this. The
is
Section
very-
88 may kindly be perused.
Precisely is your prayer, but what did the?
There is no
authority do?
assignment of timings by Karnataka. I cannot challenge the timing assigned by STA Andhra Pradesh because I am not agreed in that portion.
But that is not
Because
the-
I am agreed only in respect of countersigning the timings. Because they have got a power under section.
What the court is saying, you are agreed for something and the order is granted on some other thing.
Only counter signature is the order 6/12/2024. There is nothing more than that. 6/20, he started operated only on 6/12/2024. Earlier to that, his route was Anantapur to Chitradurga only.
And
That
this
I have not at all agreed.
Sorry for interruption, my lords. Sorry for interruption. Challakere comes between Anantapur and Chitradurga only, not in the extended route. Let him reverse the geography.
According to his own endorsement, page 26 may kindly be perused. Endorsement of counter signature of renewal of stage carriage permit that is dated 14/12/2020.
Please show me one line.
Please, my lord.
In your review petition grounds, what is that you have sought for? You have said that this petition is not having permission to fly till Chitradurga. Then that is your grievance.
My grievance is that they cannot assign timings for the
That is
intermediate.
what I am saying. You are
Please, my
only
lord.
concerned with the timings, but what did the authority did by this order? Read it.
My request, it may kindly be modified. Let him not pick up and sit down at Challakere.
Yes.
Please, my lord.
Yes, Mr. Senior Counsel, he says he has no objection to
For,
modify this order.
let them
He
delete,
is only concerned with the timings.
pick up and sit down at Challakere.
Timings, my lords.
With regard to the timings, we'll delegate both of you to the.
Timings, my lords. My lords may delegate, relegate both of us to the STAT, setting aside the order, holding that it is beyond the prayer made, and the matter,
As far as his grievance is concerned,
Yes,
let authority pass an order.
let authority pass
Please,
an
my
order.
lord.
Hearing both the
Let
parties.
my
Yes.
objection may kindly be considered. Until then, let him not operate because he has already stopped the service.
Yes.
Stopping the
ask him-
service because
It
of
is
illegal
already
order.
stopped service. Let it be done within a week or 10 days. I have no objection.
If you let the court say something, then you'll.
Sorry, ma'am.
I'll ask the authority to decide this within a week.
Yes, my lords.
By tomorrow, we'll upload this order.
Yes, my lords. Meanwhile, this
Such
order
time-
of the STAT has to go.
It will go,
Yes,
but anyway, he is not operating.
Yes.
No, I have to operate because, my lords, I am,
This 1 week again.
my lords, kindly see, my lords. In fact, before the tribunal,
No, from
I
when-
agreed
no,
also.
From when you are not operating?
My lords, I am not operating from the order itself was passed on 12, on 12/6,
So it's been a month.
2026.
It's been a month. Wait
There
for
is
one
my
more.
certified copy is secured on 18/6. Well, the order is dated.
Let the
My lords
order-
would get the page.
Let the order be passed. Basing on that, you can fly the vehicle.
My lords, in fact, in the intervening period, my lords, I have myself suggested.
Then you do one thing. Till if you want to ply the vehicle, as per the earlier timings, before.
Very well, my lords, as per the earlier timings, I will
Let
ply.
him ply the vehicle as per
Till
the
it is
earlier
decided.
timings.
Because his variation has been granted, it is in violation of this scheme 7/3/2019.
Earlier order you have not questioned.
Please, my lord.
Earlier order.
Earlier after my service, okay, I have no objection.
Then we don't have to send it to the STO also. He has no.
I'll
objection.
submit, my lord.
He say you-
I
you
have.
can-
If timing
I
is-
have suggested, my lords.
If you can ply the vehicle.
In fact,
as
my
per
lords,
the-
page 60,
You that,
page 60, I have suggested timings.
page?
Page 60. There, my lords, I have said petitioner timings 609, that is the present respondent number 2. He will leave 3 minutes earlier to me. And the destination also, he will reach 3 minutes earlier to me. He wants earlier than me.
That is That is,
Go to the earlier timings.
yes, my lord. 6:15.
Yes, my lords.
Let us go to the earlier timings.
6:15.
Earlier timings, my lords. Earlier timings. Earlier timings.
I've given the comparison, 6:15.
Where is it?
In the comparison,
Page, in the
annexure
first
only I have
page of
stated in
the,
my revision petition.
in the first page of the, what is, the text.
Page
I'll point out,
44.
my lords. Page 39 is the authentic recording.
No, this is the latest one.
No. Existing timings, they note.
Yes, existing timings. So,
Proposed timings, they note. I have no difficulty in going by the, this one, existing timings mentioned there.
there is no difference between the existing and proposed.
Proposed means there is a difference, man.
Yes.
For
other
example,
stations there is-
Chitradurga, existing 7:10.
Sir,
Now I reach at 6:45.
The earlier timings, the existing timings.
6:15. That 6:15. It is mentioned at Chalkere 6:15.
6:15.
That is what I have compared, given comparison and revision. And one more blunder, you may kindly see, agreement is starting. One minute,
Please,
Mala.
please wait. So you have no objection if this person, if the petitioner flies the vehicle in this existing times.
I have to get the instruction from the client. Let the authority hear, because in their presence only I have to submit. Because timings, they knows very well than us. And one more, you may kindly see, is only exists.
If you have no objection.
Yes.
For the existing.
My lords may pass an order, my lords, that pre-existing timings, whatever was there, as noticed in annexure E, I can operate on that. If he still has got any dispute regarding
What we do is,
timings,
as an interim order, I'll pass this order, I'll keep this writ petition pending.
Yes.
You can come up with your objection.
Yes. Oh, one more. There is one more this thing. You may kindly see is annexure E39 only. Existing timings and proposal timings. From where he starts? He cannot start from Sivagange. His permit has been issued by Andhra Pradesh. How can it possible?
if that is his
That is
argument,
not possible at all.
he has to raise the dispute regarding
Because
timings
now,
also
now
in
only
Andhra
he has
Pradesh.
given these annexures. He has not produced all these things before the court, and in the statement of objection before the tribunal, para 7.
Now, you have questioned the arrangement pursuant to this 26/11/2021.
Yes.
Yes, that's a 2021.
So, whatever is existing prior to that, let that continue.
Let that continue
You
as
cannot
a-
have any
as a
objection to
interregnum.
that. Where is the earlier one? There must be an order
Yes, my lords.
prior to this 26/11.
Prior to this 26/11, the order endorsed, in this they notice, in the first part, the existing timings, that is prior timings. That is based on, my lords, that original I have not produced, but that is pursuant to annexure D, page 35, where they granted me variation. Immediately thereafter, the timings are fixed, which the page 26 is the endorsement of counter signature, but that does not contain the timings. For the present, my lords may, because he has not questioned the existing timings as per annexure E, page 39, that may be as an interim measure that can continue.
Please go.
And one more request. Let it be as per the interstate agreement, serial number 25 and 39, Mala.
25?
And 39. It is there annexure only, annexure
Yes,
C.
yes, that is what.
Please.
Senior counsel
is there.
As per annexure C,
The
let the authority consider and
petitioner
pass
is
order.
agreed with the order. Passed with the. Which respondent is he?
Respondent number 2 is the, I was before the tribunal, I was
agreed with the
respondent number,
Tribunal.
respondent number 2.
R2 is the revision petitioner
2025.
before the tribunal.
Dated 12th June 2026, whereby the tribunal has allowed the revision petition filed by the respondent, and the endorsement dated 6/12/2024 in connection with the counter signature is set aside. The matter is remanded back to the first respondent to reconsider the grant of counter signature of renewal of permit of the second respondent as per the interstate agreement in accordance with law. Further, the first respondent is directed to dispose of the matter within 60 days from the date of receipt of the order. Then the senior counsel appearing for the petitioner submits that the order that is passed by the tribunal is beyond what has been sought in the review petition. The review petitioner is only agreed with regard to the timings, but the authority has gone beyond, the tribunal has gone beyond, and
Set aside the counter signature itself.
has observed that the respondent authority was under a bounden duty to verify as to whether the counter signature granted in respect of the second respondent's permit covering the route Chellakere was originally mentioned or not in the interstate agreement.
Please.
It is submitted that the route is from Anantapur to
Sugam.
Chitradurga, and Chellakere is, they have to enroad through Chellakere. It is submitted that the order under the order passed by the tribunal is contrary to, is beyond the scope of the review. Next paragraph. Land counsel appearing for the respondent review petitioner submits that already in the light of this order, where is that?
36. In the light of order M 48,
In the light of the order
M,
passed by
annexure
the
M,
tribunal
there's a date of annexure M is not 12th June.
12th June
on
2000.
36/20/26. On from 36/20/26, the petitioner is not permitted to ply the vehicle.
Please.
Is not permitted to ply the vehicle. It is submitted that while granting, while mentioning the timings, court has failed to consider, the authorities have failed to consider the permit that is granted to the respondent and the difficulties faced by him. Next paragraph. This court has having heard the learned senior counsel and the counsel for the respondent, this court has perused the order in view as rightly submitted with the learned senior counsel. The order that is passed by the authority, by the tribunal,
Karnataka State Appellate Tribunal,
Karnataka
Transport
State
Appellate
Appellate
Tribunal.
Tribunal is beyond what has been sought and sought. As far as the earlier
Timings mentioned at
earlier timings mentioned in the proceedings dated 26/11/2021, the respondent herein has not questioned before the revisional authority. He is only aggrieved by the endorsement of counter signature dated 6/12/2024. Hence, balancing the interests of both the parties, this court is passing the following order. The order passed by the appellate authority dated so and so.
Appellate Tribunal.
Appellate tribunal dated so and so. The operation of the order is suspended till further orders. Number 2, the petitioner is permitted to ply the vehicle as per the existing times mentioned in the proceedings dated 26/11/2021.
My lords may also say annexure E, my lords. Annexure E.
Annexure, as per the existing times mentioned in annexure E. The respondent shall file his objections, if any, by the next date of hearing. This is matter in the month of September.
Please.
Great.
Number 43. Vivekananda N. for petitioner.
Respondents.
I appear for petition. My lord, the defendant's petition, the plaintiff has filed a suit for partition, my lord, against father and brothers. During the pendency of this suit, she files an application for depositing of the means profit. That application is allowed, my lord. Without going to merits, my lord, may I submit, my lord, if my lords are pleased, the order may be set aside and direction may be given for early disposal, because now the plaintiff has completed her
Order to
evidence.
be set aside means you want the retribution to be allowed.
Yes, my lord, that's what. 3 months, my lord, I'll cooperate with, for early disposal of the suit itself, my lord. Because
Which
suit
year is the suit?
2023.
Then why should there be a direction
My
for
lord,
early disposal?
now it is for defense evidence, my lord.
But we cannot grant, sir, there can't be a
Then
mandamus
I'll-
of that nature.
My lord.
Argue on the
Then
merits of it, don't worry about the disposal.
2023 suit filed by the plaintiff, my lord.
Please
And-
come to the impugned order.
My lord, impugned order starts at page 26. The reasons starts at page 28, my lord. Shall begin from reasons, my lord.
Please.
Point number 1. This is the suit filed by the plaintiff for relief of partition and separate possession of her legitimate share in the suit scheduled property. As per the contention of the plaintiff, suit scheduled property fallen to the share of defendant number 1, who is her father under the registered partition deed dated 10/4/1996, which was executed in between the family of defendant number 1. The defendant number 1 has been looking after the management and affairs of the joint family properties that fell to him in the said partition. The plaintiff is married and residing in her matrimonial home at Bangalore. Further, the plaintiff stated that the defendant number 1 is not the absolute owner of the suit scheduled property, even though he has executed the registered gift deed dated 26/11/2021 in favor of defendant number 2 and 3, without the knowledge and consent of the plaintiff behind her back. The plaintiff stated that even though the defendant number 1 executed registered gifted, but he is the person who managing the affairs of the suit scheduled property, and hence the plaintiff claiming a legitimate share over the suit scheduled property. The defendant filed the written statement and contended that the defendant number 1 started enjoying the suit scheduled property as an absolute owner, being in possession of this same after the effecting the partition in the year 1996. Further, the first defendant, being the duty-bound father, has given sufficiently and also performed the marriage of plaintiff with high dignity as expected by his son-in-law and his family members. In the meantime, defendant number 1 is started suffering some health issues due to the age factor, and to avoid litigations amongst his children and also to get himself retired from the responsibilities, he has bequeathed the scheduled property in the name of his sons under the registered gift deed dated 20. My lord.
You can come to paragraph 9.
Paragraph 9. On careful perusal of the pleadings of both the parties, it shows that though the defendants contended that suit scheduled property is an absolute property of defendant number 1, but they have not denied the fact that the suit scheduled property is owned by defendant number 1 under the partition deed in the year 1996. And also the contention of the defendant is that the defendant number 1 is enjoying the suit scheduled property as an absolute owner since the date of partition in the year 1996. The admission of the defendants clearly shows that the defendant number 1 owned the suit scheduled property under a family partition. Furthermore, it is not the case of the defendant that the photographs annexed to the application filed by the plaintiff is not the suit scheduled property and have not accrued any rental as stated by the plaintiff. Under such circumstances, prima facie it shows that the plaintiff, being the daughter of defendant number 1, is also entitled to her share in the suit scheduled property. However, the final adjudication is pending, and the contention of the defendant regarding the absolute ownership of the defendant number 1 over the suit scheduled property will be decided after the full-fledged trial only. However, the final disposal of the suit may take time, as it requires the full-fledged trial to come to conclusion by the court to pass the final judgment. Till then, directing the defendant to deposit the rent accrued out of the suit scheduled property before the court is just and proper to safeguard the questioned legitimate share of the plaintiff till the final outcome of the present suit. Accordingly, I pass the following order. 1996 is the partition deed. 1970, I purchased the property. Defendant number 1 purchases the property. The whole family, the father of the defendant number 1, they were residing together. After that, it was a family arrangement. By that, I got this property, my lord. It was my absolute property. 1976 sale deed is also available. So my content.
Purchase the property.
Yes, I purchased the property. Defendant number 1.
Chair.
1976 under registered sale deed. This I have taken this contention in written statement also. After the family arrangement, it was the family, they were doing business together, my lords. At that time, in 1996, they partitioned the property. Whichever property they had purchased, it went to their share. That sale deed is also available. That is my contention, my lord. I have taken it's not a joint family property or the ancestral property, because I purchased the property in 1976 and I became the absolute owner of the property. My contention is the plaintiff is not entitled for any share. This is my defense, my lord.
Yes.
My lords, the 3 submissions that I would like to make before this honorable court, my lords. Here the first defendant number. Thank you. My lords, the first presentation is about how he got that property, my lords, the suit scheduled property that is owing to the partition deed on 4 to 1996, my lords. Thereafter, what happened, my lords? He has got,
Purchased the property in 1979.
that is what their contention, 1996, he got that property through partition deed, my lords, between family members, my lords. Thereafter,
There is a sale deed
no,
in his
they
name.
are contending the same, my lords.
But it's
But
not there
as
before
per,
the court.
please, my lords,
The document is not there before the court.
not so, my lords.
I'll produce, my lord. It is.
Now they are telling they will produce, my lord. Not so in the OS, my lords. But as far as my presentation is concerned, my lords, he got that property by partition deed, my lords, on 10/4/1996, my lords. He got three issues, my lords. One is plaintiff number 1, defendant number 2 and 3, my lords. What he did, my lords, on 26/11/2021, he executed gift deed only against defendant number 2 and 3. That is 2 sons, my lord, excluding me, my lords. That is daughter. Being aggrieved by the same, my lord, she filed a suit for partition, separate possession, my lords, of 1/4 share in the suit scheduled property and also means profit, my lords. That's why we have filed IA, my lord, say,
As far as this property.
under 151 of
In
CPC.
respect of which the court has passed the order, there is a sale deed of 1979.
Please, my lords, it is not their case there, my lords. They have
You say
Page
so?
46, my lord. Page 46.
40?
46, 46. Para
Yes.
H, it is further submitted that insofar as the suit scheduled property is concerned, it is the absolute property of this defendant number 1, as it was purchased in his name way back in the year 1976 under the registered sale deed. It is significant to note that here that the firm which is named Supra was closed in the year 1996. As on those days, only 2 properties were left, and this defendant number 1 and his brother by name Ramesh were residing jointly even after the death of Durgappa. Durgappa is defendant number 1 father.
Yes.
Since the year 1996,
So basing on what this court has to come to a conclusion that it is he has acquired this property from
My
the
lords,
earlier partition.
as far as their presentation is concerned, they got a firm, my lords. That is family firm, my lords. Whatever they have purchased, that is through family earning only, my lords.
1976. Why should there be an order of for this?
My lords, here the daughter files a partition suit, my lords. If if there is no arrangement for deposit, my lords, thereafter if she wins, my lords, she is unable to get it back, my lords. That's why she has filed that IA, my lords, under section 151 of CPC, my lords.
Let us look at your IA.
Please, my lords.
What did you say with regard to this property?
Annexure E,
50,
page
my
50.
lords.
Page?
Page 50, my lords.
Yes. Don't mention anything.
It is there, my lords. My lords, in affidavit, page number 51, my lords.
Yes, I'm at 51.
51. May I read, my lords?
Relevant you read.
Okay.
You have referred to a gift deed dated 26/12/2021.
Please, my lords.
Then you have referred to the suit scheduled property consisting of ground floor, first floor and second floor.
Please,
In
ma'am.
respect of this, he says that he has purchased the property in the year 1979.
My lords, now they are stating this before this court, my lords. They
Not
have
before
not
this court.
produced.
No.
They have said so in their objections.
Written statement.
My lords, for understanding whether it is there or not, for that full-fledged trial is required. That is what the observation made by court below, my lords. My lords, if for a moment, my lords, if that deposit were to be made, my lords, if I am not going to succeed, means they are only going to get that amount, not me, my lords. That's why if they are depositing that much of amount, it is not going to affect their interest, my lords. That is what my submission, my lords, because she is a girl. Intentionally, they entered this, they executed gift deed, my lords, in the year 2021 without giving consent, without
That is with regard to
consent of a daughter, my lords. That is what the grievance, my lords, before this honorable court, my lords.
Please come. Agreed with the orders passed on I number 2 and OS number 397 of 2023, dated
7/4/2026.
7/4?
2026.
7/4/2026 by the principal senior surrogate and CJM Court Davangere. the the respondent, the petitioner defendant is before this court. The respondent herein, who is a daughter of the petitioner herein, has filed a suit for partition in the year 20, that is OS number 397 of 2023. In that, she has filed an IA. Where is that affidavit?
51, my lord.
51.
She has filed an IA.
49, my lords. Yeah, 50. Annexure E, my lords.
She has filed an application seeking a direction to the defendant number one to deposit the entire rental income of 2 lakhs per month derived from the suit scheduled property. It is stated in an affidavit, in the affidavit that is filed in support of the IA, it is stated that the suit is filed seeking partition of the properties and also to allot 1/4 share in the suit scheduled property and all, and by holding that the alleged gift deed dated 26/11/2021 executed by the father in favor of defendant number 2 and 3 is not binding on the plaintiff, and to extend the legitimate undivided share. It is stated that the suit scheduled properties consisting of ground floor, first floor and the second floor, and all of them have been let out to the tenants on the rental basis by the first defendant. And the first defendant is managing the FIs of the said property and collecting rent every month from the respective tenants. As such, the application is filed, giving a direction. Continue to deposit all further rental income derived from the suit scheduled property in order to prevent the defendant number one from misappropriating the same and also to aid the main relief sought by them in the suit. By order impugned
My lords, one submission. The prayer is also for means profit, my lords.
and for mean profits. The court by order impugned had allowed the said application. While allowing the application, the court has observed that on careful perusal of the pleading of both the parties, it shows that though the defendants contend that the suit scheduled property is an absolute property of defendant number one, but they have not denied the facts that suit scheduled properties is owned by defendant number one under partition deed in the year 1996. And also the contention of the defendants is that defendant number one is enjoying the suit scheduled property as an absolute owner since the date of partition in the year 1996. This admission of the defendants clearly shows that the defendant number one owns the suit scheduled properties under a family partition. Furthermore, it is not the case of the defendant that the photographs annexed to the application filed by the plaintiff is not the suit scheduled property and they have not accrued any rent as stated by the plaintiff. And such circumstances, prima facie, it shows that the plaintiff, being the daughter of defendant number one, is also entitled for a share in the suit scheduled property. However, the final adjudication is pending. The contention of the defendant regarding the absolute ownership of the scheduled property will be decided after full-fledged trial and accordingly allowed the application. Then counsel appearing to the petitioner submits that the defendant has taken a definite stand. Thus, this property has been is purchased by him by way of a registered by way of
46, page 46.
registered sale deed in the year 1976. And ever since he has been in possession of the property. And according to them, the partition was effected in the year 1996. But this property was purchased in the year 1976. And he is the absolute owner of the property. Considering the sale deed that is executed, considering the fact that the property was purchased by way of a registered sale deed, and ever since, from several decades, he has been enjoying the property. There cannot be any at this point of time, without even coming to a prima facie conclusion with regard to the nature of the property. The court ought not to have granted, ought not to have passed an order directing the petitioner to deposit the Land Council appearing for the respondent plaintiff submits that the father has executed a gift deed in favor of the other defendants, depriving the petitioner of our legitimate share, which made her to come before the court by filing the partition suit. It is submitted that this contention with regard to the sale deed of the year 1979 was not earlier taken up by the petitioner. It is submitted that if the court comes to the conclusion that the petition is entitled, that the plaintiff is entitled for the partition, and at that point of time, the petitioner will not be in a position to recover all this, also sought for the mean profits. As such, it will not be in a position to recover the same, and the court has rightly passed an order. Next part. Having heard the counsels on either side, further material on record. Suit is filed for partition, and also a declaration that the gift deed executed by the father in favor of the other defendants is not binding on the plaintiff. The case of the plaintiff that the suit scheduled properties or the joint family properties and the properties were fell to the share of the father in the partition that took place in the year 1996. And it is a case of the defendant that he has been that's a property is a self-acquired property which he has purchased in the year 1976, and ever since he has been in possession and enjoyment of the property, the trial court, while passing the order, has failed to consider this aspect. At the same time, this court is conscious of the fact that the respondent, the plaintiff, has sought for the mean profits with regard to this. Hence, in the facts and circumstances, passing an order directing the petitioner to deposit the rents before the court. The court ought not to have passed such an order, considering the sale deed of the year 1976. However, to balancing the interests of both the parties, this court is passing the following order. The order impugned dated so and so is set aside. However, whatever are the rents that are received by the petitioner, with regard to that, the complete details with regard to the rents that are derived from the said property, the petitioner by way of an affidavit shall state all the same before the court. Yes, accordingly disposed of.
Then number 44.
My lords, one submission, my lords. Half of the rent amount may kindly be deposited, my lords, before the court only, my lords.
Yes.
Till number 44. Kartik Surya
First
Prakash.
respondent.
The petitioner, Lords. Lords, the petitioner has challenged the acceptance of the valuation report by the executing court, my lords. The proceeding arises from a partition suit where there was a compromise decree, and subsequently the petitioners, who are the judgment debtors, had preferred an application for preemption before the executing court, which was rejected. Subsequently, the judgment debtor approached this honorable court, and the application filed by the judgment debtor was allowed with the consent of the respondents number 1 and 2. Now, subsequent to this, the section 3 of the Partition Act preemption proceedings are ongoing. My lords, I may refer to some dates, some 3 dates that I may refer.
No, please, where is the impugned order?
My lords, the impugned order may be found at page 160, my lords.
160.
Indeed, my lords. Annexure N. The order starts at page 160. But there are multiple submissions, but the first submission that I would like to focus.
DHRs and JDR number 1 and 2 are hereby directed to present before the court, to participate in the bid and to comply the order of the High Court of Karnataka. That's the order.
160, my lords.
I'm reading it 168.
158.
168.
Indeed, my lord, that's the order. Indeed. At page 168, para 14, the court commissioner report has been adopted. 168, the top paragraph in 168, my lords.
Para 16.
Indeed, my lord. Para 14. Indeed, that is correct. My lordship is on the right page.
Yes, please read it. Further, both DHR and JDR
are hereby directed to be present before the court on 6/6/2026 to participate in the bid and to comply with the order of Honorable High Court of Karnataka. Further, the JDR number 1 and 2 are directed to deposit 25% amount with regard to the purchase of 1/3 share of each of the DHR 1 and 2 in the office of that day itself, and directed to deposit remaining amount within 10 days.
So how are you agreed by this order?
We are agreed by this order because, my lords, the court The court had sought for the appointment of a court commissioner to independently value the said property. My lordship will find, my lordship may refer to the order sheet at page number 100, my lords. Page number 100 is the order passed subsequent to the order.
Page number 100.
Indeed, my lords.
Was it question?
Annexure K. No, my lords, this is questioned in the RA proceeding. There are two orders on the same date. The first order pertains to the fixation of the date, whether it is 2015 or it's 2025. That is subject to RA because the question of date is a matter of decree and that is subject to RA. On page number 102, my lords, subsequent to that order, page number 102, valuation report is filed by both the parties. We file the certified value of the sub-registrar values, my lords, and the DHR files a report by BM Associates showing that the present market value of item number 3 property is 1 crore 72 lakhs 83,000 and guidelines value is 93 lakh 35,000. The JDRs dispute the same. The learned counsel for the JDR number 1 and 2 submitted that the court may take assistance of executive engineer of either PWD or City Corporation Shimoga. Subsequently, the court orders for the assistant executive engineer to prepare a report, and subsequently the report is also filed by the assistant executive engineer. However, my lordship will find at page 109, my lords, 28/3/2026. The report filed by the court by the assistant executive engineer is confined to the guidelines value on the basis of Karnataka Stamp Act, and the valuation of the building has been carried out on based on the prevailing sub-registrar values, and further stated that the asset valuation, including the market value of the land and building, has to be assessed by a qualified chartered engineer and valuer. Subsequently, on the same date, in the last paragraph, my lordship will find the appointment of the court commissioner by the court. On searching through Google, many of the companies are found, out of which Sajjan Associates, Mallesh Commercials, 109 last para, my lords.
So from 102 to when did you go to 109? Yes.
109 last paragraph, my lords.
Yes.
Out of which Sajjan Associates, Mallesh Commercials, Cella Floor, opposite Prithvi Mansion, 100 feet Main Road, Vinoba Nagar, has been appointed as the court commissioner.
Yes.
Now, my lord, subsequently, the next date, page 111.
Yes.
Again, it is Sajjan Associates, Mallesh Commercials, has not submitted the report, and they prayed to pose the matter on the next day, 904. Page 112, my lords. Case called out Sri Pranesh BM Associates, who is the assistant of Shanta Kumar of Sajjan Associates, present and seeking assistance. And subsequently, the court has directed them to prepare the report, and they have filed the report on 13/4/2026. The report may be found at Annexure M, my lords. Annexure M is the report, page 145, my lords.
Yes.
It's by BM Associates, my lords. The same firm employed by the DHR. The court, without even appreciating the fact that the report is not by the court commissioner appointed by it, has proceeded to rely on the same as though it's an independent valuation. It is not the court commissioner who was appointed. On this preliminary ground itself, I would seek for a fresh and independent inquiry, because when the court has appointed Sajjan Associates as an independent valuer, when the same report...
Shanta Kumar is the proprietor of Sajjan Associates. That's all I can say. The letter is on BM Associates.
But it shouldn't be.
I understand, but the problem is his objection. His objection is the valuation is on the higher side, therefore it should be reduced.
Not only that, when somebody is appointed as a commissioner, he has to execute the work.
I understand.
He can't delegate it.
Lords, my only request, my lords, is 2015 is a decree. Within 4 months, they had to buy the property and give us our money. We are in 2026. I am at my lord's hands. Kindly, lords, I request my lords to do. My age is already about almost nearing 80, my lords.
We'll fix a time frame.
And this is a compromise decree. They were supposed to buy the property in 2015, 4 months.
We'll fix the outer limit for all this.
Plus, this honorable court granted 6 months time. Plus totally, my lords, 37 applications are filed by the JDR.
Months time from when was the order?
Plus that order, my lords,
99, page 79, my lords.
page 79, my lords. 19th January 2026
Oh, 6 months time elapsed already.
already. Plus 37 applications are filed, one after the other.
Finally, we'll say 1 month from the date of receipt of the copy of the order.
From the date of the, as soon as the valuation order is made, my lords, we will immediately.
He did not file his objection to the valuation report on the ground that is submitted by somebody else. He knows Shantakumar is the proprietor of Sajjan.
When was the report submitted?
15/4, my lords, it was submitted before the court. He filed his objection on 16/4. On 16/4, he did not take up the objection that is not submitted by Sajjan Associates.
Where is that?
Let's kindly see, my lords, page number 150, 154, annexure M1.
Yes.
Lords, it's a 3-page objection. Nowhere objection was taken that it is not by a Sajjan Associates.
It was not known to us. It was being taken on a day-to-day basis, my lords. In fact, I've also pointed out in the order sheet.
Come to know.
My lords,
When did you come to know?
my lords, when we are,
Now, this order is unconnected with your objection.
my lord,
The order is something. The court has already acted upon the commissioner's report. You never take an objection to that, saying that this is by somebody else, but not by that person which the court has appointed.
my lord, because the order sheet also points out that there is an assistant of, that is the fraud being projected.
That is cost to you now.
My lord, because there is no independent valuation report at all. There is no independent valuation report except it was the valuation report which was rejected by the honorable court on, the same report was rejected by the honorable court on.
How many months and years you want to get
My lord,
this?
a timeline may be fixed. We are willing to buy the property. A timeline may be fixed, but an inquiry.
1 month from the date of receipt of the copy of the order, whatever has to be done within that time frame. And you keep on, you cannot, and next time we will not even entertain these kind of petitions. I'll say that without taking an objection at an appropriate point of time, you let the court pass an order and now you come before the court. When the commissioner report is filed, you don't file objections saying that this is not executed as per the order. So which shows that your intention is to drag on the proceedings.
It was not discovered at that time, but my lordship may fix it.
And my lords, this order is in April. He keeps quiet after the court accepts the valuation report and accepts 20 lakhs rupees from me as my portion of the money. And for the balance amount, 9/7 is the date fixed. And they challenge their whole object is, my lords, the valuation is to be fixed as on 2015. That is their basic presumption.
That is the holding of the honorable court in Malati Ramchandra Rawat's case, my lords.
That has not been accepted.
That was pending in RA proceedings, my lords.
Agreed with the order dated 25/4/2026, passed in execution number 31 of 2017 by the second additional civil judge, senior division at JMFC Shimoga. The petitioner, the judgment letter is before this court. It is a grievance of the petitioner that earlier the court has appointed a where do you get that name?
83. My lords will get the name at page 109, my lords.
The court has appointed
last paragraph. Last paragraph.
Sergeant Associates, Malesh Commercials, within brackets cellar floor, opposite Prudvi Mansion, 100 feet main road, Vinoba Nagar, Shimoga, who is a chartered engineer and approved valuer in Shimoga, to inquire about the valuation of the property. The valuer, the valuer has placed the report and the petitioner has filed his objections. Later, the order in tune came to be passed, whereby the court has directed THR and JDR number 1 and 2 are directed to be present before the court on 6/6/2026 to participate in the bid and to comply with the order of the High Court. Further, JDR number 1 and 2 are directed to deposit 25% of the amount with regard to the purchase of one-third share of each of DHR number 1 and 2 in the office of that day itself and directed to deposit remaining amount within 10 days. The petitioner now has come before the court stating that the court has directed the Sergeant Associates to carry out the valuation, whereas in this case, report is filed by
BM Associates.
BM Associates.
PM Associates. They are not the same persons as appointed by the court. And hence, it is further submitted that whatever is the valuation of the DHR, the same is reflected by them. It shows that they are not the independent valuers. As such, the order impugned needs to be set aside. The counsel appearing for the respondent submits that, in fact, the person who has done the valuation is partner of Sergeant Associates.
Is a proprietor of Sergeant
The
Associates.
proprietor of Sergeant Associates. No doubt, the report shows, what is that number?
Page 1,
What is the name?
BM Associates.
But however, the report shows BM Associates. It is submitted that the petitioner wanted to purchase the share of the decree holder, and this decree was passed
In 2015, my lords.
2015, and petitioner could successfully drag on the matter till 2026. It is submitted that the only intention of the petitioner is to drag on the proceedings. In fact, to the commissioner's report, the petitioner has not, to the commissioner's report, to the valuer's report, the petitioner has filed the objections, but he has not taken the objection as stated before this court with regard to the name of the agency. It is submitted that the court, the petition has to be dismissed with exemplary cause. Next, having further concerns on either side, which you do not record. There is no dispute about the fact that the court has appointed Sergeant Associates to value the property. No doubt, the commissioner's report that is placed before the court is by
PM Associates.
PM Associates. According to the learned counsel for the respondent, that he is the proprietor of Sergeant Associates. However, that aspect cannot be considered by the court as the Sergeant Associates is appointed as the commissioner. The report shall be placed by Sergeant Associates. At the same time, this court finds force in the argument of the learned counsel for the respondent that the petitioner who has failed to file his objections, who has filed the objections but has not taken such a ground before the court, is now coming up with the said objection, questioning the impugned order. A decree that is passed in the year 2015, even till 2026 also, the decree holder could not, is not in a position to enjoy the fruits of the decree. On the face of it, it appears that there is an intention on the part of the petitioner to drag on the proceedings. But at the same time, the court cannot lose sight of the fact that the report that is placed before the court is contrary to the order passed by the court. In that view of the matter, this court is passing the following order. The order dated so and so is set aside. As per the earlier order, Sergeant Associates.
My lord, it is submitted that he is a partner of that said firm. So I would submit an independent value may be appointed by the court within the timeline, by the executing court. Because he submitted that the same firm that was appointed by the DHR1 is a partner of said Sergeant Associates. That fact had to be disclosed by the DHR.
The matter coming up before the trial.
9/7, madam.
9/7. On 9/7, the trial court shall appoint a independent valuer, and from the valuer, how much time the valuer takes generally?
A week or
That's,
two.
2 weeks, 3 weeks maximum.
Within
They will
15
come
days.
and visit the property, my lords, and then give their report, my lords.
Date of appointment, the valuer shall place the report, and the trial court is requested to complete the entire process within a period of 1 month from the date of, from 9/7/2026.
That's,
The petitioner shall cooperate with the executing court and any unnecessary applications shall not be considered by the court.
Lords, it is also challenged another order dated, my lords,
That's consequential.
consequential order where I was,
Where is that?
lords, at page number 196, my lords.
No, where is that writ petition?
No, in this very writ
As it-
petition has
as it
challenged two
follows-
orders, my lords.
As it follows consequentially.
Where is that order?
Page
Lord,
number
that order-
196, my lords.
196.
28 June 2026.
Accordingly, order dated, two orders. One is that I've already said, the other is.
20th June 2026.
30th,
20th June.
2026 is also set aside.
Yes, but I have made the deposit of the amount with the court, my lords, 20 lakh rupees.
Take it.
It may be ordered soon.
You want to withdraw it?
No, not like that, my lords. It will go on like this, my lords.
That's why, what can we do?
For order sale number
But it was a
45.
compromise decree. Virtually, my lords, 4 months they had to take the property.
No, we fix 1 month time.
Please,
For order sale number 45.
lords,
Abhinav
may
Raman
kindly
and
observe, my lords, in that, my lords, only with respect to the valuation report, not with respect to the date of valuation, my lords. Their grievance is date of valuation.
That, this order is remanded. The order is set aside as far as the report of the valuer is concerned. And the remaining aspects, this court has not interfered.
Great.
Sale number 45. Abhinav Raman.
Lord, had served the advocate appearing. He has not appeared, my lord, before this court. 2/6/2026, my lords, had directed.
Complaint filed by the advocate for having served the hand.
Yes, my lord, I have served. Court notice may have to go because they have not appeared.
No, you said that summons through post.
Through post.
Yes, my lord, because the office is locked, my lord. Office is
So
locked.
what happened to that?
It is delivered, my lord. I have produced that as well. It is delivered. Right hand side, 23/6/2022, 6:20 delivered, my lord. I have produced the tracking report. Last line, my lords will kindly see, it is delivered, my lord.
Then counsel the petitioner submits that he has taken out, he has tried to serve the hand summons, has offices locked. He has served the same by post and placed before this court the consignment record which shows that. Where do you get it?
Last line, my lord, last line, delivered, my lord.
The dated 23/6/2026 showed that the item is delivered, hence notice to the respondent is held sufficient. You have an interim order.
Yes,
Interim order earlier granted is extended list in the month of September.
yes, I'm grateful, my lord.
Yes,
Number
46.
46. Karthik Surya Prakash.
Not for the petitioner, my lords. Lords, petitioner is challenging the dismissal of an order for application to withdraw the suit with liberty to file a fresh suit. The suit is a suit, it's for declaration that an agreement for development has become rescinded by virtue of the operation clause.
Officers raise an objection with regard to maintainability.
Indeed, my lords. Insofar as section 115 of the CPC is concerned, an order becomes liable to civil revisions insofar as the success by a petitioner would lead to the termination of the proceedings before the trial court. In the present case, if my order for application to withdraw with liberty to file a fresh suit is allowed, there would be termination of proceedings before the trial court. And therefore, I would submit that under section.
This objection with regard to maintainability is kept open. Yes.
My lord, the impugned order is at Annexure M, my lords. The reasoning of the court may be found at page 145. Lords, the principal reason for preferring this application is that the present proceedings are before this junior division court, whereas in the joint development agreement and
This is the suit of the year 2025. Suit is for
Suit is for declaration that an agreement of 2023 has been rescinded by virtue of has elapsed, my lords.
Why do you want to withdraw?
My lords, the present suit is a complex proceeding where there was a family partition pertaining to 14 acres, 3 guntas of land. And subsequent to the family partition, there was also an appeal filed before the Honorable Court. Now, there are two parties who had filed a specific performance suit against the joint family of the petitioner. And there was an initial suit of partition compromise followed by a suit which culminated in RFA 299 of 2017, which is at page 54, before the Honorable High Court. Now, as a part of the compromise proceedings, it was held that nearly rupees 1 crore 16 lakhs was paid to the family of the petitioner, with the petitioner recognized as the owner of the land. And in return for the consideration amount of 1 crore 16 lakhs,
Petitions permitted pay for transfers and file memo to the effect. Once the memo is filed, this is matter.
a date
47.
may be fixed, my lords.
4th of August.
A
I
short
appear
date,
for
my
the-
lords. Some.
Cell number 47.
For the respondent, my lords.
No, I'm for the petitioner, my lord.
My lords, I've received the files last night in the morning. I filed my wakalat therefore, my lords. I seek an adjournment for the next week.
My lord, I just seek the attention of this this court, my lord. Because see, what is happening, my lord, is they're just trying to circumvent the legislative intent, my lord. What is there in the PTCL Act?
We'll address it on the next week.
Just the objectives, my lord. Just see that, my lord.
If the court has issued notice and not granted stay on the last occasion, that means now also I'll not grant any stay.
No, my lord,
That also is not a subject matter.
I will
of the-
just.
What do you want?
I seek an adjournment. I seek an adjournment for the next.
When?
Any time the next week.
After tomorrow.
My lord, not there for tomorrow. I'm not there for tomorrow.
Next
Next week, 14th or something.
Yes, yes. This is matter on, yes, 14th of July.
Obliged, Your Honor.
So and so submits such as instructions to file wakalat.
I have filed wakalat in the morning.
It is submitted that so and so. has
My lord,
filed
there are two CRPs, my lord, 516 and 517.
One at serial
Let
number
them be tagged
85
together.
also, my lords.
Tag along with 5 and 7 of 2026.
Which is at serial number 85.
85.
Which is at serial number 85.
85, yes. Tag on.
Obliged.
Cell number 48. Cell number 48.
Sit to appear for petition.
Sabah.
What are this non-compliance of objections?
Lordship will kindly see the plaint for a minute. Page number 19.
No, office, what are the?
That's not for office objection only. Plaint is filed for seeking some arrears in their salary of the plaintiff. He has made defendant 1 as a company. And defendant 2 and 3 are the directors. Now both the directors have filed 2 separate IAs to delete themselves. So 2 orders are passed, identical, refusing to delete. So we have filed 1 common petition because they both have come together.
But there are
Office says file 2 separate.
Because that's a circular now. As per that, 2 petitions have to be
We
filed.
thought we can save multiplicity of
No, not
petitions.
multiplicity. The
Very well,
difficulty
Lord,
is,
Lordship may give us 1 week
Office
time.
objection. with
Insofar
regard
as the second office objection,
the office objection with regard to the maintainability of the red petition, questioning 2 IAs in 1 red petition is upheld. The petition shall comply with the same. Yes.
no, second one, we have not made the company a party because we have not asked any relief. So we will explain that in the second.
Cause title in the trial.
We
court.
will
Office
explain.
objection, second also shall
Lordship
be
may have it
complied
next
with.
week. There's an urgency, so I thought next week, Your Lordship.
Yes, this is matter on, if office objections are complied with, this is matter on 16th of July.
Obliged.
Hearing on interlocutor application 49. Delay.
Notice. Hmm? Oh, where is that? None appears. This is matter. 49.
49, please. Suit for recovery, madam.
Last time also there was no representation on behalf of the
No
respondent.
representation.
The I number 1025 is filed to condone the delay of 213 days in filing the, though respondents have filed though the wakalat is filed, no objections are filed by them. No objections are filed by the respondents. Accordingly, for the reasons stated in the accompanying affidavit, the delay of 213 days is condoned in filing the petition. Yes.
Pertaining-
Condone the delay.
It's okay.
Yes.
In fact, they were proposing, in the trial court, they said that they are proposing for settlement. Here they are pursuing this case. I don't know why.
I have no
Is it correct?
No, ma'am, not at all. But
My
the
lord, I
case
can
arises
produce the
out of-
order sheet also.
Producer.
That's what, the last date of hearing, it was
how can you
posted
do-
for cross-examination. They
But I've
said
got no
that,
instructions.
that let them say that, let them not say it's not right.
Land counsel for the respondent submits that before the trial court is submitted that they want to compromise the matter.
No, that's what they say.
Same is
At the
rec-
time of cross-examination,
The
they
same
said
is
this.
recorded by the court.
I believe it is recorded, my lord. I don't know.
And
I
the
don't
counsel for
remember.
the respondent wants to place the same on record. Let's this matter after 2 weeks. Yes. 15.
Pertaining to IA number 2 may kindly be considered in the meanwhile. But this is a
No,
matter,
it's
my
an-
lord, pertaining to 2013.
If this submission is correct, the CRP itself will go. Yes, 15.
50. Sita for
Notice.
DM.
Yes, 51.
57.
I have filed a suit for permanent injunction. That suit came to be decreed. Against which the respondents have filed RA. RA also came to be dismissed.
No, there is a delay. We'll issue notice. Yes, next, 51.
Cell number 51.
51, appellant in 51.1 and 2, my lord, filing a withdrawal. There was another 2 more cases filed by the claimant for enhancement, which was not noticed by the insurance company. We had filed challenging liability negligence part, but there is another 2 matters arising out of same accident before Dharwad bench. We settled that matter for 70-30. The same order may be passed in both. In other 2 cases also, my lords stated 70-30. So
1 minute.
Seven. Order passed by the Honorable Court on 17/4/2025. 17/4/2025.
1 minute.
all 4 may be disposed together.
3 alva.
7939/2022.
7939, 7917 dispose ಆಗಿದೆ. ಇವೆರಡು ನಮ್ಮ appeal. Same accident.
So you want to dispose of this appeal as withdrawn?
Please. Because it does not survive, my lord. We had settled.
MFA number 7. What about his appeal?
It was already disposed of. 7939 and
disposed.
7917 was disposed of.
MFA number 7581 of 2022. MFA 7595 of 2022. A memo is filed stating that already in respect to the very same accident, they have compromised the same before the Dharwad bench in MFA number 101740 of 2021. In view of the same, these appeals may be dismissed as withdrawn. Accordingly, memo is taken on record and dismissed as withdrawn.
My lord, amount deposited can be. If the amount is deposited, can
The
be.
amount in deposit shall be forthwith transferred to the trial court. Yes. That is, we are not interfering with that order. Yes.
Much obliged.
Where are the other matters? 70?
7939 and
No, no, you said 70 or something.
Sorry, my lord.
Any other matter in the list?
No, before this Bangalore, only 4
these.
cases, my lord.
Yes.
Please.
Cell number 52.
Appearing for,
There are LR represent the petitioner.
Respondents
LR
were-
application in both the writ petitions. Notices may have to go, my lord. Notices. You wakalat hai.
not filed.
We have got 7 of 25 for vacating the interim order. You appear for whom?
I am appearing for the respondent number 26715.
7 and 15.
Yes, ma'am.
In
My
first-
application, my lord, for
In first
vacating of.
matter, respondent number 12 died. Notices, we have filed LR application. Notices may have to.
Lord,
But how long, what is the writ petition about? Let us see that.
But on merits, my lord, we will argue.
No, my lord.
Because if on merits you
Because-
have no point that.
Because,
that, in
if-
pleading and all, you can do it before the trial court.
Trial-
Why should we keep it, the
Manoj, I will-
suit be stayed and matter be kept pending here?
No,
That's
no,
the whole point.
injunction regarding interim order. There is no stay of further proceeding. It is.
If that is the case, we can dispose it of. We'll see
But
what
my
is the
lord,
order.
some of the contesting parties, my lord, my learned friend appeared for fellow. Now
We
he
are
is-
only the contesting parties.
What
fellow
the
is,
contesting part? Let's see the injunction order.
Yes, my lord.
Lord, may I make one submission, my lord? In that event, my lord, I will file a brief synopsis on any date. It may be posted in, my lord, it may be, it
Appeal
can.
filed by the appellant is hereby dismissed with cause.
Yes, my lord.
The
This,
order passed by the trial court.
this honorable court,
is-
my lord, was pleased to
Both
grant an
concur-
order of status quo.
Concurrent finding of both the courts.
Lord, this
Injunction
order has
application-
been operated.
When is the order passed?
Lord, order was passed in 2016.
20.
In the interim injunction will grant and keep the matter pending for years together.
No, my lord, this order may be continued, suit itself can be disposed of within
The
6 months.
categorical finding of two courts, my lord, 1931 to
Matter, when
1957.
will you argue?
And anyway, then
This
next
is
week,
matter on 15th of July,
16th or
15th of July.
16th or 16th.
Yes, 16th of July as the first matter on the top of the list.
Please, interim order may be,
Interim order order granted is exchanged.
please.
Yes.
Urgency mention matters. That urgency mention matters, list number 1, serial number 153.
Respondent in this matter, interim order of this honorable court has in fact stayed the proceedings before a learned arbitrator. That interim order came to be granted on an ex parte basis during vacation, concerning only the arbitrator's decision to not allow one application through which they sought to confront my witness with evidence that they sought to produce at a belated stage, at the stage of final arguments. They file an application at the stage at which the arbitral proceedings are set down for final arguments.
Very simple order.
Your
Straight away
Lordship,
come to
Lordship.
that.
Impugned order is at page 20.
20.
16th April 22.
Mentioned?
Sorry?
Why is this matter mentioned?
Your Ladyship, because the arbitral proceedings are pending and there's a stay given by this honorable court.
No, that's not the reason. If that is the reason, I wouldn't have granted.
And the arbitration, in fact, was today. The stay has been pending for the last 3 months, Your Ladyship. The arbitral,
Your colleague was too smart to mention it in the morning, but. that-
they mentioned, Your Ladyship. The petitioner's counsel have
It
mentioned
is
it.
posted for today, my lords.
Why you have mentioned having an interim order?
Because the mandate for the arbitrator.
They have
is
given
going to end,
undertaking
my
to
lords, which we
the
didn't want to-
arbitrator also that we will get the matter disposed of.
At the time of filing the petition, we had and given an undertaking that we are going to finish it.
Some matters, they never see the light of the day. Some of the matters should keep on coming for interim order, coming for again final disposal out of turn. You want interim order, you want the order to be on a final order also, now itself. That is unfair. Where is the impugned order?
Page
Impugned
20,
order was
Your
at 20, my lords.
Page number?
20.
If anybody takes advantage with these kind of submissions, from tomorrow onwards, I'll impose exemplary costs. Even if I allow the writ petition also, I'll allow it with costs to pay to the legal services authority. In every matter, you have a stay. And what is urgency for you?
Because the mandate was going to be ending very soon, my lords.
Huh?
Because the arbitration mandate is going to end
Then why
soon.
did you obtain an interim order? Yes, come to the order.
My lords, we had filed 3 applications.
Yes.
One is for recall and the other one is for marking certain documents. The other one was for recall of the RW1, and this was filed in the context of a counterclaim that they have filed for a tune of about 15 crores, my lords. And the documents that you have marked is essentially the ones that we are saying that we are given a credit note for this particular things. The reason we had actually also sought for the recall of this is basically because we wanted to confront the RW1 for some of the questions that has been very non-committal on their part, and also to a question on the part of the counterclaim, my lords, which is to the tune of about 15 crores.
Coming to para number 8, please come to para 8 and read.
Para number
8.
Para number page 24, Your Ladyship will find the reasoning from the 10th line from the top.
If these documents are allowed to be produced and marked in the evidence, the respondent will get an opportunity to cross-examine PW1 on these documents. If these documents are not allowed to be
Reading it, you are reading it, page number?
24, my lords.
No, no, please read from paragraph number 8, page number 22.
Sorry. Coming to the merits of the applications filed by the applicant, I have perused the additional documents sought to be produced by the claimant. These documents are emails forwarded by the claimant to the respondent, credit notes, compilation summary with the credit notes and the bank account extract of the claimant company issued by the HDFC Bank reflecting the payments received by the respondent. Along with the application, the claimant has also filed affidavit as required under section 64 subclause 3 subclause 4C part A stating that stating therein as to how these documents have been procured. From the dates appearing in these documents, it cannot be said that these documents have been created after the filing of the claim. All these emails were exchanged between the parties during the course of the business. These documents are within the knowledge of both the parties. If these documents are allowed to be produced, the respondents would not be taken by surprise. Moreover, mere production of documents is not an admission of the documents in evidence. The respondent has every right to raise the objections while marking these documents of the claimant. Of course, the claimant ought to have produced these documents along with the claim statement, or at least when the evidence was going on. There is omission on part of the claimant in producing these documents when the evidence was going on. If these documents are allowed to be produced and marked in evidence, the respondent will get an opportunity to cross-examine PW1 on these documents. If these documents are not allowed to be produced, it will prejudice the case of the claimant. And further, says on the face of it, it appears that these documents would assist the arbitrator in rendering justice to the parties in an effective manner. After all, the counsel representing the parties is the master of the case. If there is omission or negligence on part of the counsel, party should not be penalized as the approach of the arbitrator, as they approach the court or the arbitrator for release. The ends of justice will be met if the application 2 and 3 are allowed on the payment of cost. However, as far as the question is only with respect to IA number 4, my lords, where we have sought for recall of the RW1 for further cross-examination. There are 3 applications. My applications as PW1 is allowed, but RW1 is not.
Morning, I have refused to entertain a order of this nature. What is the prejudice to you?
Because, see, my lords, the arbitration is the total to the tune of about 22 odd crores, my lords. Now, all I'm saying is there is a counterclaim that they have filed for about 15 crores. I have marked some documents which are related to the counterclaim. Now, if I'm not allowed to confront him, my case would be prejudiced, my lords. Because I have claimed about 6 crores. They have claimed about 15 crores.
II and IA number 3 are allowed on payment of costs.
Yes, my lords. That is for me to recall my witness and mark the documents. On the same, these are the documents which are related.
IA number 4 is rejected.
4 is rejected.
They want to confront my witness with documents that they have sought to produce at the final stage of the
It is
proceedings.
allowed, my lords.
I'll submit your leadership once my friend is done.
No. What is like all are the email correspondence between the parties?
Yes,
What is the prejudice?
No, your
to
leadership.
you?
May I just, number one, when this honorable court first took up this petition at the vacation stage, the question was raised as to the maintainability. Because in arbitral matters, the courts have consistently held that only challenge that should be available is as per under section 37 or at the conclusion of the proceedings as an award under 34. This does not fall into either of those categories. The only circumstance under which a writ petition under 227 is maintainable is if there is perversity manifest on the face of the record, which in my respectful submission there is not. They have come to the honorable court without stating on record the exact factual circumstances in which this order came to be passed. Your leadership may for a moment have the list of dates that I produced as a part of my objections. It is not the first, it is not the second, it is not the third time.
No, but when you're saying that the writ petition is not maintainable, first he has to cross the threshold, then the merits of the matter.
Yes, your leadership. On maintainability, I have law to support my position. And more importantly, if your leadership finds that the petition is in fact maintainable, I have material to show, factual material from the arbitral tribunal.
What do you say on maintainability?
Well, lords, this is an appealable order. It's basically section 37. It reads thus, my lords. Notwithstanding anything contained in this, my application is under section 17 of along with other sections, my lords, and it very clearly says notwithstanding anything contained in any other law for the time being in force, an appeal shall lie from the following orders. And the last part says.
If it is a 30, if
my
he's
lords,
saying it is a section 17 matter,
Along with
then the
others.
37 will lie before the Dwelling Division bench.
My
It is not a writ petition before a single
My lords,
bench.
it doesn't mention that, and it's going back. But anyways, I'll read the portion of it, my lords. 37, 2 subclause B, granting or refusal of an interim order under section 17. And my application is under section 17, along with other sections, my lord, section 18 and so on. So it is very much maintainable under section 37. Therefore, it is maintainable, my lords.
Just so you heard what he is submitting.
In fact, matters of this nature, both our own Honorable High Court as well as the Supreme Court have held, where there is an interlocutory order passed by an arbitrator, either directing production, not permitting production, or seeking recall of witnesses during the course of proceedings, does not form an order under section 17, not forming part of an order that can be appealed under 37. Only in such cases where there is perversity in the order can 227 be invoked. So if my friend is saying this is a 37 appealable order, let him go before the appropriate bench. If he's saying it is a 227, he has to show that there is manifest perversity.
Well, it's, can I make a submission? There is a judgment that I have before me, my lords. This is Uttar Pradesh Power Transmission in paragraph number 67, my lords. Now, where I'm actually coming from is there is perversity in the order basically because I am admitted to mark my documents but not allowed to confront him because this is concerned with
Yes, sir. Where is the finding?
67, last page, my lords.
67 order.
Paragraph number 67, sorry.
Yes.
It is well settled that availability of an alternate remedy does not prohibit the High Court from entertaining a writ petition in appropriate case. The High Court may entertain the writ petition notwithstanding the availability of a alternate remedy, particularly
Propositions. When availability of alternative remedy, when you can, though there is a remedy, when you can come to the High Court and all, these are all settled propositions. But
more so
there
in
is
the
no judgment.
more so in the arbitration.
That para deals with that.
Yes, my lords. Essentially, what I'm saying is, there is a violation of principles of natural justice.
What do you submit about? Where is the principles of natural justice? Court.
Because I have not been
every
given
order is a principle. Then in every case, it's an order where there is.
My lords, the whole point is that
Court heard and court has passed an order. There is no question of violation of principles of natural justice. And now the second submission, what he is making is, if you say that this is an order under section 17, you cannot come before this court, but you have to go before the division bench. I will set aside this order. I'll give you permission. I will give you liberty. You say what you want to do, you please do.
Will be given the liberty to file.
Is that?
If you are given the liberty to file before the appropriate judgment.
Your leadership will set aside the interim order.
Interim order?
Yes, yes.
I will vacate the interim order.
Very good, very good. I'm obliged.
This writ petition is passing the following prayer. A coordinate bench of this court on 14/5/2026 has passed an order. Extract this order. Then counsel appearing to the respondent submits that against the order impugned.
Can I make a small submission, Millards? There is, I'm sorry to interrupt, Millards. This application is also filed under section 8. I mean, if I'm allowed indulgence for another minute, Millards. The application is also filed under section 17, 19, 23, and 24, Millards. But effectively, I don't have any remedy as long as this is, if 17 is not permitted, there is no remedy that I have, my lords.
So 17, it says it has to go before the division bench. And I will also leave all contentions open with regard to the maintainability also. Then counsel appearing for the respondent submits that against this interlocutory order passed by the court. The petitioner cannot come before this court under Article 227 of the Constitution of India. It is submitted that even if it is a case of the petitioner that there is an order under section 17, the appeal lies before his remedy is before the division bench, but not before this court. On any count, the writ petition is not maintainable before this court. Land counsel appearing for the petitioner does not dispute the fact. Does not dispute a dispute with regard to the submission made by the for the respondent that any order that is passed under section 70, it will not come before the single judge of the. It is numbered as, then how it will numbered come?
COMAP.
COMAP. The GMCPC. It can't come before, it can't be numbered as a GMCPC, and then a single judge has no jurisdiction. In that view of the matter, this court is passing the following order. The writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy. It is made clear that this court has not expressed anything on the merits of the matter. Number 3, all the contentions are left open to the parties.
Interim order vacated. Interim order.
I have disposed it, so nothing.
No,
all IAS will go.
the arbitrator will require a clarification.
No, when the writ petition itself is
Very
withdrawn, then
very
there are there will be an order. All IAS stands dismissed.
Very
closed.
obliged.
Cell number 155, Hiram at CS.
Please, madam.
Where is
Happy
it?
for petition.
Respondent in this case, my
Do you
lord.
have any instructions in this?
Yes, my lord, I received the instructions. The Bescom authorities went to the petitioner's premises to restore the electricity connection, my lord. But the
the
neighbors
videos-
are obstructing for that, my lord. If they are they are shouting and the officials are instructed.
No, what
we are
will
unable-
you do when?
Let them provide some protections
Somebody
to-
is interfering with, when you are exercising your official duties,
Yes, my lord.
then that's your responsibility. You are disconnected.
We are unable to enter the premises only.
Then you take the
We
police
have not
credit.
disconnected, my lord. The neighbors themselves has removed that everything.
Neighbor has disconnected near the meter. No,
Yes, ma'am.
I cannot engage private persons
are not
because the only
disconnected, my
KV
lord.
persons have to do this work. Otherwise, I engage some other private persons. Near meter, we have no right. That's why I'm asking them. I have given.
Let them provide some protections for us, my lord. My officials will come today only. Because it was lot of noise
The 83
going on
years
there.
old
my lord.
lady, my lord.
It's a citizen.
Yes, my lord. The thing is
The
that
citizen,
even I requested my officials, they said, they are making lot of noise. They are not allowing to enter the premises only, my lord. That is the difficulty for us, my lord.
No, in these kind of situations, what are the remedies available to you?
Sometimes we'll take a police protection.
Take the police protection. I'll clarify this.
Yes, ma'am. Until and unless the court directions.
Counsel for the petitioner submits that the respondents are not restoring the power supply restoring the power supply. Then counsel appearing for the respondent submits that. In fact, they went to the said premises to restore the power supply, but there was lot of resistance from the neighbors. As such, they could not execute the same. Considering the submission of both the counsels, the respondent shall forthwith restore the power supply to the petitioner's premises. If required, they are permitted to take the necessary police protection.
Much
notice to who are the respondents? All 3 respondents already notice issued.
Yes, ma'am. I filed the wakalat.
So and so. We'll list this matter after 4 weeks. Yes, next.
Notice to respond number 3, madam. Notice to respond number 3 also.
3 is on
Water
private
supply
party.
board.
Water supply.
Disconnected what?
Notice to the 3rd respondent.
Obliged.
230 Moon matter. Hussain Moon.
How many matters?
The petitioner have challenged the order dated 1st July.
This is the
by
last.
which my application for
Yes.
cross-examination has been allowed, though it has been allowed, but with a heavy cost, my lord. Page 17 is the impugned order. It starts from 14.
You mentioned it today.
For this, because this today that matter was listed, but with a heavy cost, that application was allowed, which plaintiff has signed for the plaintiff, petitioner here. So my application was allowed, but with a heavy cost. Page 17.
I said, why you have mentioned it today?
Because
Why
today
it-
matter was listed there in
What
trial court.
happened?
That has been adjourned for, because matter or 24th.
Lordship, after 5 days or 7,
After?
5 days, Lordship.
What is the date?
Next week perhaps.
Next week, Lordship.
Date.
May-
Tell the court officer a day before you give this matter.
Thanks, Lordship.
Yes.
Alright.
Signatures.
Serial number 149.
Serial number
Lords.
2425. Morning password, my lords. This disconnection of electricity, my lords.
Where are they?
Council is there, my lords.
Yes, call him. Call him.
24, 25, 157 and 158, my lords.
Yes, call those matters.
Yes, please.
I'm not taking up other passwords. I already told you in the morning. This is, I said specifically at 2:30.
At least tomorrow.
Tomorrow it will come. You can tell the court officer. Don't mention all the cases now. Yes.
My lord, serial number 77, yesterday also made a submission that the interim order is not being extended time to time. As madam,
For respondent,
ಆಗಿದೆಯಾ?
I am taking up the matters. Yes.
The matter pertains to disconnection of electricity. connection.
When was it disconnected?
Not a disconnected, my lord. They have to put us notice. They are likely to disconnect in the morning also. They have visited this spot.
What is the prayer?
Please.
Issue a writ of
Quashing of the election year.
quashing the impute notice. Why should the notice be quashed?
The notice is a show cause notice, my lords. But they visited this spot and they informed the petitioner to disconnect the electricity connection. For the reason that they were not obtained the plan and the construction of the residential house.
And they have issued a show cause notice, you have to respond to that. Why you have not responded? When they have issued a show cause notice, you should respond to that.
Breathing time, lords. They're not there. They already visited.
You already have enough breathing time. This is issued on 15/6/2026.
They already submitted the entire
No, they have
documents.
not done anything.
They have submitted the entire documents. We have furnished the entire documents. As per annexure F2, B to F.
You have furnished the document. They have not passed the order. Why did you come to the court?
Disconnection of electricity connection.
When they have done?
In the morning only, morning session, they have visited this spot.
After filing the writ petition.
Before that also, my lord, and at the time of filing the writ petition, we have sought for some time.
But these are all, these writ petitions are called vaccination writ petitions.
They inform the concerned officers regarding.
Yes, Mr. Devrat.
That this is a notice only, that they have not sent, they have not submitted any objections.
That's all, like the same order like in the other petition.
Yes, yes, no, that it
Let
is
them within 1 week from
1
today,
week that-
let them submit.
Yes.
And thereafter you pass orders.
orders in accordance with law.
The writ
Till then,
petitions.
the payment.
In all
regular
the
consumption.
all the writ petitions, four writ petitions, 4 show cause notices.
Yes, different.
Different petitioners. sir.
Change the number of the date of the show cause notice. The present, the writ petitions are filed, seeking questioning a show cause notice issued by the respondents. Then counsel for the petitioner submits that the respondents have issued the show cause notice directing the petitioner to furnish the
Documents. Furnish the documents from the.
furnish the documents pertaining to the
Pertaining to NOC from the BBMP.
pertaining to the NOC from the BBMP as as it takes some time to collect the documents. The respondents are trying to disconnect the power supply. Next parallel, and counsel appearing for the respondents submits that the respondents have not it submits that in spite of a notice on show cause notice on 15/6 in the month of June, in spite of a show cause notice in the month of June, so far the petitioner has not submitted his explanation, and it is submitted that without passing the order, they will not disconnect the power supply without following the due process. Next para, having other counsels for neither side, personal material on record. The respondents have issued the show cause notice. Petitioner is obligated to respond to the same, but in this case, the petitioner has not given such reply. Hence, this court is balancing the interests of both the parties. This court is passing the following order. The writ petition is disposed of, directing the petitioner to submit his explanation to his reply to the show cause notice within a period of 1 week from today. After receive the second number 2, the respondent shall consider the same and pass appropriate orders. Once the order is passed,
for a period of 1 week, they shall not give effect to the order, so that facilitating the petitioner to avail the appropriate legal remedies in all the 4 matters.
Payment of
My
regular
lords, item
consumption.
number 123, my lords.
that
It's
till
the seventh
consideration-
time it's been listed, my lords. It's a
It will
KB
be
matter, my
listed
lords.
another 200 times also.
My lords,
At that time.
my lords, after the filing of the writ petition, the respondents herein are seeking to take
Nainalla,
the.
nainalla.
My lords, if the matter may be taken up on Thursday, my lords.
At 21 it is listed.
4181 ಅದಲ್ಲ same ಅಲ್ಲ. ಇದು ಬೇರೆ.
Hmm.
ಅದ್ರಲ್ಲಿ ಬೇರೆ ಇದೆ, ಅದ್ರಲ್ಲಿ ಹೊಸ ಕನೆಕ್ಷನ್ ಕೊಡ್ಬೇಕು.
Madam, 230 madam. Ma'am.
ಇಲ್ಲ same ಅಲ್ಲ. ಅದೇನೋ ಹೊಸ ಕನೆಕ್ಷನ್ ಅಂತೆ.
ಹಾ ಅದು ಬೇರೆ.
ಅದೇ 77 ಲಿಸ್ಟ್ ಅಲ್ಲೇ ಬರುತ್ತೆ, ರೀಚ್ ಆಗಲ್ಲ. ಪ್ರತಿ ಸಲ ಬಂದ್ ಸಾಯ್ಬೇಕು.
ಯಾವತ್ತು ಡೇಟ್ ಸರ್?
It is 21. It is listed on 21.
ಸರ್
Trial code it is listed on 21. Now it is posted on 20. 2 years. 1 day.
21 million
Madam, ಇದು
230 movement 230 movement 20th.
Thank you.
ಮೇಡಮ್ ಎಂಟ್ರಿ ಮಾಡಿದಿಲ್ಲ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಲ್ಲಿ ಅದು ಎಂಟ್ರಿ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತಾ? ನಿಮ್ದಿದೆ ನಾನು
All list one matters, so whatever the remaining matters will be repeated as it is tomorrow. List number 2 matters will go dates.
ಮೇಡಮ್ ಅದ್ರಲ್ಲಿ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್
8 ಆದ್ಮೇಲೆ ಸರ್ 5, 8 ವರೆಗೂ ನೆನೆ ಬೋರ್ಡ್ ಫಿಲ್ ಆಗಿದೆ. ಕೊಡ್ತೀರಿ
ಮಾಡಿದ್ದಾರೆ. ಹೌದು ಹೇಳಿ.
ಸರ್ ಕೊಡ್ತೀರಿ. 5, 8 ಆದ್ಮೇಲೆ ನಾವು ಆ 1 ವೀಕ್ ಒಳಗಡೆ ಎಲ್ಲದಕ್ಕೂ ಅಕಾಮಿಡೇಟ್ 10 matters ಗೆ 1 ಡೇಟ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅಕಾರ್ಡಿಂಗ್ ಟು ದ ಲಿಸ್ಟ್ ಐ ವಿಲ್ ಅಸೈನ್ ಫಾರ್ 10 dates 1 ಡೇಟ್. 6, 8 ಕೊಡ್ತೀರಿ. ಅದು ಯಾವ ಡೇಟ್ ಅಂತ ಅಪ್ಡೇಟ್ ಆಗುತ್ತೆ ಸರ್ ಸಂಜೆಗೆ.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್
ಮಾಡಿ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಇದ್ರೆ ಇಲ್ಲ ಅಂದ್ರೆ
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 14 ಲಿಸ್ಟ್ ನಂಬರ್ 2
ಅದು ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇರುತ್ತೆ. ಕೇಳ್ಕೊಬರ್ತೀನಿ ಪಾರ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಏನ್ ಮಾಡೋದು ಅಂತ. DRT ಇದಲ್ವಾ
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 14 ಇನ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಎಂಟ್ರಿ ಮಾಡಿ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಬೇಕು ಮೇಡಮ್.
ಇಲ್ಲ ಇದೆ ಕೊಡ್ತೀನಿ. ಸರ್ ಅದು ಲಿಸ್ಟ್ 1 ಅಲ್ಲಿ ಎಲ್ಲ ಹಂಗೆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇರುತ್ತೆ ಸರ್. ನಾವು ಅದಕ್ಕೆ ಅದ್ರಲ್ಲಿ ಡೇಟ್ ಕೊಡಕ್ ಪ್ರಾವಿಷನ್ ಇಲ್ಲ. ಲಿಸ್ಟ್ 1 ರಿಪೀಟ್ ಆಸ್ ಇಟ್ ಈಸ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಎಲ್ಲ ಹೋಗುತ್ತೆ ಸರ್.
ಮೇಡಮ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ದಿಲ್ಲ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಲ್ಲಿ
ಅದೆಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
ಹಾ
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿರೋದೆಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ಆಗಸ್ಟ್ 6 ಇಂದ ಡೇಟ್ ಹೋಗುತ್ತೆ ಎಲ್ಲ.
ಓಕೆ ಸರಿ ಸರಿ.
ನಿಮ್ದು ಇದು ಏನ್ DRT ಅರ್ಜೆಂಟ್ ಆಗ್ಬೇಕಾದ್ರೆ ಕೇಳ್ಕೊಂಡ್ಬಿಡ್ಬೇಕು ನಾನು ಮೇಡಮ್. ಒಂದ್ ನಿಮಿಷ ಇರಿ.
ಆಯ್ತಾ ಬೆಳಿಗ್ಗೆ ನೀವು ಹೇಳಿದ್ಮೇಲೆ ಒಳಗೆ ಆಚಾರ್ಯ ಕೊಟ್ಟರೆ ಒಂಚೂರು ಹೋಗಿ ನೋಡಿ.
ಆಗಸ್ಟ್ 6 ಡೇಟ್ ಕೊಡ್ತಾರಂತೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್. ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲಿ ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ.
ಜಾಸ್ತಿ ಮ್ಯಾಟರ್ಸ್ ಇದೇ ತರನೇ 40, 50 ಇದೆ.
ಅದು ಅವರೇ ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು. ಲಿಸ್ಟ್ 2 ಆಗಸ್ಟ್ 6 ಮೇಲೆ ಡೇಟ್ ಕೊಡುತ್ತೆ.
ಅದಕ್ಕೆ ಇಲ್ಲ ಆಗಸ್ಟ್ ಅಲ್ಲಿ ತಗೋತೀನಿ ಅಂದ್ರೆ ಆಗಸ್ಟ್ ರೋಸ್ಟರ್ ಚೇಂಜ್ ಆಗ್ಬಿಡುತ್ತೆ. ಅವಾಗ ನಮ್ಗೆ ಏನ್ ರೋಸ್ಟರ್ ಕೊಡ್ತಾರೆ ನೋಡ್ತಾರೆ. ಚಾನ್ಸ್ ಆಫ್ ರೀಚಿಂಗ್ ಅವಾಗ ಬೇಕಾದ್ರೆ ಒಂದು ಡೇಟ್ ತಗೊಂಡ್ಬಿಡಿ. 3, 8 4, 8 ಯಾವ ಡೇಟು? 27 ಅಲ್ಲ ಸರ್ 27 ಇಲ್ಲ ಅಂದ್ರೆ 38 ತಗೊಂಡ್ಬಿಡಿ. ಅವತ್ತು ಸ್ವಲ್ಪ ಕಡಿಮೆ ಇದೆ. 37 ಏನಾದ್ರೂ ಡೇಟ್ಸ್ ಹೋಗುತ್ತೆ ಇವ್ರೆ. ಅದು ಪ್ರೊಸೀಜರ್, ಅದು ನಮ್ ಪೋರ್ಟಲ್ ಪ್ರೊಸೀಜರ್. ಅದು ನಾವ್ ಯಾವ್ದಕ್ಕೂ ಡೇಟ್ಸ್ ಕೊಡಲ್ಲ. ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಅಲ್ಲ ಗೊತ್ತಾಯ್ತು. ಡೇಟ್ ಆಗಸ್ಟ್ ಅಲ್ಲಿ ಹೋಗುತ್ತೆ ಇವ್ರೆ. ನಿನ್ನೆ ಎಲ್ಲ 5 ವರೆಗೂ ಡೇಟ್ ಫಿಲ್ ಆಗಿದೆ. ನೀವೇನ್ ಹಾಕೊಂಡು ಎಲ್ಲಾರ್ದು ಅದೇ ಗ್ರೌಂಡೇ. ಆಲ್ ಇವಾಗ ಲಿಸ್ಟ್ ಆಗ್ತಿರೋದೆಲ್ಲನೂ ಅದೇ ಗ್ರೌಂಡ್ ವೆಕೆಟಿಂಗ್ ಅಯ್ಯನೆ. ನೆಕ್ಸ್ಟ್ ಮಂತ್ ನಮ್ಗಿರೋದೇ ಆಪ್ಷನ್ ಆತರ. ಈ ಮಂತ್ ಅಲ್ಲಿ ಡೇಟ್ಸ್ ಇಲ್ಲ ಮೇಡಮ್, ಈ ಮಂತ್ ಅಲ್ಲಿ ಡೇಟ್ಸ್ ಇಲ್ಲ. ಅದ್ ಪಾರ್ಟ್ ಆಡ್ ಮ್ಯಾಟ್ರು. ಇಲ್ಲಿ ಡೇಟ್ ಇದೆ, ಡೇಟ್ ಅವೈಲಬಿಲಿಟಿ ಇಲ್ಲ. ಬೋರ್ಡ್ ಮೇಲೆ ಡೇಟ್ ಮೇಡಮ್ ಸ್ಪ್ಲಿಟ್ ಅಪ್ ಮಾಡಿರೋದು ಡೇಟ್ಸ್ ಅದು, ನಾವಲ್ಲ. ಸರ್ ಅದೊಂದು ಬ್ಯಾಚ್ ಮ್ಯಾಟ್ರು DRT ಇದೆಯಲ್ಲ ಪಾರ್ಟ್ 2 167 159 ನಿಮ್ದು 159 ಸರ್ 167 ಅದೇ ಚಿಕೇಶ್ ಜೋಶಿ 159 ಇದು ಎಕ್ಸೆಪ್ಟ್ ಜೋಸೆಫಾ ಇವ್ರೆ ಅದೊಂದು ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿ. ಅದು 159 ಅಲ್ಲ ಸರ್, GK ಭಾವನ. ಟೂ 259 ಆಯ್ತು.
ಎಲ್ಲ ನಿಮ್ಗೇನೆ
ಇದೆಲ್ಲ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಎಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ ರಿಪೀಟ್ ಆಗ್ಬೇಕಿದು. ಆಯ್ತು 37
ಹೋಗಿ ಒಂದು ಪರ್ಟಿಕ್ಯುಲರ್ ಡೇಟ್ ಆದ್ರೆ
12 ಮತ್ತು 13 6 8 ಸರ್ 12 and 13 6 8 30 32 ಅಂದ್ರೆ
ಏನು ರೀಚ್ ಆಗಲ್ಲ.
ಅಲ್ಲ ಇವ್ರೆ 32 ಮತ್ತೆ ಇನ್ಯಾವುದು 12 13 ಅಂದ್ರಿ ಮತ್ತೆ 6 8 ಅದು ಈ ಮಂತ್ ಅಲ್ಲಿ
ಒಂದು ಪರ್ಟಿಕ್ಯುಲರ್ ಡೇಟ್ ಕೊಟ್ಬಿಡಿ, ಹೇಳ್ಬಿಡಿ ಅವ್ರಿಗೆ ಇಂಟಿಮೇಟ್ ಮಾಡ್ತೀನಿ. 6th ಮ್ಯಾಟ್ರು ಒಂದು ಡೇಟ್ ಒಂದು ಅದೇ ಯಾವ ಡೇಟ್ ಅಂತ ಹೇಳ್ಬಿಡಿ ಮೇಡಮ್, ಅವ್ರಿಗೆ ಇಂಟಿಮೇಟ್ ಮಾಡ್ತೀನಿ. ಮಾಯಮ್ಮ ಮಾಡೇ ಮಾತಾಡಕ್ಕಾಗಲ್ಲ.
ಆಗಸ್ಟ್ ಫಸ್ಟ್ ವೀಕಲ್ಲಿ ಕೊಡ್ತೀವಿ. ಎಲ್ಲ ಫುಲ್ ಆಗುತ್ತೆ. ಮೆಮೊ ಹಾಕಿದ್ದೆಲ್ಲ ಎಲ್ಲ ಮೆಮೊ ಹಾಕ್ತಾ ಇದ್ರು, ಅದಕ್ಕೆ ಮೆಮೊ ಹಾಕಿದ್ದೆಲ್ಲ ಎಲ್ಲರೂ ಶುರು ಫುಲ್ ಯಾರೋ ಮೆನ್ಷನ್ ಮಾಡ್ಬೋದು, ಎಮರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಮಾರ್ನಿಂಗ್ ಮೆನ್ಷನ್ ಮಾಡಿ ಹೇಳ್ತಾರೆ. ತುಂಬಾ ಎಕ್ಸ್ಟ್ರೀಮ್ ಎಮರ್ಜೆನ್ಸಿ
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 80 81 ಯಾವ್ದು ನಾಳೆನಾ?
ಅದು ರೀಚ್ ಆಗಿಲ್ಲ. ಫಸ್ಟ್ ಲಿಸ್ಟ್ ರಿಪೀಟ್ ಆಗುತ್ತೆ, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಎಲ್ಲ ಡೇಟ್ ಹೋಗುತ್ತೆ. ಏನು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತರಕ್ಕೆ ಹೋಗಿದ್ರೆ ವೇಟ್ ಮಾಡಿ, ವೇಟ್ ಮಾಡಿ ಮೇಡಮ್ ಹತ್ರ
ಸರ್ ಸರ್
ಅದಾಗದಿಂದ ಇವತ್ತು ಹೇಳ್ಬೇಕಾಗಿ
ಅದನ್ನೇ ಮೆನ್ಷನ್ 10ವರೆಗೆ ಇದೆಯಾ ಎನಿವೆ ಸೀನಿಯರ್ ಬಂದ್ರೆ ತಗೊಳ್ಬೋದಾ ಏನು 13
ಎಲ್ಲ ಅಪ್ಲೋಡ್ ಮಾಡ್ತೀವಿ ನೀವು ಕಂಪ್ಯೂಟರ್ ಇದ್ದಾಗ ನೋಡ್ಕೊಂಡು ನಿಮ್ಮ ಮೊಬೈಲ್ ಅಲ್ಲಿ ಅವರೊಳಗೆಲ್ಲ ಅಪ್ಲೋಡ್ ಆಗಿರ್ತದೆ ಡೇಟ್ ಬೇಕಾದ್ರೆ
ಅಲ್ಲ ಏನ್ ಗೊತ್ತಾ ಸೀನಿಯರ್ ಬಂದ್ ಬೆಳಗ್ಗೆ ಇಟ್ರಾಗಲ್ಲಂತೆ ಇವತ್ತಿನ ಲೀಸ್ಟ್ ಇದ್ದಾಗ ಬೆಳಗ್ಗೆ ಬಂದ್ ಹೇಳಿದ್ರೆ ತಗೊಳ್ಳಾರಂತೆ
ಹಾಗೇನಾ ಇವತ್ತಿದು ಲಿಸ್ಟ್ ಬೆಳಿಗ್ಗೆ ಬಂದು
ಇವತ್ತು ಲಿಸ್ಟ್ ಆಯ್ತಲ್ಲ ನಮ್ದು ಸೀನಿಯರ್ 10ವರೆಗೆ ಬಂದ್ಬಿಟ್ಟು ಇವತ್ತು ನಂದು ಎಮರ್ಜೆನ್ಸಿ ಇದೆ ಅಂತಂದ್ರೆ ತಗೊಳ್ಳಾರಂತೆ
ಅದಕ್ಕೆ ಒಂದು 2-3 ಕೇಸ್ ಕರೆದು ಮಧ್ಯಾಹ್ನ ಅದು ಲಿಸ್ಟ್ ಬೆಳಿಗ್ಗೆ ಮೆನ್ಷನ್ ಮಾಡ್ಬೋದು
ಬಿಫೋರ್ 10:30 ಒಳಗಡೆ ಮಾಡ್ಬೇಕಂತ
ಅದು ಗೊತ್ತಿತ್ತು
ಬರ್ತಾರೆ ಟೇಬಲ್ ವೇಟ್ ಮಾಡ್ತೀವಿ
ನೋಡುವ ಇವಳ ಹತ್ರ ಕೇಳು
ಕೆಲಸ ಇದೆ
ಈಗ ಯಾವುದೇ ಡೌನ್ಲೋಡ್ ಮಾಡಿರ್ತಾರೆ
ಇಲ್ಲ ಇರಿ ಫುಲ್
ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಎಲ್ಲ
153 ಸೀರಿಯಲ್
ನೋಡಿ ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿ ಚೆಕ್ ಮಾಡಿ ಇಟ್ಟಿದ್ದೀನಿ ನಾವು ಡೇಟ್ ಏನು ಕೊಡ್ತಾರೆ ನೋಡಿ ಕೊಟ್ಟು ಅಲ್ಲಿಂದ ಎಂಟ್ರಿ ಮಾಡಿಸಿ ಅಲ್ಲ ಅಷ್ಟೇ ನಾನು ಇಲ್ಲಿಂದ ಅಲ್ಲಿಂದ ಇಲ್ಲಿ ಯಾಕೆ ತಗೊಂಡ್ಬಿಡ್ತಾರೆ ಪ್ರಿಂಟ್ ತೆಗೆದುಕೊಡಿ ಸೈನ್ ಮಾಡ್ತಾರೆ ನೋಡಿ ಹಿಂಗೆ ಕೊಡೋರಿಗೆಲ್ಲ ಡೇಟ್ ಕೊಡಿ ಅವರು ಯಾವ್ದೋ ಒಂದು ಮ್ಯಾಟರ್